Thanks for being prompt. We wish we had been a little quicker, but we had other business to take care of. At this time, I would like to welcome you to the the September meeting of the Tennessee Real Estate Commission. I would ask our Executive Director, Malcolm Young, to read a required document into the record. Mr. Young.
Good morning. The meeting date and time and location have been noticed on the TN Real Estate Commission's website, included as a part of this year's meeting calendar since July 1st, 2015. Additionally, the agenda for this month's meeting has been posted on the TN Real Estate Commission's website since Friday, September the 2nd, 2016. Also, this meeting has been noticed on the tn.gov website since Friday, September the 2nd, 2016. Thank you.
Thank you, Mr. Young. Will you please call the roll?
Yes, sir. For the roll today, John Grease.
Here.
Rick Douglas. Gary Bloom.
Here.
Diane Hills.
Here.
Austin McMullen.
Here.
Marsha Franks.
Here.
Bobby Wood.
Here.
Fontaine Taylor.
Here.
Johnny Horn.
Here.
Mr. Chairman, you have a quorum.
Thank you, sir.
Sir, my name was not called.
Stand by.
I love it. Just
All right. Let's do that, Mr. Young. Let's call the roll of those people who are participating by teleconference.
Okay.
If you hear your name called, first of all, please unmute your phone, and second of all, reply by here. Mr. Young.
We need their license numbers as well, right, Brooke? Yeah.
All right, and we also need your license number when your name is called.
Brooke, do you have the names of the people on the call? I do not. Yeah, what we'll do is we're going to ask you to identify yourselves on the phone, please.
Okay. My name is Regina Savage, Savage, and my license number is 305822.
Thank you. Is there somebody else on the phone?
Gary Carrier.
Did you say that again?
Carrier.
Okay.
License
My
number?
license number is 329185.
Okay. Are there any others on the call?
Yes.
There should be a Kevin Stafford.
Yep. Kevin Stafford. And 274313.
Okay. Any others on the call?
All right, those of you who are participating by telephone, if you will now mute your phone and pay attention, but we will not need your input. We may check to make sure you're there occasionally, but we don't need your input. All right, at this time, I'd like to ask Commissioner Johnny Horn to lead us in an invocation and then the pledge to the flag. Commissioner Horn.
Father God, we do thank you for this time, Lord, that we have given, and we just pray the fullness of time, our time would be your time. And we pray, Father, that you might just bless this proceeding in a wonderful way, that the people may be protected from those who are doing harm. And Lord, we thank you for what you're going to do, for we ask it in Jesus' name. Amen.
Thank you, Commissioner. Please stand.
Pledge another flag. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Commissioner. All right, next we need to adopt today's agenda. You've been sent that agenda. Are there additions, corrections, or deletions? Yes, Ms. Kirby.
The review and vote of the amended statement of necessity needs to be removed from the agenda.
Okay, Mr. Chairman,
Yes, sir.
I would move that we adopt the agenda with that change, and also to add, following the special appearance from our auditor,
I would like to add a consideration of human resources matter. And under the 11 a.m. commission discussions, I would like to add discussion of pending litigation.
Second.
Let me see, is there objection to either of those additions? If not, we'll just consider them added. Other items to be added, Ms. Hills?
Mr. Chairman, and there may be a place, because it's just struck me, and if there's a place, please tell me, that for clarification, I guess for me, I may be the only one, clarification as to attendance now with the meeting.
That under commission discussion.
Or legal report. So, do you have a preference?
No.
Okay, let's put it
Wherever you
after,
would like.
following the litigation item that was added.
Okay.
Yes, ma'am.
I mean, I don't think it's a thing that needs to be added to the agenda because I think it can fall under legal report, but we'll have two litigators coming to address the commission about pending cases.
Who are they?
It's Robin, Ryan, and Sarah Page. And they may have some time constraints this afternoon, so they may be in here sometime this morning, but I'm not sure when they're going to come down. So just to make you aware.
Thank you. All right, Commissioners, anything else to be added, deleted, modified? If not, is there a motion to accept the agenda as amended?
So moved.
Motion by Commissioner McMullen, seconded by Ms. Hills, that this agenda be adopted. All right, next up is the approval. Oh, let's see. Where?
Vote on that motion.
Thank you, we do. We need to vote on the motion that was correctly made and seconded. If you're in favor of the motion, please vote aye.
Aye.
If you're opposed, vote no. Thank you, Mr. McMullen. So, Mr. Chara is not here. We will, when she shows up, under the right set of circumstances, we'll recognize her immediately. We hope she is. Okay, under approval of minutes, we have two sets of minutes to approve today. Did you get mine? Let's talk about a regularly scheduled August meeting.
Move to approve.
Second.
I have a motion by Ms. Frank, seconded by Mr. McMullen, that those minutes of the regularly scheduled meeting in August minutes be approved. Discussion. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Now we have minutes of an emergency meeting that was held on August 22nd.
Move to approve.
Let's get a motion on the floor. Is there a second?
Second.
Okay, the motion is to approve these minutes properly made by Ms. Frank, seconded by Mr. McMullen. Ms. Taylor? Yeah, there's some things in this minute, at least the minutes that are on your iPad that are not correct. Do you have a list of those now you'd like to mention to us, or we can go through them individually?
I have made two different changes, one with Ms. Taylor and Mr. Wood voting no, I believe, on the first motion. And then I also did note that Chairman Grease and Mr. Wood did leave and dismiss themselves from the meeting. I do not have that updated on my computer nor in front of me, but I have made those two changes.
Did you note that Commissioner McMullen ran the meeting?
Yes, I did.
Not me.
Yes, I did
Okay,
as well.
got that.
I do apologize.
And finally, this is my question to the commission. To me, it would make sense that the minutes would show who is in attendance by teleconference.
It does.
It does now. Does,
Fourth paragraph.
I'm talking about the licensees. Are they all there?
Yes.
I am Regina Savage.
Kevin Stafford here.
No, gentlemen, ladies, you just keep your button muted until we call on you.
Yes, sir.
Thank you. We're talking about a previous meeting.
I can bring you the updated copy after like a break or lunch, just so you guys
why
can see
don't
that
you
in
give us,
front of you.
Since this was a
Yes.
special meeting, I think it'd be good to have that
That's
for
totally
sure.
fine.
finally, I talked to, and again, Commission, this is up to you guys, I think. In my way of thinking, if there is a less than a unanimous vote, it would be appropriate to show who voted no. Okay? And in this particular meeting, and you may have already addressed this, Brooke, but two of us left this meeting before it was over. So I think it would be appropriate to show at what point in the flow of the meeting the two of us left. Great, okay.
Would we then vote on this now or wait till we get
Well, what, it's your call.
Move to defer until we have revised minutes to review.
Second.
Okay, that motion is on the floor. Is there any objection to that? Then without objection, we'll postpone this until this afternoon. All right, thanks, Commissioners. At this time, we have a special appearance. The state's auditor, Ahmad Lewis, is here. He used to be solely dedicated to the Real Estate Commission, and to a person, people are disappointed that apparently we're sharing you with other agencies or entities. But we're happy you're here this morning. And your topic, Ahmad, is?
I've been asked to come here and just give a brief presentation on some stats and just the process itself. So, if you guys are ready to go, you ready to go?
You're available for any other questions, though, as well.
Yeah.
Okay, just want to make sure.
Yeah.
Ever
No questions, guys. No questions.
Ever since you've been promoted, I don't know about that.
No. We're good. Ask questions away.
Okay.
So you just let me know when you're ready to go.
Let's go.
All right, let's go. Let's do it. All right. So, as Chairman Grease had said, I'm split between. I used to solely be the auditor for the Real Estate Commission, but now I work for the Division of Regulatory Boards, serving other commissions, as well. So we'll start off with just giving some stats here. I've compiled data from the last 3 months, and if you flip to your first slide there, just to give a year-to-date update, there's been 130 audits opened and 157 closed. There's been more closed than open just because, there's some that carried over from the previous year. And now if you take the stats here from June through August, what I've done is I've kind of included a percentage of audits that have had findings. So in June, there was a total of 7 findings and 5 no findings and 12 audits completed. So that just means that there was 7 audits that had issues, and 5 of them were just fine. And then in July, there was 5 that had issues and 10 that were just fine. And then in August, there was 4 that had issues and 13 that were just fine. And then if you look to the far right, there's just a percentage that I've included there. And all in all, I would say that in general, there's probably around 40% to 50% or more audits that have issues. So what I've done here is I've compiled kind of a range of the issues that I see. So here's kind of what I've been seeing here over the past 3 months, but this is kind of just a snapshot in general of what I generally see. So commingling, escrow/trust deposit issues, escrow trust disbursement issues, record keeping issues. Basically what I've done, I've broken it down basically by the month. What categories of issues that I'm finding. The most common ones are issues surrounding the deposit and disbursements. Occasionally there are commingling issues. Occasionally there are record keeping issues where people can't produce records that have been requested for whatever reason, lack of proper care, or whatever their reasoning is as to why they can't furnish that. But nevertheless, it's an issue occasionally. So that's kind of a snapshot of that. But then I've also kind of included a percentage of what is what. So 58, generally, as I stated before, the escrow, if you guys are following the slides with me, I'm not telling you to flip the slides. I just need you to kind of follow along with me here. I think you're with me here. On the next slide here, for the issues, I basically broke down the percentages. So basically what you can see is that there's a lot of issues with depositing. Ooh, this microphone is kind of. There's a lot of issues with depositing. That's where the bulk of the findings come from. Just, people that, don't, and it's not negligence or anything like that, but it's just, if the contract's saying it needs to be deposited in 2 or 3 days, maybe they're doing it in 6. And sometimes that has to do with the passing of hands internally inside of their firms, to where the broker that's working on the deal doesn't receive the check in time, or things are in the mail, or whatever the case is. But it's an issue that's out there, and it all depends. I find these things, and there's no real process as far as opening up complaints. But if you guys would like to see complaints opened up, I can do that. But right now, as it stands, I've just been finding these things and compiling the data. And this is just a snapshot of the data for you all to see as far as what I'm finding. Now, as far as a plan for the future, when people are audited a second time and, I see the same thing, that might warrant a complaint being opened up. So if, say, this year I found that you had a commingling issue, or a trust deposit issue, or a trust disbursement issue, then the second time I come around and see the same thing, then, a complaint could be opened up. But generally, the process itself, when I'm working with licensees, I like to give them, ideas and as far as what they can do moving forward to kind of correct this, because it's not just that I'm finding things. I want to help them to be able to comply moving forward. Now, if there's no questions on the stats.
There might be. Don't make any assumptions.
Yeah, let's not make assumptions.
Ms. Franks.
Well, I have one question on
Yes.
the
Which one?
escrow. If a contract does not have a time frame in that contract, in your opinion, what is that time frame?
Well, generally, we took it out of the, the facts, but generally 3 days, is reasonable. But, I haven't really been writing, look, every contract should have some type of time frame identified. But the amount of contracts that I do see that don't have a time frame on it, it's a very small percentage of people that don't identify a timeline.
I deal with that with some builder contracts.
Oh, okay, I got you. I've seen a few, but not many. But generally, when I have seen that, they're actually pretty timely about depositing the money, surprisingly. Okay, there's no timeline identified, but, if it's in there within a few days, I just leave it alone, because it's not worth, hey, unless I look and see that there's a consistency and, there not being an amount of days identified, then, it's not really, not to say it's not worth me bringing it up to them, but if it's just a one-off, then
3
that's
business days.
Yeah, generally.
That's really is a legal question that would be up to the commission to determine. We do have a rule that speaks to that, but it's not specific in a number of days, so that may be something the commission would want to discuss at some. Actually, I think it's on our agenda
It's
today.
on the agenda today.
Yeah.
So. Commissioner Bloom.
Ahmad, I appreciate very much what you're doing with the audit, and it looks like you're moving our licensees forward in a positive way. Am I to assume that when there are commingling issues or trust money issues, that they are not at the level that we need to hear about?
Well, per the instructions that I was given, I will open up complaints if I find commingling issues moving forward. It's just not as common that I see that. It's a very small percentage, but there are folks out there that have well, there are folks out there that basically mix the funds. They're out there. So, but I will open complaints on those ones moving forward, per the instructions that I'm given, as long as you guys are good with that.
Well, and that would really be something for the commission to. And I believe I was last month the commission directed us to open complaints on any audit violations that were found. I don't really know of a good reason why we wouldn't. We open all other complaints. So.
Crickets, crickets.
So you find these violations, do you call the principal broker back and say, I found these violations? And
Yeah, generally how it works is when as soon as I kind of, see something, then, I generally let them know, ahead of hand, kind of what I'm seeing and what I found and what they can expect. And then at the very end, when I find something, I always kick it back to them to make sure it is what it is, that they cannot, provide anything additional to substantiate what I've found. And then if they can't substantiate it, then it's final. But generally, I'll let them know what the issue is, but it's not final, when I find something, because, they may have something that they might have left out, but then I kick it back to them, and maybe we go back and forth a bunch of times. And then after we've gone back and forth, they've provided documentation, then, it is final.
so how many audits on an annual basis what's your goal at this point?
Well, if we did, my goals, my performance plan is 15 a month, and that's generally what I stick to. So if we did 15 and 12, whatever that amounts to, 100 and some, yeah, it's good. About 180 audits a year. So we're well within that goal right now. And but like I said, I split my time between other boards, but it's a reasonable number as far as my time is concerned. But if you guys want more, then that'd be something you have to discuss.
Are they still randomly selected?
Okay, so let's just move forward to
Thank you.
the process itself. So I generate an active licensees report from CORE, and then I do that generally at the end or the beginning of the month, and then a random sample is generated from that report. If they haven't been audited, then they're getting audited, but a strong percentage folks are out of state. They're bordering. We border with a lot of states, and those ones typically, those are a lot of those are open and closed just because some people just open the accounts up just to have them, but a lot of times with those audits, I just find that there's not really anything going on. It's just they open up an account just to have it. But so, and then generally 15 are selected, but it's a random sample from that report. And then I generate the letters, and then I give the licensees 30 days. But I'm a reasonable guy, as long as I can be in contact with folks and I know what's going on, the 30 days is, it could be extended, if they need more time and they contact me. And then the approximate time frame that it takes to wrap it all up is about 90 days, because I give 30 days for them to get it back to me, and then I complete a preliminary review, and then, there's a 30 days where we kind of kick it back and forth, and then a 30 days to kind of finalize everything. And then after it's all said and done, we do meet. I do keep the licensees appraised of what's, going on throughout the process. So, as soon as I find something, if I find anything, then I'm calling them up and kind of letting them know to expect something, from me. And what I do is I kick them back, basically something preliminary, like this is what I found. And like I said, I give them time to kind of go through it and see what is what, and if they can provide any additional documentation. And if they can't, then, then it is what it is. But after it's all said and done, then there's a final report that goes out that basically summarizes all that and corrective actions that they can take moving forward to correct these issues and be in compliance. Gosh, these microphones are difficult to speak into.
Ms. Franks.
What typically will you ask a principal broker to submit?
Well, bank statements, copies of their reconciliations, a selection of contracts. It just depends on how many they have. But per meeting that I had with y'all maybe a year and a half ago. I don't go over 30, but generally up to 30 contracts I look at that I sample, And it's really not super complicated, the amount of stuff, that I do ask for, but mainly bank statements, your reconciliations, ledgers that basically can show the in and the out, the who, what, when, where, and why of the money that you've held. That's the important thing. And then from those reports, I use those to select samples, and that could be the same for, property management as well. I don't ask them for much, but give me a report showing all your properties that you manage, provide documentation that shows that you're tracking the in and the outflow of funds, and you can do that, then you're doing okay.
And is it different for a firm that has 2 licensees versus one that has 500? Or would it still be about 30 files?
Well, it'd be 30 files. I mean, it just depends how many, like I said, it tops out at 30. But a lot of times it's less. It just depends, So if it goes over, basically, if you exceed 200 deals that you've held money for, then 30 is what I'm looking at, And I basically do a random sample, unless I have some type of inside information as far as certain contracts to look at. It's a random sample from the reports that I'm given.
Tails.
And I know because of the size of the company, but do you have any idea how much time a company may spend to collect their data? I know everybody's bookkeeping's different. Has anyone given you feedback? I know you're not there, but
Oh, yeah.
What have you seen any average or?
Oh, well, as far as the average timeline, I mean, it depends because, as soon as I send these letters out, I'm expecting a wave of calls, within shortly after sending them out. So some folks, with the smaller firms, I find that, they have a lot more questions. With the larger ones where they have people actually in charge, of accounting and things like that, they're able to coordinate that a lot better. So I don't think it takes them as much time, but for the smaller firms where I basically hold smaller firms, I'll hold your hand and walk you through what's needed. That's not a problem. That's what I'm here for. But generally it's the smaller firms I think takes more time, but with them, I kind of walk them through. So I try not to have it take too much of their time. That's kind of the goal. So, I don't want them to look at the list and be like, oh my God, this is going to take me 5 or 6 days. Like, no. This is not. Explain to me. Then I kind of get into more detail as far as what they're doing at their firms, so on and so forth. And I'm like, okay, so for your situation, this is exactly what I'm going to need. But I explain that the letter is a catch-all. And, I can't do anything specific if I don't know exactly what your operations are. But generally when they call in and they say, okay, well, this is what I do. I just do this. Okay, if you just do this, then this is what you provide.
And then I know when you were just with us, you went around with a road show.
Yeah.
Now that we're sharing you, what's the future hold on
the road?
providing information to?
I think Malcolm and Ross and Mallory have been doing that, I suppose. That's what I think, right? You guys been going to those, right?
And the audit process is well represented because we do discuss it.
Yeah, but I mean, if it's necessary for me to go out and it's okay with my bosses and things, then we're good to go. But I think those guys got it covered. But if they need assistance doing it, I'm more than willing to jump on the road.
And I can help Diane because being on this side of the audit that we got, I mean, it was intense. I mean, it took a lot of time, but really and truly, I mean, it should have been done. I mean, it's in comparison to audits I've gotten over the other 20-something years, 30 years, this was a lot more intensive and took a lot more time. But it's not like I'm going to be doing this every week either, And I like to look at numbers and to how many you can do a year, and I kind of take into account how many companies we got. Really and truly, if you were just to go one by one, it would take you almost 8 years to get to everybody, and so that's just that doesn't mean he needs to work more hours. That just means we may need another Ahmad at some point, but that's not for today's discussion. But
Yeah, and I can, like I was saying, with everybody needs to get audited, but a lot of firms are on that border. So I'm not saying that it's not necessary to audit those ones, but you know, if we cut those out, then we could get down to the real, what would you say, problem areas if need be. Because a lot of the out of state ones, I don't really, borderline firms, I don't really see too many issues with those ones. So if we cut those, not to say cut them, but if we kind of eliminated looking at those, then that would be, probably easier. Just a recommendation. But like I said, it's random, and a lot of the ones, out of state or the border ones kind of end up in there. But I don't really find too many issues with those ones.
So an out-of-state broker is required to have an escrow account or a waiver?
Well, a lot of times I just talk them into getting a waiver, because they just, like I said, they just have the account to have it. It's like, well, I don't really do too much, and I just opened this because we had to. Then I just recommend a waiver for them, and a lot of times they just fill it out.
All right, Commissioners, other questions for Mr. Lewis? Well, on behalf of Commission, we appreciate the part-time we have you.
And we meant to get you a Superman shirt, but we forgot.
Oh, well, hey, that's always nice. I actually do have a few of those that I wear around. I had to show the S on my chest. Yeah.
Well, thanks for taking the time to come down and giving us an update. We appreciate it.
No worries. And, you guys discuss away and fill me in.
Well, did.
Thank you.
We know how to reach you. Thanks, Ahmad. I need to go back in the agenda. I skipped unintentionally a couple of items. Ms. Kirby, a roll call vote of previously adopted proposed rules. You want to speak to that and just tell me, make sure.
I think I don't think the commission voted on whether the phone attendance was going to count towards their meeting requirement.
I think that's part of the question Diane's asking. We're not sure what is, from my perspective, I'm not sure what has to be done to accommodate these people on the phone and where we are in the process.
Sure. I guess it may just be a good idea to go ahead and decide that. So if you decide not to count it, they're not hanging on the phone line for no reason.
So how do we know if they're like, how do we know if they drop off the call?
Well, we don't really.
Okay. And so was this a result of our emergency meeting? Because that was not what I understood that we ever decided on in the emergency meeting. It was decided on for the emergency meeting.
Right, and the question is whether you're going to allow it for this meeting as well. This wasn't voted on at the emergency meeting. This wasn't part of the emergency rules. This is just since the emergency rules have not gone into effect, they're not signed by the Attorney General yet. We're still waiting for that. So right now, the requirement still stands until we get the emergency rules in play. That's assuming he's going to sign them. But until we get the emergency rules in effect, the requirement for them to come to a meeting still stands. So the question is whether the individuals on the phone, this can count as their meeting requirement for today.
I was concerned during the emergency meeting that at the end we did not know who remained. And I know Commissioner Taylor dropped off and had to come back on a couple times. So I know that can happen. My concern in doing this would be holding it accountable, having a spot roll call or something if we were to go that route. But I'm not inclined to bother. I think it's as we've already heard a couple times, I think it's a static. I'm not inclined to
So let's take some direction from our council. What do you see as the first step in your discussion on these two items plus attendance at today's meeting? What should come first? We'll handle it.
I think the attendance should probably come first.
All right, is there a motion by any commissioner that would grant attendance requirements to those people who are on the teleconference call?
make a motion that we give credit to those who have called in to fulfill the meeting attendance requirement to have their licenses reinstated.
Is there a second to that motion? Seconded by Commissioner Horn, properly made by Commissioner McMullen. Now discussion on that motion. Ms. Taylor.
Should we add something to that? I mean, we don't know, as Commissioner Hills was saying, we don't know if these people answered on the phone at the first and if they've now gone to a meeting and kept their phone on the table while they're doing whatever they want to do. And I just don't think that this is the appropriate way to do things.
Did you want to offer some sort of amendment to the motion or a second?
I don't know how we can check in with them or have a roll call every few. I just don't know how to handle
A random
it. To know
spot
that they're
roll
on the phone.
And I think, I'm wondering too, how did we get here? How did we get to this?
Well, we have, as I recall, and Ms. Kirby or Director Young can correct me, we had the reinstatement requirement that included an attendance requirement in order to be reinstated. And we we amended that rule to eliminate the attendance requirement some time ago. And that, the new rule has been pending with the Attorney General for quite some time and does not go into effect until the Attorney General actually approves the rule. So we felt like that attendance requirement should be eliminated. We had expressed that, but it still was being required. And so we had the emergency meeting in August in order to pass an emergency rule to eliminate the attendance requirement. And we took some additional steps at that time in order to try to make the situation as best we could in light of the fact that our original rule was still just sitting at the Attorney General's office. And as part of that, we gave credit to people who called into that meeting, and there were some other steps that we took. I can't remember all of them. But apparently the emergency rule is still pending with the Attorney General as well. We hope that it will be acted upon quickly. And one of the benefits of the emergency rule is that let me tell one of the detriments of the original rule, I think is a better way for me to put it. The original rule, even after the Attorney General approved it, would not become effective for something like 90 days or maybe more. I can't remember.
Right, it has to be filed with the Secretary of State and then have the 90-day waiting period. Mm-hmm.
So the benefit of the emergency rule is that when the Attorney General approves it, it's effective immediately or immediately upon recording with the Secretary of State. There's no 90-day waiting period. So we're trying to get this darn attendance requirement out of here as quick as we possibly can. But right now it's still in place. And so to try to be as understanding as we can with the licensees, at the August meeting we let people call in order to get credit, recognizing that we had people across the state who were dealing with this issue. And again, today we have people who have called in, and I made the motion because I think that we ought to give them credit for calling in, just like we did the people last month, recognizing the fact that we really think this requirement ought to be out of here. And we're just dealing with it as best we can while we're still stuck with it, pending final approval and action by the Attorney General. Now, there have been some nuts and bolts questions asked about how can we make sure that the people who've called in stick around. And I think we can occasionally ask if they're still there. There are only 3 people, so it won't take but just a minute. And, if somebody disappears and we don't feel like they attended the meeting, then certainly we don't have to give them credit.
Ms. Taylor.
Would be exactly what I would suggest, that when we take breaks, that they call, that they have to answer back to us. Before and after lunch, they have to answer back to us. And at close of day, they have to answer back to us in some way.
They need breaks too.
Yes, in beginning and end of breaks, and that way we know that they're there and paying attention.
Thank you, Ms. Taylor. Ms. Hills.
And my understanding from the emergency meeting is that their license would, once they paid their fees, their license would still show expired until the Attorney General signs off on either the emergency rule or the original request we had sent months ago.
For the what?
Or they attend.
or they
Right, right.
attend
Mhm.
and pay the fee, and then their license shows active. But if they pay the fee and do not attend, then we would not go after them for practicing real estate. We would let that ride until the Attorney General signs over, and they could still practice real estate even though it shows expired. Am I correct on that? Okay, so I'm not clear how we ended up today with people on the phone, just like I was not clear during the emergency meeting how we ended up with, and I asked the question then, who all was noticed that had expired license? And I believe the answer, I'm not sure who answered me, said they tried to reach everyone they could to that had expired license. And I'm not sure how far back it went because one of the people I happened to look up, I wrote down 2 license numbers, and one was October 2015 expired that was on the phone. So I'm not sure how far back we went to bring those people. How do the people today know to call in versus the other people that are sitting in the audience if they did not? How did they know this was an option to call in?
Malcolm?
Basically, what we did is we reached out to the people that had filed with us that they wanted to come to the meeting. And we took that list and then we called them.
So they're to let us know when that they plan
That's
to
correct.
come, and then we told them they had the option.
Right.
Okay.
So we may well be having more call-ins until the Attorney General's everything, so that could be
But it's
2
going to
more
be on
months.
a meeting-by-meeting basis.
Right, and I anticipate that before our next meeting, the emergency rule will be in effect. I mean, I can't say that for sure because it all depends on when Mr. Attorney General can sign the paper. But I would anticipate that this might be the last time this is an issue.
All right, back to the motion, which is on the floor. It appears to me, Mr. McMullen, that a slight modification to your motion that might require checking in with the phone attendees 2 or 3 times during the day would be accepted by the commission. Is that, would you like that?
That's fine with me.
Brandon.
If you want to consider that part of the motion, that's fine with me.
Okay. So, just so we're clear, so staff knows, are we talking like 3 more times today?
Well, it was before and after breaks and before and after lunch and certainly at the end.
Do we need to do it before and after breaks? Can we just do it after the break?
Let's not announce when we're going to do it.
Yeah.
Let's just say we're going to do it
That's
sometimes
good.
today, okay?
That's good.
I agree.
I'll leave it to the chairman's discretion.
That's good.
At the end of the day, for sure.
Similar to a random drug test, is that what
Yeah,
you're
that's
referring to?
fine. That's fine.
All right, so the motion on the floor, which was made by Commissioner McMullen, seconded by Commissioner Horn, would allow attendance credit for those who are participating on the phone call today as long as they answer present or here each time we ask if they're present or here. Further discussion? All right, let's vote on that motion. Those in favor of the motion vote aye.
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 Those opposed, no. That motion passes unanimously. I want to go to another item for a second. Mr. McMullen asked to place an item on the agenda related to a report from Human Resources. And Mr. McMullen, at this time, you have the floor.
Yeah, thank you, Mr. Chairman. We've been advised that there is an open human resources matter, and I have a motion that I'd like to make with respect to that. I move that we accept the recommendation of the Department's Human Resources regarding the open human resources matter and authorize the chairman and the department to implement those recommendations.
Second.
Got a motion by Commissioner McMullen, seconded by Ms. Franks. Is there discussion on the motion? All right, are you ready to vote?
Ready.
Let's do it. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, back to you for a second, Ms. Kirby. We're going to take a break in a minute, but let's get to your
Okay.
next topic.
Sure. So while we're on the topic of rulemaking, I sent you an email kind of explaining what we were going to do with these this morning, but the online submission rules and the proposed version of the reinstatement meeting requirement, the proposed version being the one that you voted on back in May originally, The online submissions, I believe you voted on in March, maybe April. But these require a roll call vote, and that is my error for not advising you all of that. We just did a regular vote, and it hasn't slowed up the process. They're moving on through, like I've mentioned before, I think it has to go through the Attorney General's office, the Governor's office, back to the Attorney General's office. So we've moved through several of those already. And we're nearing the end of the process. So we'll just need to, sorry, yes?
I'll finish, but I would be curious what the vote was. Was it unanimous previously, or do you recall what the vote was?
I believe it wasn't unanimous previously. I think we had a couple of people absent, but the ones that were here, I believe were unanimous.
And also on the roll call list, Ms. DeChara's name is still on there, and
Okay.
Mr. Douglas is not.
Okay, I will revise that. I want to point out a couple of little things that were revised in the different through the process since it's come back to the commission. And this is with the actually, let's first look at online submissions. So this is going to be numbers 14 through 17 on your iPads. And like I said, these documents you've seen before. They were the same documents you voted on initially. The only thing that is different is that if you're looking at the language for the online submission rules, under number 2, in the first part there, number 2 in parentheses, we've added hand delivery to the third sentence. It just didn't include that in the original rule, and it was advised that we just clarify that, that things can be hand delivered as well to the commission office. And also, and then there was just a clarification in that last sentence, received after the commission's business hours, just to do a little bit of clarification on when those things were due. So those are just little things that have been changed, but beyond that, it is identical to what you saw before.
Questions for Ms. Kirby about this procedural action?
So do we need another motion?
I want to let Mr. Young in a moment call the roll. Well, before you do that, to Ms. Frank's question, is the motion assumed to be on the floor at this point, Ms. Kirby, or do you need a motion that we're going to vote on?
You should go ahead and make a motion, and we'll do these one at a time, too. So.
Like to tell us what the first motion should state?
Sure. So the motion could be to accept the rulemaking documents for online submissions as proposed by legal counsel to proceed in the rulemaking process.
That's your motion, Ms. Franks?
So moved.
Seconded. I got a motion by Ms. Franks, seconded by Commissioner McMullen, that motion be approved. We will vote after discussion if there is any. I sense there is not. By roll call, Mr. Young.
Chairman Grease?
Yes.
Rick Douglas? Gary Bloom?
Yes.
Diane Hills?
Yes.
Austin McMullen?
Yes.
Marsha Franks?
Yes.
Bobby Wood?
Yes.
Fontaine Taylor? Johnny Horn.
All right, that motion passes on an 8-aye, 0 no vote. Next item, Ms. Kirby, is you have a second motion for us to consider?
Yes, so the second one is the second set of rules. This is the proposed version of the removing of the meeting requirement, and I don't believe anything has changed in revisions on this one. So it's the same documentation that you've seen before, and I just recommend a motion to accept the rulemaking documents as proposed to move forward in the rulemaking process.
So moved.
Motion by Ms. Franks, seconded by Mr. McMullen. Now, is this the original set of rules?
Yes, so this is the one that will have the 90-day waiting period. This is not the emergency, because the emergency one, you did a roll call when we had the emergency meeting.
Will the emergency rules preempt the need for the regular rule?
No, because emergency rules only last for 180 days. So by the time the 180 days is up, then the other version should be through the process.
Got it. Other discussion, other questions? Let's vote. Mr. Young.
John Grease.
Yes.
Rick Douglas. Gary Bloom.
Yes.
Diane Hills.
Yes.
Austin McMullen.
Yes.
Marsha Franks.
Yes.
Bobby Wood.
Yes.
Fontaine Taylor.
Yes.
Johnny Horn.
All right, that motion passes on an 8-aye, 0 no vote. Thank you, Ms. Kirby. We've got another item coming up, but the review and vote of the amended statement of necessity.
That's the one that we struck from the agenda this morning.
Do we strike it twice? I had it on the agenda back under commission discussions. That was informal applicant process rulemaking.
Oh, that's different.
So that one stays
Yes.
on? I'm sorry. Let's do it. Let's take a 10-minute break. We're back in session. There's been a request that Mr. Young check on our telephone conference attendees. Would you call their roll? And if you are on the line, please unmute your phone and say here or present. Mr. Young.
Ms. Savage? Ms. Savage? Regina
Yes,
Savage?
here.
I think once more, Malcolm.
Regina Savage?
Yes, I'm here.
All right. Gary Kill. Gary Kill. Gary Kill. Are you
There's
there?
a Gary Carrier.
Oh, okay. Sorry. And Miss Stafford?
It's Kevin Stafford, yes,
All
sir.
right. Yeah. Okay. All three are still here.
Thank you.
Thank you.
All right, you can mute your phones again and listen in. All right, this time we've before I do that, let me just go to Ms. Hills for a second.
But Mr. Chairman, and I know it's on the agenda and we have discussed it, but I know there are a couple people in the audience who, my understanding is that they called in to say that they were coming and they were not given the option to call in and be on this meeting by phone. They did receive an email, I believe, with the location and times and things. So my question is, do we offer them the option and let them decide if they want to get on the phone and start traveling back to Johnson City?
Well, Chair to entertain a motion. Or is that just a rhetorical question that you're asking?
Ms. Hills, I do know that we went over the list of the people from out of town yesterday, and I did ask Rachel Fowler with our staff to reach out to the people out of town. And in looking through, I know that I didn't see any from Johnson City that was on the list that she was working off of. So I do apologize.
Or
So that-
Jonesboro?
So there are people who are here for reinstatement.
Yes.
I don't have a problem if they want to get on the road and listen on the phone while they're driving back home. That's fine. That's what you're asking.
Yes.
Yeah.
And if it gets dropped, because this is a route I know, and I painfully know some of the hot spots to get dropped, they would be able to call back in. They wouldn't have a problem. You don't think reconnecting or anything? Okay.
Well,
They can pop back on.
so there's a logistical question of how they get hooked up to the bridge. Do we have those, Brooke, do you know if somebody wanted to call in at this point, are there instructions for that to happen?
I do have a phone number.
Let's do this. Hey, Regina Savage. Regina Savage.
Yes, sir.
I like your accent, so let's talk with you for a minute.
Okay.
How did you get on this phone call?
Yes, sir. I received a call yesterday afternoon from Rachel Fowler, who gave me the option.
Did she give you a phone number to call in?
Yes, sir, she did. An 800 number.
Could you tell us what that number is?
Okay, if you can hold one moment, let me put you back on speaker and I can look that up, okay?
Thank you.
Yes, sir. Actually, I have it written down here also. It is 800-785-3563.
Once you called into that number, did you have to enter a code?
No, sir. It was a little while this morning. They had it doubled up with the contractors meeting. So the three of us held on. We connected to each other. It was kind of funny. And then a lady came on and helped us and asked us just to hold on the line. And they would get the contractor board meeting off the line. And then we were connected to the meeting just automatically.
Thank you, Ms. Savage. Stand by.
Sure.
Okay, Ms. Hills.
Well, and for me to get here, it takes over 4 hours. So yesterday afternoon would have been a little late if I were the one coming. it would have been a late decision for me. So I would make a motion that we give the option for anyone in the audience today, if they would like to take this 800 number and get on the road and go back and stay on the call from your cell phone.
Second.
Okay, I have a motion by Ms. Hill, seconded by Mr. Bloom, that attendees who are, if this passes, you'll have to identify yourself immediately, and we'll make sure you can get on before you leave. But they have the option to stay with us and enjoy the show in person, or hook up by telephone and listen in while they travel home or wherever they go. That's the motion. Is there discussion on that motion?
Could we possibly do this instead of stopping the meeting, and because there will be a disruption as we do this, but could we maybe do that at lunch break? Let those people identify themselves, who they're going to do with the people, and then that way that gives them basically an hour or more to be getting on the road, make the phone call, and then we'll be ready to go when we get back from lunch break.
Let's just, for my edification, who would take advantage of this offering? 4 people? Okay. Bobby, you think we can take it? Let's see. I'm going to go with the gentleman. I'll go with you, ma'am. Would you dial that number real quick and see if you can get on this call? Are you on it?
Has it?
Put it on speakerphone and see what it says.
I'm here.
She came right on.
Okay, great. You can hang up. Thank you.
She can stay on, she's stay on the phone.
Well, if ladies and gentlemen who want to take advantage of this offer need to have a license number and your name is registered with the Real Estate Commission, if you have that, Brooke, could you meet them right down here at this table?
Don't they need to check back in with us as
Yeah, we'll check back in with them too. So, ladies and gentlemen, if you want to take advantage of this and you've got your license number, please see Miss Brooke right here, and she will get you signed in. Mr. Horn. What's your license number? As a matter of fact, let's do it at the very back of the room. Thank you. That's a good idea. All right, while that's going on,
Do we need to vote on the motion?
yeah, I just want to see if we really have people want to do it. Okay, great. So the motion on the floor is to allow these 4 attendees, if at their option, to join by teleconference and hit the road.
Call for the vote.
All right, those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Thank you, Mr. Chairman.
Thank you, Ms. Hills.
Question.
Yes, sir. I don't know if... Yes, ma'am. We think, it's in the chair's impression, that if you are here to get your license reinstated and you want to do it by phone, at this point you can get on the list. Yes, sir. Would you come up here or stand and say that again?
Stay for the morning, then leave.
All right.
Travel after lunch. Could I do that?
Yes, sir.
Yeah.
With the understanding that we're going to check on you guys to make sure you're on the call. If you fall off the call, we're not going to give you credit. But you can go at your convenience once you've identified yourselves as participating on the teleconference. Ms. Hills.
So,
travel safe.
Ms. Kirby, so will their license still show expired until the Attorney General signs?
No, because they're attending the meeting. So if they're, still on the line or whatever, when y'all check in with them, then they'll get credit for this meeting. And if they've done everything else, then they can have their license reinstated.
All right, we're going to proceed on with the agenda. We're going to, at this moment, we're talking about people who have let their license expire. We're about to start a portion of the agenda where people who don't have a license but would like to have one and also have special circumstances come before this commission to try to get permission to pursue their career in real estate. So we've got as many as 5 different applicants who need to come and testify before commission with their brokers. So the process will look like this. I'll call you the name of the licensee and his or her broker. If the two of you will come up, the law director will ask you to raise your right hand and ask if you'll tell the truth, at which point you'll both be seated. Our executive director will give us a little history on the particular situation. And once that's over, then the licensee or the potential licensee has the right to tell us, and really the responsibility to give us some background about what happened, what's been going on in his or her life since then, and why he or she is a good candidate to have a real estate license. Once that person is done, the commissioners can ask the applicant any questions they want to. At some point, we'll go to the proposed principal broker and ask the proposed principal broker why you would like to have this person affiliated with your firm. And you can tell us about that, and then the commission can also ask the principal broker any questions that a commissioner would like to ask. So that's kind of the process. We're going to start with Wesley Keene and Linda Pennington. If you're in the building, please, if you will come up. Ms. Pennington's been here before. She knows this process. But if you guys will just stand for a second. Ms. Kirby, you want to swear these folks in?
You solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, nothing but the truth.
All right, please have a seat and try to locate yourself near a microphone because we'll need to get you on the record. Mr. Young.
The applicant is Wesley Keene. The principal broker is Linda Pennington. Mr. Keene has taken and passed the Tennessee real estate exam for affiliate broker. The principal broker is Linda J. Pennington, was first licensed as a broker in October the 12th, 2004, became principal broker of the firm effective 6/10/2013. Ms. Pennington is responsible for supervising 200 affiliate broker licensees. There have been no disciplinary sanctions. The firm is Keller Williams Realty, and the summary of disciplinary sanctions here is theft, and also the attached information is in your iPads.
Thank you, Mr. Young. Mr. King, he gave us hardly anything about what happened. So would you give us some details of what caused you to get here today?
It was a theft by receiving charge. When I was in college, I bought a stolen parking pass from a teammate of mine.
Well, I'm going to ask you to say that again, but talk a little louder in there. We have a hard time hearing.
Okay.
Here.
Yes. It was a theft by receiving charge. I believe it was under $200. I bought a stolen parking pass from somebody who I played college football with while I was in college.
How long ago was that?
I think 8 years. 8 years, I believe.
What else would you like us to know about you?
What would you like to know?
I don't care, really. You can tell us what you think might help your case.
I mean, since then, I believe it's been dismissed, but I did community I've worked full time since I got out of college.
What do you do?
Well, I was full-time employed with Mars Pet Care up until a few weeks ago.
Else, commissioners now can ask you questions, so maybe we can get you to.
Yeah, that's fine.
Bring that
If you
out.
guys
Ms.
have any
Franks.
questions for me.
Okay, so this parking pass had a $200 value, right?
I don't know that for sure.
Oh, okay.
It was up to, I think the theft by receiving, I believe, is on, the charge is on there. It was up to 200, I believe, or so. I don't know. I don't know the exact amount.
Okay, and so you were in school in Colorado?
Yes, ma'am.
Okay, and so there weren't enough parking spaces then there?
Apparently not.
And how old were you at the time?
I believe I was 22, maybe 21.
Did you know that it was stolen?
I did not. No, I bought it unknowingly.
And how did you get caught?
I can't remember exactly. I think I don't know if maybe they had been on watch for it, knowing that it was stolen.
Okay.
And yeah. So.
Okay. Did you work at Mars Pet Care in Thompson Station?
No, I actually worked out of St. Louis. I was a field rep, so I wasn't stationed in a corporate office.
Okay. So what has gotten you? You're not working there now, and are you from Tennessee?
Oh, ma'am.
Okay. So what has gotten you interested in real estate?
My parents live here, and I moved here, and I've wanted to do real estate for a while, so I jumped into it.
That's all I have.
The commissioners.
I had a question. So this is a school parking pass? I mean,
Yeah, yes, sir.
Okay. I'm just trying to make sure I know where my son got his parking pass now. I'm just trying to. I'll ask that question at break.
Sure.
I think we may have all been tempted by that.
Mr. McMullen.
Yeah, Mr. Keene, whenever you filled out your application, there was a question that asked, had you ever pled guilty, pled no low contender, or been convicted of any criminal offense?
Yes, sir.
And you answered that no?
I may have. I don't recall.
Okay, so why didn't you disclose this conviction?
Because I thought it was dismissed, so I don't know. I don't know the legal terms, to be honest with you.
And it was dismissed. I see it in the paperwork here that it was deferred and dismissed. So I'm not really sure why he was asked to be here today, but.
Well, other questions. So back to council for a minute. Ms. Kirby. Consider this case?
I do not believe you do.
Mr. Horn?
Microphone.
Johnny.
I can hear you.
Microphone.
I can hear.
We're taping it.
Oh, okay.
How do you feel about receiving a document like that?
A document. Are you talking about the parking pass? Well, to be honest with you, I bought it unknowingly, and after I bought it, I was absolutely willing to pay for it. I just unknowingly bought it from. It was actually a teammate of mine that worked in the pass office for the parking pass. So I thought it was legitimate, but he had actually stolen it and passed it on to me for what was a profit at the time.
You think that was a crime, or?
Did I think it was a crime?
Yes.
Not. To be honest with you, at the time, no, I didn't, because I did it unknowingly. I think, if anything, it's a crime of ignorance, maybe. If that makes sense.
I'd like to make a motion.
Okay, Ms. Franks?
I'd like to make a motion that we approve that he move forward.
I'll second the
Motion
motion.
by Ms. Franks, seconded by Mr. McMullen, that Mr. Keene be allowed to proceed with his licensing process. This may be a overkill, but let's, is there discussion on the motion? Mr. Bloom?
No, I was going to make the motion that we tell Mr. Keene good luck, and we apologize for having him come here.
That's, we'll roll that into the motion. Mr. Horn?
Yes, Mr. King. Have he looked into the possibility of expungement?
I believe it was dismissed. It's already been dismissed, but I don't know if it was something to do with a portion of maybe the court's not sending it through. I really don't know, to be honest with you.
All right, Ms. Kirby, we're going to vote on this even if we don't need to, okay? If you're in favor of the motion, please vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Ms. Pennington, you didn't get to say a word.
Okay.
How's business?
Great.
Is it good?
Can I ask you a question? So what is his next step? Is he granted a license today or what?
If that was the last
I would say
requirement,
yes.
get commission's approval.
Well, I mean, it would depend on if his file's complete, which,
It's been complete for a couple months.
okay, then it should be processed soon, but that will be up to Malcolm and his staff.
We'll ask staff to expedite.
We'll definitely expedite it, Ms. Pennington.
Thank you guys for coming down. Good luck to you,
Good luck
sir.
to you.
Thank you.
But by any chance, do you have any friends with the state of Tennessee that can hook us up with some better parking passes for the commissioners? 'Cause we're tired of walking from Egypt to get here.
I don't know that you want to
so
talk
I'm
to my friends about a parking pass.
Okay.
We
Well,
need pass.
thought I'd try.
Thank you, guys. Next up, Christina Fishy. Is that how you say that? Fisher. I got a double E.
On the
here.
iPad, it's right on the paper.
Okay,
It's wrong.
Christina Fisher and Tony Rogers, broker. You all stand for just a second. Ms. Kirby will swear you in.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
All right, Mr. Young.
The applicant is Christina Fisher. The principal broker is Charles A. Rogers. Ms. Fisher has taken and passed the Tennessee real estate exam for affiliate broker. The principal broker is Charles A. Rogers. He was first licensed as a broker in July 25th, 1994, and became principal broker of the firm effective 1/11/1999. Mr. Rogers is responsible for supervising 90 affiliate broker licensees. There have been no disciplinary sanctions. The firm is Realty Executives Associates. The summary of disciplinary actions is theft. And the court documents show Ms. Fisher received probation and was fined. And Ms. Fisher's statements and letters of recommendation are on your iPads.
Thank you, Mr. Young. All right, Ms. Fisher, sorry about that mispronunciation. Would you give us all the details you'd like for us to know? And if you don't give us enough of them, somebody's going to ask you, so you might as well go ahead and.
Okay, that's fine. Okay, so I had made some very poor decisions in my life and ran with some pretty bad people. And we were at a Walmart, and the person I was associated with had stolen some shoes and possibly a drink. And he went on out to the car, and then I was paying for some items, and I walked out, and they stopped me because he was gone. I was scared, and I told them a different name, and then they got me on the theft charge because I wouldn't tell who he was. And then I did probation until fines were paid and was released.
That's what you want us to know. Okay, commissioners, Ms. Franks.
So he's not your friend anymore, right?
No.
Okay.
No.
And how long ago was this?
2012.
Okay. And can you tell us what you've done with your life since then?
Yes, I've currently, I gave my life over to God and just changed my life, and being active in church. They are sort of my support group, and just doing what I'm supposed to do. I don't affiliate with any of those people anymore, or do I ever want to, so.
Where are you working now?
I'm at Jewelry TV currently, and I work from home, so it's very flexible with wanting to do the real estate also.
What made you want to get a real estate license?
I love real estate. I know how it feels like. Me and my husband just purchased our home a year ago, and I know the feeling of like the excitement of purchasing a home, and I just want to help people do that.
Bloom.
Can you tell me again what it was that happened? Did somebody bring some shoes to the car, did you say?
No, they switched shoes. Like they went to a different aisle and they put their shoes in the box and switched them out. So.
Well, in your response, I have trouble reading that, but it looks like you had possession of drug paraphernalia?
Yes, that was another charge that I had in Knox County. And that was, I got pulled over and had paraphernalia in the car, and they charged me on that.
Was that a felony?
No,
So that's not something we need to look at then, is it?
none of them were felonies.
When did you complete your probation?
December or November 2000, like a couple months after it happened.
In 2012?
Yes.
Okay.
Mr. Horn.
Yes, ma'am. You don't owe any fines or forfeitures or anything of that nature, do you? And the next thing, have you looked into the possibility of getting all of that mess taken off of your records?
I've not, and it's something I'm going to look into.
So, Jewelry TV, did they check your background when they hired you?
They said they did, yes.
Did any of this come up?
No.
And when did you start working there?
Years ago in October 6th, yeah, 2 years ago.
Mr. Rogers, Tony.
Sir.
Why do you have an interest in this lady as a potential licensee with your firm?
She is
Move up to
she's-
that microphone, Tony.
Oh, sorry. She's good friends with one of the agents in my office that I have the utmost respect for, and I've gotten to know her over the last few weeks, and I believe everybody deserves a second chance. So I think she'd make a great agent for us.
Questions for Mr. Rogers? Ms. Taylor?
Realty execs, do you give, you have 90 people there, how do you train a new agent?
We have new affiliate training. We have that training for the new agents, and also we do some. I do some training inside my office. We train on all the systems that we use. We have someone come around to each office and do training approximately once a month, that's how we do it.
As a new agent, she has to go through the training first before she's let loose, so to speak?
That or she's placed with a mentor, and we do that as well, and that's what she's going to be doing.
Other questions?
I guess this is more for Mr. Rogers. I mean,
Yes, sir.
does the fact that this only happened 4 years ago, does that concern you?
No, it doesn't.
Okay.
I think she's learned her lesson.
Just to see how much you learned your lesson, were you arrested? Were you fingerprinted? Yes. Picture taken?
Yes.
Court?
Yes.
Bail?
Yeah.
Any of those things you want to do again? Just checking, just want to make sure. Tony, I've got a question for you after we vote, okay?
I'd like to make a motion that we approve her application.
Motion by Ms. Frank, seconded by Mr. Horn, that Ms. Fisher's application be allowed to process. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Good luck to you, Christina. Tony, so the Real Estate Commission, maybe a year and a half ago, passed some new rules or guidelines related to advertising. Have you found those to be helpful or detrimental to your agent's business?
Detrimental.
What respect?
Well, it's just keeping track of everything. It's
detrimental to you, business personally, as a principal broker?
Yes.
That's what you're talking about?
Yes. Now, as far as the agents go, I think it's really difficult for them to keep up with it all as well. And it's needed, though. It's needed. I'm just saying, it is detrimental, but it's progress. So and it protects the public. So I'm in favor of it.
So in your training for Ms. Fisher, you'll go over those?
Absolutely. Go over her contracts, all of her contracts, her advertising, any kind of advertising, web advertising, billboards, anything. We go over everything. We actually have a compliance office that helps with that as well, as far as the contracts. So it's looked at probably 4 different times before before we turn it.
I appreciate your opinion on that. Thanks. All right. Safe travels.
Good luck
Thanks
to
for
you.
coming.
Thank you.
Sherry Harrington and John Hughes. All right, in this particular case, I'm unsure who the broker is and who's the applicant. Who?
Broker.
Okay. Ms. Kirby.
Raise your right hand and repeat after me. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Very good.
Please have a seat. Mr. Young, give us some background.
The applicant is Sherry Harrington. The principal broker is John Hughes. Ms. Harrington has taken and passed the Tennessee Real Estate Exam for affiliate broker. The principal broker, John Hughes, was first licensed as a broker in 5/24/2013 and became principal broker of the firm effective 6/03/2013. Mr. Hughes is responsible for supervising 150 affiliate broker licensees. There have been no disciplinary sanctions. The firm name is Greater Chattanooga Realty, doing business as Keller Williams Realty. Summary of disciplinary sanctions is theft by shoplifting. Court documents show Ms. Harrington pled guilty received probation, fined, and did community service, and the additional information is on the iPads.
Thank you, Mr. Young. Ms. Harrington, tell us about it. When did it happen? Let's start with that. It's been a while, correct?
I was under the impression that I was here for an infraction that happened well, first of all, I'd like to say thank you for having me and the opportunity to explain. But 27 years ago, I was with some other teenagers and went to spring break in Florida and went to a person's house. Supposedly it was the guy that we were with, his grandparents' house, and we woke up the next morning to knocks on the door, and it was not his grandparents' house. And we were all pretty surprised by that. And in hindsight, I guess I should have checked the pictures on the wall to make sure that it really.
What were you arrested for? Trespassing?
Yes.
Don't go to a lot of detail. No, I just was curious. I mean, did you steal anything, or were you charged with stealing? It's just being in somebody else's house.
I was in someone else's house unlawfully, unbeknownst to me.
Understood. Questions, commissioners?
I'm a little confused because on here it says shoplifting, not trespassing.
The paperwork that I got from Aaron said that was 2 years later, and that I was with a friend in a store. She took a pack of ham and put it in her purse, and they stopped me at the checkout and detained me, and I had to do community. I was on a year probation. That was 2 years later with the same friend.
When you when you were in the house in Florida, was that a felony? Okay, so what you're here today for is that shoplifting, because it's theft of money.
Okay.
Either a felony or theft of money, or a theft, period, is why people come here before us for
apologize.
this.
I was misinformed.
It's an interesting story about just crashing in somebody else's house you don't know.
We'll have to tell our
Ms.
children
Taylor.
that.
When you started off, you were confused because you thought you were here to explain something that happened 2 years ago. Is that what I heard you say?
27 years ago.
27 years
Yes,
ago. I
ma'am.
thought you were confused about that, thinking there was another something that you were.
2 years after 27 years ago.
All right, okay.
Is when the other incident happened with the same friend.
But there is another one on here that is a felony on page 5 of her.
If you look underneath that, it says it was dropped.
Okay.
So what have you been doing with yourself since?
I was 19 then. I later moved on and had 3 children, and all of them are adults and good products of society. And I am a business owner. I go into people's homes and remodel their bathrooms and their kitchens. I have been successful at that for the last 17 years. I am married, and I am a springboard diving coach. I'm also a diver myself and won a gold medal 2 years ago at FSU. And I am seeking my real estate license because I have a true passion for homes and the families that seek them. I love everything about homes. I love renovation. I want to get off my knees because I'm 46 now and start redirecting the passion that I have for homes and people, and help people obtain the success that you find in home ownership.
Other questions for?
I just wanted to ask the convictions that you've had on your on the application where it asks, have you ever? No, let's see. Where is it? Number 5. Have you ever pled guilty to any crimes? And you said and you said no.
To be honest with you, I had forgotten about it. I was 19, and it happened so long ago that I did forget about it. I was shocked when it came back. It was something that, you know, it was before I had children, and, you know, with 3 kids and all the things that come with that. And
All I have.
All right, Mr. Hughes,
Yes, sir.
tell us why you're interested in this lady as an affiliate.
When I met with her and had the interview process, and I learned that she was a business-minded person and that she already had a database, she knew how to run a business. Those are the people I like to align myself with in this real estate world, because they can start right off the ground, and then once they plug into our training and coaching, they should be a great real estate agent.
Thank you. Questions for Mr. Hughes? Let me go to Johnny Horn first.
How do you do? Did you ever consider getting your records expunged?
it was supposed to be. My mother actually tried to, she paid a fee when she come and got me when we were picked up at the house the next morning. She came and got me and paid someone something. Like I said, it's been so long ago, I don't remember. But it was supposed to have been expunged. Going through the process of being a coach, you know, there's a thorough background check there too. So I was really surprised. But it is something that I would like to see about getting that taken off my record, because I pride myself in being a very honest person with a lot of integrity and a trustworthy person that can be trusted with someone's valuables in their home while I'm there working. So yes, I would like to see that expunged off my record.
Sure. Why do you think she would make a good sales representative?
Well, because she's a business owner, and that's what truly real estate agents are. They're business owners. They're not salespeople. They're business owners, and she's business-minded, and she's ready to hit the ground running. She has a database, and she understands how to run a database.
Have any training in place where you can check her progress as she goes?
Yes, I do, actually. I can look at every one of my agents' progress right now if I needed to.
Ms. Hills.
Mr. Hughes?
Yes, ma'am.
This is a little off this, but how do you view the advertising rules or adjustments?
Which ones?
Well, any of them. That's why I'm just asking as a broker, because
More prominent, or which one? Which word we want to talk about?
Any of them. I'm just asking your opinion.
My opinion on it is I like how you guys had changed it with the prominence, but then I learned the other day when we were in the meeting in Chattanooga that it was still going to be the same size or prominence, so we're kind of confused, to be honest with you. And so I've stuck to my signage in my office as one platform, that's it. And if somebody tries to do anything that's custom, it goes through a very vigorous process before it's released.
And that's on signage. Is there anything else with the advertising?
Well, I kind of look at it all in the same, you know, a billboard versus a sign in the yard versus magazines. You know, I think it's all the same, and I view it that way, as well as internet too.
I just like here, since you're from Chattanooga.
Yes, ma'am. And we take it very serious because we do have a lot of affiliates in several offices, and we do, I'm sure most of you know, oh God, I lost his name. Well, Steve Champion and I, we're totally on top of it, and we're watching it at a high level.
And so, do you see most people in Chattanooga?
You're going to have people pushing the envelope, and we have those conversations. Steve's thoughts and I on it are, if we're willing to come here and sit before you, then we feel like it's compliant. And I don't like to push the envelope, and neither does Steve. Thank you.
Just to follow up, one quick question about that.
Yes, sir.
So the guidelines are helpful in the fact that they're at least more specific than they used to be?
Yes, they make more sense.
Okay.
I mean, they're more, I mean, you can sit down with an agent and say, this is what they mean, except for when we learned the other day that we were under the impression that prominence was going to be the word, that we use, like more prominent. And then I believe,
How come?
Yeah.
What'd you say? Or Ms.
Yes.
Kirby?
Yeah, we have that statute that's separate from the rules that says on a sign specifically the firm name has to be the same size or larger than any other name. So that is a little bit tricky because we have the statute that's in place for signs, and then we have the advertising rules that also issue it must be the most prominent. So those on signs, those have to both be involved there.
So
That's
it's just,
kinda- yeah.
sorry, go ahead.
No.
And I think we had a detailed discussion about that in Chattanooga, and Steve and I discussed that after the fact. It's a true concern of ours because we don't want to bog you guys down with this kind of stuff. We want to run a business.
We appreciate that attitude, but if there's something this commission can do to help and still protect the consumer, I think we'd like to get that kind of feedback as well.
Yes, we're totally on board with that, and I've always said the consumer's never had a problem finding me.
Sometimes that's not the case, we found, but
Well, I agree, and,
we appreciate your attitude.
no problem. Thank you, sir.
All right, let's get back to the item that's in front of us, and that's to decide whether Sherry Harrington gets to go on and get a real estate license or does not.
I'd like to make the motion we approve this applicant.
Mr. Wood moves that she be allowed to proceed. Ms. Taylor seconds that motion. Is there discussion? Let's vote on the motion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Good luck.
Good luck.
Very much for the opportunity to come here today.
Well, thanks for coming up here. We're glad that you're dedicated enough to make that effort.
Thank you.
Absolutely.
Thanks, Jeff.
Appreciate your questions as well.
Yeah.
Since Ms. Kirby brought that discrepancy in the rules up, is that something we should address?
Well, we got that coming up as an agenda
Okay.
item later, and that's
All
why I
right,
wanted to
okay.
get a little feedback before we did that. Thanks, guys. All right, Mr. Weston, Mr. Yates, I've got to interrupt this process just for a second to get a litigator up here. They generally have no patience and won't sit around. So, Ms. Ryan, if you will come tell us what you're doing here. I know you're a busy person and don't have time just to sit around.
Actually, today what we have is a baby shower for one of our attorneys, so that's, and unfortunately, I'm on the Sunshine Committee, which means I have to participate. So, thank you very much for fitting me in. This is a representation of a case.
Talk louder, please, or move that microphone around.
This is a representation of a 2014 matter, and I'm coming back to you based on some things that have happened since you first heard it. And let me explain that this is the case that if you choose not to, I inherited it, okay? I just got it. I got it from the attorney, Denard, who's left. If you choose not to make a change, then I am going to ask, because of the dynamics of this case, I am going to ask permission to do it before an ALJ, and I'll explain that later. But let me start off with, this was first heard by you all in February of 2015, because the respondent, and as soon as I say this, I know everybody remember, was arrested and detained for violation of the Peeping Tom laws. Now, at that time, it was put in litigation monitoring. This respondent has licenses for both auctioneers and motor vehicle commission, and I wanted to update you on all of that.
In real estate?
And real estate.
Okay.
Auctions, real estate, and motor V. So this issue was before the other commissions as well. The criminal matters resulted in one dismissed and two were a best interest plea for 1129, which is a misdemeanor, and he did serve no time, and he got no civil penalties, no criminal penalties, nothing. What he did was when he was arrested, he spent the night in jail, and that was the summation of it, although he was ordered to do 40 hours of work, community work. The commission for the auctioneers, he had 4 licenses. They cited him $1,000 for each of the licenses, and he's paid. The commission for motor vehicles cited him $2,000, and he's paid. What this board and commission had requested was revocation, and that is the reason I'm back before you, to see if you would reconsider that, based on the dynamics I just explained. And if not, if you will give me permission then, because of the dynamics I just explained, give me permission to do this before an ALJ alone, so that there's no appearance or question about this person's particular rights based on that criminal matter, because I don't think we've had one ever before. As long as I've been here, that's the only one we've ever had like that.
So, because other commissions and the courts were not nearly as demanding as this commission is, you're back asking if we might like to
There are a lot of things involved. For instance, the particular the person who was the quote victim won't cooperate, won't give a statement, won't cooperate. There is no finding of guilt really in the grand scheme of things from the criminal courts. They found no photographs or anything, and so that always suggests that, and it was a best interest plea, and he absolutely has, as I said, is 1129, which is a misdemeanor, and he paid nothing. So that also suggests that there are facts there or issues there that probably make it weaker. And because this is the only commission, that you were asking for revocation, and that's the issue that we have before, that is the reason I'm come back to see if you would consider a higher civil penalty. It won't be resolved except for by civil penalty. I can just tell you that as well, because there will be a trial. And there have been and there are attorneys involved, and you know I'm not scared of trials, guys. Okay, I'm not scared of that at all. I'm just saying, when I see issues, I want to present them and give you an opportunity. And if you choose to remain solid in it, I understand that as well. But then I'm going to ask you, please, to give me permission to do that particular issue before an ALJ alone.
Chairman?
Yes, Ms. Franks.
I think because we have so many new members on this commission that didn't hear any of the information about it, that it would be hard for them to, with this amount of information, to make a decision.
Maybe, but we have 5 that did.
Who are those 5?
In front of me. It was presented twice, once in February of 2015 and July of 2015. Thank you.
I'm going to rely on my counsel to my right here to give me some advice or make some sort of statement.
Well,
Just
that is part of the problem.
Austin is part of the problem?
Yes.
Because he's a lawyer?
No. Because of the discussion that went on in this case beforehand. This is a part of being in the ALJ versus you all, that particular issue.
That case. What do you think, Austin?
I'm okay with an ALJ hearing it.
Gary, you're one of the 5, apparently.
I concur.
As do I.
As opposed to doing a civil penalty, a larger civil penalty.
Right. What is our civil penalty that we impose?
Well, you requested revocation and $2,000. You can get up to $1,000 per violation. You could increase the civil penalty as well. Well, we had just the 2, and they were the vague violations of, we only asserted 2. If we chose to look at it again to see if there were other sections of the statute we could quote, you can choose more.
My concern is that if the witness is not cooperating, I just,
We had an investigation, and she wouldn't, and her attorney wouldn't. And now sometimes that means they're negotiating settlements, but in this particular case, I can tell you that's not the met I got from that, because the defense attorney, the attorney for the witness said, I'm concerned that we push at this at all because the defense has a very good claim. So I'm saying that I think there's more to all of the story that we don't know. And I don't know what all of that is. If you want to go forward and have a trial on it, I'm happy to do that. You know that. I'm just saying there are more things here that may come up.
I've only know what I heard presented the first time, and my vote at that time was based on what I heard and what I considered to be a person who I didn't think ought to be practicing real estate.
I understand. I'm not.
And so but it's okay with me if an ALJ hears it and let them hear the evidence and decide. And if this board wants to do a lesser punishment, then that's up to them as well.
And I have no problem with either one.
Yeah.
Okay.
So at this point, I'd love to get a motion on the floor so we can discuss a particular.
We need a motion?
Yeah.
I move that we refer the matter to be tried before ALJ.
Is there a second to that motion?
I'll second it.
All right, so properly made is a motion that this case, instead of coming before the full commission, go instead to be presented in front of an administrative law judge. Properly made by Commissioner McMullen, seconded by Ms. Franks. Discussion on that motion. Mr. Horn.
A little bit of a problem for the monetary punishment. How far can we go?
Well, we can, as I understand, it's $1,000 for each violation. Found, yes. And at the time, we found 2, apparently.
You use 2 sections of the statute, as Mr. McMullen has suggested. Use 2 sections of statutes to justify the $2,000. I'm not saying there aren't more that can't, I mean, I haven't looked at it recently. I'm not saying there aren't more that could be, but that is where we were.
Okay, further discussion on the motion. So do you think, Ms. Ryan or Ms. Kirby, that those who didn't vote on this originally or weren't on the commission should pass on this vote? Or
I think they've heard the facts now that you've heard. I think they can vote. Do you not, Ms. Kirby?
I mean, I agree. I think it's up to the individual commissioners if they feel comfortable, like they know enough to be able to make a decision, then they're welcome to vote. If they don't feel comfortable, then they're welcome to abstain.
okay, let's, just for that reason, let's do a roll call vote on this, Mr. Young. The motion is to refer this case to administrative law judge.
And please, so that everybody behind me understand, when it's a question of revocation, this commission very rightly says this is something they should be hearing as opposed to somebody else. In this particular case, though, because of the facts and the dynamics, we want to make sure there's no question about the person getting a fair hearing and that we are not impartial in any way.
Ready for the roll call?
Yes, sir.
John Grease.
Yes.
Rick Douglas. Gary Bloom.
Yes.
Diane Hills.
Yes.
Austin McMullen.
Yes.
Marsha Franks.
Yes.
Bobby Wood.
Yes.
Fontaine Taylor. Johnny Horn.
Oh.
The final vote total is 6 ayes, 1 abstention, 1 no vote. So this matter will be directed.
Before an ALJ, and
Yes.
because it's an older case, I'm going to attempt to get it on the docket as soon as possible because, of course, less time is better. Thank you very much for hearing me today.
It's always a pleasure. You come down anytime.
Good luck.
Thank you. Thank you.
All right, Mr. Weston and Charles Yates, if you two will come forward, we appreciate your indulgence. All right, Ms. Kirby, swear these guys in, please.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you.
All right, which one is the broker?
I'm the broker.
And are you Mr. Yates?
I am Mr. Yates.
Okay, thank you. All right, Mr. Young.
Okay, the applicant is Gregory Weston. Principal broker is Charles L. Yates. Mr. Weston has taken and passed the Tennessee real estate exam for timeshare. Principal broker Charles L. Yates was first licensed as broker on 2/28/1996. Via reciprocity, and became principal broker of the firm effective 7/19/1999. Mr. Yates is responsible for supervising 50-plus timeshare licensees. There have been no disciplinary sanctions. The firm is OLCC Tennessee, Inc. The summary disciplinary sanctions is a felony of larceny, and court documents show that Mr. Weston was fined and issued probation, and his additional information is on the iPads.
All right, sir. Mr. Weston, you've seen how this works. Would you give us a little history lesson on what has happened? And speaking to that microphone, I know you're a big man, but you may have to lean into it for us to hear.
Yes, sir. In 1986, when I got out of the military, I took a part-time job with a retail store. It's not around anymore, Sky City in North Carolina. It's kind of like a Kmart. Sold a firearm to a really good friend of mine that didn't have the proper identification, driver's license. His brother was subsequently caught with this on federal grounds, traced it back to me. I got a felony firearm larceny.
30 years ago. What have you been doing since?
Stealing guns.
Stealing guns?
No, sir. No. I'm sorry.
You
No,
could have said stealing guns.
I don't hear
no, sir. I've been in the timeshare travel club industry since 1989.
Right, questions for Mr. Weston? Ms. Franks?
So what have you been doing in the timeshare business?
I work for Spinnaker Resorts, Plantation Resort in Myrtle Beach, also for Festiva, Church Street Inn in Charleston. These are, at the time in South Carolina, you didn't have to have a timeshare license to sell timeshare. Travel clubs, I worked for Global Escapes for the better part of 16 years, setting up off-sites, selling travel club.
So that was primarily in South Carolina?
South Carolina, well, I've been up and down the eastern seaboard with the travel club end of it. The timeshare end of it was in South Carolina, yes, ma'am.
Okay, and so they didn't require a license?
No, ma'am.
Do they require a license now?
I can't speak knowledgeably if they do or not, because this has been years ago, so I don't know if they do or not. I would like to say I don't think they do.
So where will you be selling?
In Gatlinburg.
Okay. Do you live there now?
I live in Sevierville, yes, ma'am.
Okay.
Ms. Taylor?
I see some other things on your record that you didn't mention. Manufacturing and selling marijuana.
No, ma'am, I was actually maintaining a dwelling. That was an automobile. I was in a softball tournament, and some guys on my team were in the back of my truck, and they decided to smoke a joint, and they got caught because the truck belonged to me. But I was answering his felony larceny was what I was talking about.
Right, and that charge is a misdemeanor and doesn't involve theft, so that wouldn't be one the commission addresses.
Horn?
Yes, it always intrigued me when I run into an ex-serviceman or serviceman that treat serial numbers and weapons reference so carelessly. Now, how long did you stay in the service?
4 years.
4 years, okay. And you realize that all weapons are traceable.
Absolutely.
And what was your rank?
E5 when I got out, Frock E5.
So you made that decision when you should have known better. So what I'm wondering
Without a doubt.
now is you entered into another new field, and it's a lot of things we hope that the broker is teaching you, and that when you attempted to make a easy transaction, have you kind of looked back at your past and thought maybe that's not the way we're going to go anymore?
Well, for me to say that I've thought about this over the last 30 years and that it comes up every time I make a decision in my life over whether something's right or wrong, I would be remiss to say yes, I do that. This is something that I've chosen over the years to forget about and put behind me and try to lead my life, especially being a father now, you know, having kids and obviously wanting them to do well and be the best people that they can be. For me to say that I give it a thought and everything that I do, I don't, because I have put it behind me. But I've also, I hope and I think over the years as I've gotten older, realized the things that are important, and I pretty much let my life be guided that way.
How many children do you have?
I'm sorry?
How many children do you have?
5.
Ms. Hills, did you have anything? No. Okay.
I would like to say that it seems like today that several people have forgotten their crimes. He did on his application say yes that he had had a charge. So I appreciate that honesty from him.
Mr. Yates, so I think I can answer this question myself, but why would you like for Mr. Weston to be associated with your firm?
Well, he's got a lot of experience in doing what we do, so that's number one. And I've got to know him quite a bit through this whole process, and I think he's a very reliable person. We can count on him to do the right thing.
We've had a lot of timeshare people in front of us over the years, but just from my perspective, if I'm committed not to buying a timeshare, he's the last person I want to run into because I believe he can sell. I may be wrong, but I believe he can sell. That's just an aside. Ms. Franks?
I'd like to make a motion that we approve his application.
Second.
I have a motion by Ms. Franks, second by Mr. Wood, that this application, Mr. Weston's application, be allowed to continue down the process. Discussion on the motion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Mr. Yates, how's the timeshare business in Gatlinburg? So the more people than ever are coming up there right now, right? Why is that? Just they got more money?
And it myself, sir.
Well,
we
you guys
appreciate it.
Oh, you guys be careful heading back.
Thank you.
Good luck.
Good luck.
And finally, in this section of our agenda, Kevin Gray and Linda Pennington. Yes. All right, if you, Ms. Pennington's already sworn in. Mr. Gray, if you'll raise your right hand. Ms. Kirby?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you.
All right, Mr. Young.
Applicant Kevin Gray, principal broker Linda Pennington. Mr. Gray has taken and passed the Tennessee real estate exam for affiliate broker. Linda J. Pennington was first licensed as a broker 10/12/2004 and became principal broker of the firm effective 6/10/2013. Ms. Pennington is responsible for supervising 200 affiliate broker licensees. There have been no disciplinary sanctions. The firm is Keller Williams Realty. Summary of disciplinary sanctions: theft by shoplifting. Court documents show that Mr. Gray received judicial diversion of 11 months and 20 days probation. Kevin Gray's statement and letters of recommendation can be found on the iPads.
Okay, Mr. Gray, why don't you tell us what your statement says on the iPad here? What happened?
Oh, okay, it's kind of similar. Just young, running with the wrong people at the time. Made a dumb decision going into a mall. Really, a stupid decision that shouldn't have been made. I take full responsibility for it, and I've went on to correct any type of wrong that I've done in that situation. I think it was theft, maybe of 150 or something like that. That equaled up to 150 under 500, and so.
This commission likes to know detail, like what was it you stole? We've heard about a pack of ham today, so there's nothing that can be.
It wasn't on me. Well, basically it was clothing. I'm not sure everything that was taken, but.
Help me out here. How did you get caught?
Well, I'm sure when you in the mall and I guess they watch you, you know what I mean? So basically trying to leave out of the mall, got caught by mall security and taken to the office in the mall.
Commissioners, questions?
Yes, sir. I'm not quite understanding exactly what happened here. You said that it was a pre-trial diversion.
I'm not really sure what that meant.
I mean, did you give a diversion when you went before the judge?
Did you make a deal with the DA before you went to court?
The only deal was to go do probation for it.
But no one told you that if you did your probation, paid the fines,
right?
Then at the end, this would
right.
disappear.
Right. Yes.
That's a pre-trial
yes.
diversion.
Yes.
Right.
Yes.
Okay. Then why didn't it disappear?
I'm not quite sure. Well, I guess recently they said that I didn't complete everything that I needed to do, and so I had to go back to that part of Tennessee and make sure everything was done. And so right now I'm actually working on trying to get it expunged from my record completely.
Hills?
I was in school at the time, and so when I went home for summer break, I wasn't able to actually go and see the parole officer that I had been assigned to, and so that was the reason why it wasn't completed just straight through, because I was from Memphis, Tennessee, and I was actually going to school in not Johnson City, but I was going to school in Greenville, Tennessee, and the incident actually happened in Johnson City.
I figured you was a student, otherwise they wouldn't have given you a pre-trial on that. It seemed like they did what they said they was going to do, but you didn't quite do what you said you was going to do. In other words, do you still owe any fines or diversion at this time?
It's all completed. It's all completed.
Everything's completed.
Yes, sir. They have paperwork from the courts on file here with TREC. I'm sorry.
Right. Thank you.
Ms. Hills?
So you were 18 at the time,
Yes, ma'am.
approximately, and you're 27?
I'm 26. I'll be 27 November 1st.
Okay.
Since then, I've completed college. I've had multiple jobs. Right now, I'm doing real estate investing, what you call a wholesaler. Not good at it, really, but that's what I have my foot in right now. So I put in the time and I put in the efforts to get my real estate license. I wouldn't risk putting Linda in a situation to where she would look bad or by hiring me or anything like that. I've moved on. A really dumb decision, kind of crazy having to answer for just years down the road, but you know, I've learned my lesson from it. I know what to do, how to move. These are things that I'm not involved in now, so.
What's a real estate investor? What was the other word?
Wholesaler.
Wholesaler. What is that?
Basically, you're just a middleman. Somebody's trying to sell a house fast. Well, I'm looking for people trying to sell houses fast. Finding them cash buyers who are trying to fix up the home for rentals or fix it up for a bigger profit.
So are you negotiating these deals?
Yes, ma'am.
You have a license, a real estate license?
No. Negotiating as far as a cash price.
Do you get compensated for that?
I haven't been so far. That's why I said I'm not just the best at. So I'm trying to switch over to just selling real estate.
Is there some reason that you're changing from Exit Realty Elite to this lady's company?
Yes, ma'am. I wasn't able to contact or get in contact with my broker from Exit. I haven't really spoke with him. And so this was a situation that I was kind of recommended into, so.
I need
Ms. Taylor.
some help. So you were with Exit Realty and you don't have a real estate license?
I was gonna hang my license at Exit, at a new Exit that was being, he's actually getting it started.
When basically negotiating sales of real estate before you are licensed?
As a wholesaler.
Well, I don't see what the difference is. Seems to me you're still in the real estate business. Can you explain the difference to me?
One of them, you are just kind of just the middleman, finding this person a cash buyer and getting paid a fee for finding finding a buyer for somebody, and
From who? Who you paid the fee from? By?
usually it's the person that's buying the property. I mean, selling the property.
How is that any different than what you're going to do when you get your real estate license?
With the real estate license, I would guess I'm really not sure what the complete difference would be, but with a real estate license, I would think you would be more maybe legitimate in your applications or your forms and things like that that you use.
When did you complete your probation for the portion of your charge here?
I completed it when I paid off all the fines, which was not sure the date, but this year sometime. Really, I had to pay off all fines for it.
Okay, well, so that's when that's when your probation was expired this past year?
The probation was expired 11 months after the incident was supposed to take place.
Ms. Pennington?
Yes.
Did you have any idea that he was a real estate wholesaler?
I didn't until I met him a few days ago. And this is a problem with what's going on right now in real estate, the wholesale idea. And I told him that wholesale situation is gone. That is not what we agree to. We don't advocate doing wholesale real estate. And if I can take him from the idea of a quick buck, and we call them bird dogs, and I don't agree with that mentality at all, because and I don't think the general public really understands the difference. And that's where, if he is awarded a license, I can train him specifically how to do it legally and be accurate and to protect the public.
So you're willing to take someone who's been practicing real estate without a license?
I don't believe he really has. He says he's trying to find cash buyers to connect them. He hasn't been successful, and because I don't really believe he understands the full extent of really what it's all about.
And you don't think they teach that in real estate school?
Well, he's just completed the real estate school end of it, and now he's beginning to get an idea. He was doing this before he went to real estate school. That's the issue. I'd like to give him a chance to do it correctly, because we take him from the very beginning how to work through a situation. He'll be connected with a productivity coach and monitored very closely. We've added that this year to make sure things like this don't happen. I think it's very serious. The general public doesn't get the idea of what wholesaling really is.
And I can tell you, I was appointed in 2014. I've never had anybody come in here and say they were wholesaling real estate. So that doesn't seem to be something we hear a lot. So
that's
it
exactly
causes
right.
me great concern.
That's my point, and it goes on a lot. And
In Nashville?
Yes.
Or where?
I've never heard of it here.
And you won't, because the people don't think they're doing anything wrong, because they're bird dogging. They're finding property for investors, or finding a situation where an investor can come in and buy the property. He's not hooking people up, property owners and buyers per se. He's finding investors to go off and purchase properties.
And that requires a license. Do you agree?
I do, yeah.
Okay.
But I don't think he was aware of it until he took the real estate school.
Mr. Gray,
class.
how would you find a prospective seller in this situation where you were wholesaling?
Well, me personally, I was going down to the court. Well, not going down, but I purchased the I forget what it's called, but you can go online where you can look through probates and things like that, where you can go through the documents and find like different sellers and things like that have property that they may be interested in selling.
Like a situation where somebody's just died.
Right, right.
And you would contact their
Yes.
survivors to
Yes,
see
sir.
if they wanted to sell the house.
Contact the executors to see if they would be interested in maybe selling their home.
Any names? So, how did you get introduced to this? Someone else doing it that said this is a good way of doing it, or?
Yes, ma'am. Basically, the internet, finding out about it on the internet, and then I joined the local Nashville Real Estate Investors group, which also, it's a group of wholesalers in that group as well. And so it's pretty common amongst the investors, but now I see that it's not really accepted among.
This is a type of information that you'll see the late night infomercials. You don't have to have a license. This is how you do it with other people's money. This is the problem because the general public, they don't realize that this is wrong.
So, and do you think it's because we run into things with classes and things, so you'll have a teacher from out of state that maybe doesn't have this state or vice versa, and you think it's something like that like a program that originates? Because I'm just not.
Well, it is. There's years ago there was the Carlton Sheets method of doing real estate. It's that type, where they're telling you this is how you're going to make quick money. You don't have to have a license. You're going to find investors to buy what you find, and we think of it as selling real estate, for sure. But I don't believe that the general public understands that.
Appreciate your. I'm sorry.
How long have you known him?
3 days.
Well, on this letter of recommendation, it says you've known him 1 day. So now it's 3 days.
I apologize.
And so you have confidence in somebody you've known 3 days.
Well, I'd like to give him a chance and put him through our training program, for sure. If you agree, if you don't, that's why we're here.
Yes, sir. I have one other thing that you said that I don't have to worry about it now that I know the right moves. And I'm wondering exactly what did you mean by knowing the right moves. Let me tell you exactly what I'm talking about. As far as I'm concerned, any kind of deal is two people being honest with each other. So there's no maneuverability. It's that I have something to sell. Right. You have the price, then we ought to talk. But me knowing the right moves, it doesn't sit good with me. That's what I'm saying. So would you explain that to me?
This is the more, I'm going through the proper channels now as far as being with a broker and things like that to make it, I guess, more legit. So I putting myself through the right training.
If he doesn't do the right moves, how do you fit into this?
If he doesn't do the right,
I'm sorry, yeah, go ahead.
I would broker release, and I think you know me well enough that I don't put up with much. And if he doesn't follow the rules, he doesn't work for me.
Does he know this? Does he understand that?
Yes, he does.
Thank you.
Ms. Taylor.
You've taken all your classes, correct?
Yes, ma'am. Yes,
All
ma'am.
right, so in your own words, tell me the difference in what you were doing and what you will be doing.
I'll now be, in my own words, what I know, I'll be working with a broker, going through training first. And so then before I get out in the field and try to actually sell a home.
You have been listing up to a point, correct, by finding a house. You've been finding houses in the court system, right?
Yes.
And you have been
finding people who may be interested in selling, yes, ma'am.
Well, let's find a house to sell, right? And you have found then a person to buy that place. That's what you have been doing, correct?
That's what I have been working on, yes, ma'am. I haven't been successful yet, so.
But success or not, have you been trying
Yes,
that?
yes,
Okay.
that was my goal.
That was your goal.
First.
And what's the difference in what you're gonna be doing with a license hanging on your?
Just like from what I know, I'll be just working with a broker and like I say, going through all the proper channels that I need to.
My feeling is that you don't understand the difference. That's my feeling, is that you don't really know what you have been trying to do. Whether you succeeded or not, you were trying to. And what you're going to try to do. That, and going through school, you've already had your schooling, and so you should have gotten that in your head, that you know that what you were trying to do and what you're going to try to do is really the same thing with a license.
All right, other comments? Mr. Wood?
And my question, I mean, you can kind of feel there's some concern here, but my concern is actually for both of you, and as I sit here and I mean, as an applicant, you got to find a broker that's like, I mean, and from a commissioner standpoint, I look at the broker to find somebody that's kind of spent time, vetted this person out, talked to them, and you're coming to us and telling us that, hey, I've looked in this person, this is going to be a good person. I don't think you've done that, and that concerns me. And you know, and the true part about being a broker, I mean, you're taking these people and you're responsible for them, just like I'm responsible for mine. But it concerns me. You've known a person a day, and then you take them, and you know, and I'm not sure why they went from one broker to another. I don't know that you're being a broker anymore. You're more of a license warehouse, and that concerns me. Okay.
Ask one other quick question.
Yes.
Just to be clear again, so you haven't been on probation in the last 2 years, is that right? So when you were paying the fine still last year, you were on probation at that point?
I was not on any type of probation at that point.
Okay.
He said that, well, when I went to go pay, he said that it wasn't complete, and so he wasn't going to come and try to find me or anything like that since I was in Memphis. But to my knowledge, no, ma'am, I wasn't on any type of probation.
Okay, because you can't be granted a license if you've been on probation in the last 2 years.
What does his record show us, Ms. Kirby?
We don't have, I mean, our record shows that he was supposed to be on probation for 11/29, so 11 months, 29 days, but we don't have a document saying when that ended, like whether it actually ended at that point or not.
So does legal ask for that before they come in here?
This is done by staff. Legal doesn't do this.
Okay.
So it should have been. I don't know if it was.
Ms. Kirby, would it be appropriate to defer this in order to obtain documentation whether or not he was on probation in the past 2 years?
I think we probably should verify that. If you want to make a motion, whatever your decision is, I mean, if the commission votes to approve him, then maybe it could be with the contingency that he was not on probation for the last 2 years once that's verified. But I think it would be best to make sure we know that for sure.
I don't know what the will of the commission would be, even if we had proof that he had not been on probation for the past 2 years in light of what we've heard about this wholesaling issue. So
Can we take no action?
Well, I think we owe the candidate at least some decision.
And just remember that this process of coming before you is to carry out the statute that says licenses shall be granted only to persons who bear a good reputation for honesty, trustworthiness, integrity, and competence to transact the business of a broker, affiliate broker, or timeshare salesperson in a manner to safeguard the interests of the public, and only after satisfactory proof of such qualifications has been presented to the commission.
Mr. Gray, are you familiar with that term, broker release? What do you think it means?
If you don't follow the rules, your broker will release your license to TREC.
Or for any reason.
Right.
Like something that you said today might prove not to be correct tomorrow, and the broker has the right to unilaterally release that license. Okay. All right, what's the will of the commission?
I move to deny his petition.
I've got a motion by Ms. Franks, seconded by Ms. Taylor, that this request be denied. Discussion.
And I'd like to just say the reason I made the motion is I think you have a whole lot of potential. Again, we've never heard anybody come in here and say to us that what you've actually been doing is considered real estate without a license. It's unlicensed activity. And so that's our first red flag. I think, I don't know how you get at the ability to do this without any concern from us. I'm not sure about that, but I think that is a possibility. But then I also think that I agree with Mr. Woods about your broker. I don't know if in one day, I think if I'd had a conversation with him, I would not be bringing him in here knowing what he's told us today. So I hate it and it breaks my heart. And I don't know how to even direct you about it. I think you could have a lot of potential doing it though, but I think at this point, there's just too many red flags for us today to say you can have a license today.
Other comments?
I think for me, it's the fact that I don't see that you understand what you did or what you're going to do. I don't understand that you get the difference. In my mind, I just don't get it.
Mr. Bloom.
Yes, I've got an agent who works for me who used to wholesale. And actually, if you get it done right, and I think Miss Pennington will help you get it done right, you are in the most difficult part of our business. I mean, that all you do in wholesaling is prospect. That's all you do. It's the very thing that most real estate agents don't like to do. So if you keep up that aspect of it in a correct manner with a license, I think you can be ultra successful. And it looks to me like you have somebody who's willing to hold your hand there.
I'm willing to go through I want to go through all the training and things like that she's going to provide for me. It was going to start today, actually.
Stay close to her.
Mr. Horn.
I think that you may be given a bad rap on all the realtors here because I know everybody is doing this wholesale stuff. And they're telling people, look, if you find a good house, let me know. And everybody's sort of quasi out looking for a bargain to tell somebody like who's able to buy the house. And so I know there's a lot of that going on, but you was the only one candid enough to come in.
I didn't.
And say that, you see.
I wasn't aware that it was.
Yeah.
I wasn't aware that it was any type of that it would make.
We can tell you weren't aware. We can tell.
Let me finish here. What I am concerned about is that you may still be on paper.
I'm not. I can tell you I'm not.
So you're not on paper?
I'm not on any type of probation, and I haven't been.
Oh, well, see, if you get 1129 and you only prove 3 months of it or no time of it, you're still on paper because you were sentenced to 1129. But in your case, you said you had a diversion, so once you get off of your pretrial, then they can release you from there. So if they did, if your PO released you, then you ought to have something saying that you was released from probation on such a date. So I don't even know how long it's been since your 1129 to this date. Because if you take the 1129, you're going to have to put 1129 against that date. Is that right? So if you, in other words, if I got in trouble in January then December I should be able to get off. But that's almost a year. That's what it is, 11 months and 29 days. Otherwise, it would be a felony. Okay, so that's what I'm concerned about. I don't want you wasting our time if we approve this and you're still on paper.
So the conviction was in 2009. So if it was the 1129, then it should have been completed a long time ago. But since he didn't pay and do those things that he was supposed to do, that's why I'm asking if it was held longer than that.
Ms. Hills.
Did you play sports in
I
Greenville?
did, yes,
What
ma'am.
did you play?
I played basketball.
Okay. I have concerns because if we were to vote to approve you, then you have a license issued. I have trust that Ms. Pennington would do training, but if you don't take the training well, then she then releases you, and then we have a licensee out looking for someone else to pick them up. I am on the fence. I think I appreciate your truthfulness and your working. I think that you were looking for a way to do business, and you just didn't have enough knowledge at the time to know that that was not a way in this state to earn a living, to be collecting money. So I would just trust that your discipline, that you were looking for something to work and try to. I would just trust that you better stick with a broker.
Other comments? I'm gonna give you my position. I'm gonna vote against the motion for two reasons. So he was required to be here on a theft charge, and during the discussion he talked about what I think was selling real estate without a license. But that's not what was in front of us today. I mean, he was candid or careless. I don't know what the right word is to bring that topic up. Second of all, I have a lot of confidence in Ms. Pennington, who over the period of time she's been here has always spoken what I believe to be the truth. And I think her reputation is more important to her than yours is. And so I don't think she's going to roll over if you want to go cavalier on her. I think you'll be out.
I'm not trying to go anywhere. I'm just trying to get in and learn it as much as possible.
Well, you're putting your reputation on the line. If you get the opportunity to go forward, you're putting her reputation on the line, and I'm telling you, her reputation is more important to her at this moment than yours. So you've got to earn that trust. And I wouldn't cross her. I wouldn't do anything different than what she says to do. If you are lucky, and I don't know how this vote's going to turn out, but the motion on the floor, which we're about to vote on, is to deny your petition to go forward. Okay? That's what we're about to vote on. So, commissioners, if you're ready to vote, if you're in favor of that motion, you'll vote yes. If you're opposed to that or have some other motion you'd like to present, you'll vote no. And let's do a roll call vote on this.
John Grease.
No.
Rick Douglas. Gary Bloom.
Yes.
Diane Hills.
No.
Austin McMullen. No. Marsha Franks.
Yes.
Bobby Wood.
Yes.
Fontaine Taylor. Johnny Horn.
All right, we have 4 yeses and 4 noes, so that motion fails. Is there another motion someone would like to introduce?
I'll make the opposite motion. I make a motion that we allow Mr. Gray to go forward.
Second.
There's discussion on that motion.
I would like to amend that motion.
Okay.
That he would be allowed to go forward, providing that he met all the requirements, including that we checked on his probation.
That's.
I'll accept that.
Mr. Bloom. Okay, so the motion now in front of commission is that your license be allowed to be processed and you go forward with your career in real estate, subject to legal's review that all items have been properly taken care of, okay?
And he'll also have some hours that he has to take. After being licensed, he's required to take some more license classes too. So I think that might help too.
Okay, so is there discussion on the motion?
My concern is not with honesty. I think that's one of the characteristics that Ms. Kirby read when she was reading those statutes. It's with competence, and I think competence can be fixed easier than honesty. And I believe that you're an honest person, but I don't know that you are completely yet competent. You may meet the very minimum threshold, but you need to do some studying, and you need to work with this principal broker to learn a lot more before you are out there actually handling transactions on your own. And I trust that you're going to do that, and that she is going to lead you in that. And you need to really get into those books, and you really need to understand this better than you do right now.
Other comments?
Would he maybe be placed with either a mentor or someone that he could every day, day in and day out, see how it's done correctly?
Absolutely. I mean, we'll do whatever you suggest, and I think that's a great idea, especially in this situation.
All right, are you ready to vote? We're going to take a chance and do a voice vote. If you're in favor of the motion to let this licensee move on in his career in real estate, please vote aye.
Aye.
If you're opposed, vote no. All right, that motion passes on an 8-0 vote. I don't know how much more through the ringer we could have put you today. But I think you earned it, okay? But I'd love for you to come back in a year and say, based on what Ms. Middington has done for me, I'm a success. You stop by any time and tell us that, okay?
Thank you so much.
Guys.
Good luck to you.
Thank you.
So we'll verify your probation, and we'll get in touch with you about that. Thank you.
All right, John Giffen, would you come to a microphone for a second? You've been awfully patient. I know you have a reason for being here today. Would you at least tell us what that is? We may not get to the topic, but I'd like you to let us know what's on your mind.
I'm John Giffen. I'm manager of broker services for Benchmark Realty. I'm also a principal broker for one of our Franklin offices. I submitted to Mr. White a new course that I wrote over the summer in response to the Commission's desire to have some continuing education when a consent order is issued for principal brokers in lieu of coming to a two-day Commission meeting. So I wrote a course called the Principal Broker Professional Standards course and have submitted it to Mr. White to review and to present to the Commission for approval. And so I was here to answer any questions that the Commissioner might have had. Commissioner Franks has looked at it, and I believe Mr. Young has looked at it. So,
Well, if Ms. Franks so desires, we'll just pull that right onto the agenda right now. Would you like to get that course under consideration?
I would love for us to do that, if we could just do that one course.
Mr. White, are you prepared to give us your recommendation on the course?
Yes, Mr. Chairman, members of the Commission. This is a course that's on your agenda today, and it's marked as S5. Mr. Giffen's here with us to speak with us. Any questions you may have, but basically, I've reviewed it and found it to be quite an excellent course, and it would do a couple of things. If the Commission decides to approve it, then it would be considered a core course for principal brokers. And in other words, principal brokers could take this course and meet the core requirement that we have now, the general core requirement, because all the subject topics are included within this course. And he provided to Mr. Young, I think myself, the course itself in a manual here, TREC Residential Core course. However, he's presenting the course today to us as Principal Broker Professional Standards. If the Commission adopts it, then he's asking us to name it the 2017-2018 TREC Principal Broker Core course.
All right, questions for Mr. White?
Mr. White, what number is it on our iPad?
It's,
S5.
yes, it's S5.
Oh, I mean, what, no,
Oh, on the
On the education agenda.
number 10.
okay, thank you.
Mr. Chairman, Matt, I just want to say one more brief thing. I have been asked by the Tennessee Association of Realtors to write the 2017-2018 core, residential core, and the commercial core, which are now completed. The commercial core has some tweaking to be done. The residential core is embedded inside this course. What is added are specific topics for principal brokers. And that's the reason it's been brought into an 8-hour course instead of a 6-hour course. And so,
So if this is approved, this just is for 2017, 2018.
Right.
We can't recommend this as an alternate course or a course instead of attendance at this point.
This originated in, I know you'll find this quite hard to believe, but Mr. Giffen actually listens to all of our meetings. And we were
watch them.
we had a meeting where there were several principal brokers that we needed education for, and we didn't know what to give the principal brokers. And so he came to me with the idea of it, and I just thought it was an excellent idea. And so he has been working on it for several months. It's not that we're going to require some new class that brokers have to take. This is for us to be able to use when we need to give a principal broker some education. If they're not grandfathered, then it also would be their core class that they can take too.
How often do you think it'd be offered?
Well, that's one of the things that Steve McDonald and I are working on right now. There's two avenues. In order to cover all of the principal brokers in Tennessee, I think we need an online portal. I'm actually doing consulting work with the ceshop.com and have been in discussion with their CEO. It's all about numbers for them to have and that's one of the reasons I've suggested that it might become a core course, because that way they could justify loading my curriculum and licensing my course online. If that doesn't work, then Steve McDonald and I have been talking about possibly utilizing the new technology that TAR has brought on board that I think he showed the commission back in May, June, something like that. We'll probably have to have proctors, and it would probably have to be taught at least 4 times a year throughout the state. So,
All right, other questions? If not, is there a motion to approve course S5 as recommended by our education director, Mr. White?
Move to approve. Second.
Motion by Ms. Frank, second by Ms. Hills. This course will be approved for the 2017-2018 education cycle. Discussion. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Thanks for filling the gap, and we appreciate having this course as part of our bank of tools. And thank you, Ms. Franks, for pushing Mr. Giffen up here on the agenda. We appreciate it. Yeah, sure.
So I appreciate you stepping out and doing this. I really do appreciate that. And I appreciate that you've watched the meetings. So you maybe have more knowledge than most across the state. So tell me, what have you, do you practice real estate? Or?
Not anymore. I stopped selling about 3 years ago. Just because I wanted to pretty much give 100% of my focus to being a broker. And so I'm a non-competing, non-selling broker. And part of a company that is growing very fast and in an area of Middle Tennessee and that is experiencing an incredible market.
So you're aware of the advertising changes and things. As a broker and a growing company, give me some insight. What do you, good, bad, and ugly?
Well, it's interesting because as I wrote the core and as I wrote this course, it gave me time to sort of reflect on the changes from last October. I think they're very good changes. All of my classes have been reviewed by Deanna Cooper, who's now an attorney, used to be the TAR attorney, but is now in private practice. And we had some discussions about the rules. I think from a broker standpoint, I disagree with the gentleman said earlier. I do not find them to be burdensome. I found it to be a lot more clear. I think there are some questions about prominent, as he brought up. And Deanna and I have talked about that, and our feeling is that prominent basically doesn't always mean size. It means the way a consumer in their shoes is going to look at advertising and look at the broker's identity as being most prominent. Though I think, personally, I think there's some more things that we could do. But at the same time, I am very adamant about following the rules. I think as a principal broker, and I think those on the commission who are principal brokers get frustrated when others don't follow the rules. And that creates some issues. And it's taken some time to train our agents on the new rules, but we have a professional standards course that I wrote that we teach once a month to all of our agents, and the new rules are incorporated into that.
Always welcome to any suggestions, insight from people like you out in the field.
Well, and I know that was a lengthy process as I followed it through rulemaking, and I know you took a lot of time and effort, and I know they were tweaked as you went. And as I wrote the core, I think we're good right now. I think as the industry changes, as technology changes, I will say one thing that is problematic, especially as I teach courses, is the social media. Social media is such a fluid online presence. Twitter, LinkedIn, Instagram, Facebook, they're all different. And I've told all my agents, I don't care what you do, what you say, firm name and the firm telephone number must be in whatever you say in those ads. That has been an issue that's come up as a question in my classes, is what's our thought on social, what the commission's thought on social media. So it's no different than any other advertising, according to the rules. So.
Hi, John. Thanks for coming by.
Thank you.
Thanks for watching us.
Appreciate it. Thank you.
We have one more item before lunch. We'd like to recognize Commissioner Janet DeChara that has managed to stop in, and hopefully is going to have lunch with us, right, Janet? And before you do that, we'd like for you to come up. You might want to hug me or somebody else. I don't know.
You know she does.
But we have a little token of your service on this commission, and it's really a small token compared to how much we appreciate what you've done and what you're doing. Thank you, ma'am. Good to see you. Yeah, take a picture. Wait a minute, leave my glasses off. This is Tennessee Real Estate Commission honoring, I can see your name because in big letters, Janet DeChara. Tennessee Real Estate Commissioner 2011 through 2016 in recognition of your outstanding dedication, commitment, and support to the profession of real estate. We couldn't have said it better. Good to see you, miss. All right, what time is it?
Lunchtime.
12:21.
12:10. Is that what you
12:10.
11?
Yeah.
12:10.
12:10.
Okay, we'll be back at 1:30. Okay, you got an hour and 20 minutes to do what you need to during this period of time. And those of you on the phone, we'll
1:30.
check in with you when we get back. You want to call the roll now?
I think it would be a good thing.
Those of you on the phone, take your mute button off. We're going to ask if you're present. Who's got the roll?
I have the roll.
All right,
Yeah, the ones that left also.
Ms. Savage?
Here.
Mr. Kill?
It's Carrier.
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 What's the third one? Stafford.
Here, sir.
All right.
Should we just stay on the phone here, like just keep the line on here?
Oh, I want you to come back on, probably dial back in, I guess, at 1:30 Central Standard Time.
What about the names of the people who left after the break?
Okie dokie. It's about 1:15 my time right now.
Call back in at 1:30 Central Standard Time.
Thank you, sir.
Thank you. All right, let's get started. Ms. Page, it's our tradition to drop everything when a litigator shows up, so would you mind coming up and letting us know what you're doing here today.
Check who's on the phone.
Yeah, let's let Ms. Page, this is important, you know, these people are busy. We've got to.
Thank you so much, Chairman Grace. I appreciate it. Good morning. Oh yes, good. You know, I'm very bad about doing that. I do that all the time. In law school, they told me that would be a big flaw of mine, is telling everyone good morning in the middle of the night. So I think they were right. Members of the commission, as always, thank you so much for allowing me to appear before you today. Today, I'm here to with a representment of two particular complaint numbers. Those complaint numbers are listed first on your legal reports. First complaint number is 2015-020141. And the second is 2015-020151. Absolutely. I'm here today to request a reconsideration of the charges previously assessed against Respondent 1 and Respondent 2 in the description that you see. As you can see, there is a Respondent 3 and 4, however, those were previously dismissed by this commission. Yes, Mr. McMullen? The complaint number is 2015.
Do you know the number on our legal report?
I think it's 1 and 2.
Okay.
Absolutely. So this case, as you can see, has quite an extensive summary. The first time it came before this board was based only on the first respondent's response. And the second time, after the complaint was located, the second respondent submitted a substantial response, and that is why it came before this board a second time. This is the first time it's been represented by litigation. The reason I'm requesting a reconsideration of the charges in this case is because the timeline, as it has come through litigation preparation, interviewing witnesses, and collecting different exhibits, it's been discovered that the original thought on this case, in sum, was that a house was sold twice, perhaps intentionally deceiving the complainants in this case. However, after review of the evidence and speaking with all of the witnesses, it's become clear that that is not how this transaction occurred. In sum, this house was sold to the complainants through a backup contract. However, since it was a backup contract, there was already a deal pending on this case. Originally, it was believed that the complainants and their agent did not know that this was a backup contract when it was entered through a second counteroffer on the case and then an ultimate PSA. However, after speaking with the agent that represents the complainants and the complainants themselves, it has become evident that Respondent 1, the affiliate broker in this case, did in fact inform complainant's agent at the very first viewing of the home that there was an offer that was going to be pending with a home sale contingency, and that their intention was to continue to market the home because they would rather not have a home sale contingency. We've learned that this was a very popular property. The property was first showed for viewing on a Thursday. 16 different parties were there at the time, and it ended up selling over that weekend. Through the testimony and different conversations and text messages and voicemails, it seems apparent that the complainant's agent was aware that a binding contract was on this property before counteroffer 2 was agreed to. That counteroffer is what ultimately allowed the complainants to have what they believed to be a binding contract. The issue seems to be that complainant's agent didn't inform complainants of this binding nature of the contract until they had signed counteroffer 2. Complainant's agent originally stated that she didn't know it was a binding contract. I would say that the evidence is unclear on whether that's a true belief, but the evidence does lean towards the fact that she probably did understand that the binding contract with the purchasers who ultimately got the house was in fact binding, because in text messages they describe enacting a 48-hour kickout clause, and in order to have a 48-hour kickout clause, you need to have a binding contract. So what ended up happening with the commission is Respondent 2, who is our broker in this case, was assessed similar penalties as was the affiliate broker, failure to respond, unfair dealings, and things along that lines. However, we believe Respondent 2's complaint should be closed. This occurrence happened over a weekend when Respondent 2 was not in the office. When she arrived on Monday, she quickly addressed earnest money received by complainants in their attempt to continue forward on their contract, despite being aware that it was a backup contract and that the 48-hour kickout clause had ultimately been satisfied. And she also informed her office of new procedures in order to ensure that language in all PSAs in the future include indications of backup contracts. The reason that seemed unclear to both agents at the time was because all parties were informed that it was a backup contract when that PSA was signed. And that is different than what we originally believed. So for that reason, we would request Respondent 2's complaint be closed. There doesn't seem to be any evidence in the file that she failed to supervise her agents, and she took remedial actions immediately upon any sort of concern from this board. As it goes to Respondent 1, originally the violations that were listed, I believe, were in an effort to get to what a rule that wasn't considered by this board. The rule that I'm referring to is 1260.02.08. What this rule says in sum is that a broker and affiliate agent are responsible for including all terms and conditions in any purchase to sale agreement. This rule wasn't originally considered by this commission, but rather other rules and violations such as reasonable care and dishonest dealings were looked at in order, I think, to achieve the goal that this rule ultimately achieves. So my request would be to look at Respondent 1's case and the things that happened to them and to assess it in light of this rule, rather than what I think is unsupportable, which is that she was dishonest in her dealings. From the evidence, it indicates that she did attempt to keep agents for the complainants informed, and that the failure may have been on complainants' agents' part as far as informing her clients of the nature of the contract in time. So I know that's a lot of information. I'm obviously happy to answer questions. Both respondents have their attorneys present. They've been informed that if you do wish to hear from them, that they are not to reveal the identity of their clients. So if you do have questions, they are present here today. In addition to that, we recommended $500 if you do assess a violation against Respondent 1 for that rule violation. I did want to note that when reading the rule, it does appear that both agents for each side of the party would be responsible for ensuring contingency language, such as a contract as a backup, is in that purchase sale agreement. For that reason, it becomes a little more complex because the complainant's agent was dismissed. So in theory, complainant's agent and Respondent 1 should have been equally responsible for ensuring that contingency language was in the contract. However, complainant's agent has alleged some evidence that indicates that she may have been unclear of the binding nature and therefore didn't ensure it was in the PSA. However, I just, honestly, without having to prove it, I would just find that not credible at this point, just from my conversations with her. So for that reason, we would, in light of the fact that Respondent 3 was dismissed in this case, and there is evidence that would somewhat counter the idea that she knew for sure that this contract was binding, in a hearing setting, it would probably be difficult, but I think she did provide some evidence, obviously, to this commission that was considered credible enough to dismiss her. In light of that, we would ask, and maybe instead of the $500, I've spoken with the attorney that Respondent 1 would also, as an alternative, be comfortable with taking continued education in multiple offer situations and contracts and things of that nature. So I did want to throw that out as another option, but obviously this commission is well informed and able to make a decision on what they believe is an appropriate response.
All right, Ms. Page, so I want to use the term you use, in sum. I guess that means in summary, right? I just want to make sure I understand that.
Yes, in summary. I tried to sum it up the best I can. It is a complex timeline, and most of these events occurred within hours of each other, if that.
We have two respondents that you would like for us to address.
Yes.
Respondent 2 and Respondent 1.
That's right.
Respondent 2 is the principal broker.
That's right.
Your recommendation is for this commission to dismiss any penalty at all against that respondent.
Yes.
And then to consider a reduced penalty, civil penalty, for Respondent 1.
Correct.
Okay.
Or continued education as an alternative.
Okay. So, Commission, would you like to take them one at a time? Go with the principal broker first. Is there a motion?
I'd like to make a motion that we approve council's recommendation that we close our dealings with Respondent 2.
Second. Motion by Ms. Frank, seconded by Mr. McMullen, that any charges previously assessed against Respondent 2 be dismissed. Discussion. Let's vote on the motion. Those in favor vote aye. Aye. Those opposed, no. That motion passes unanimously. Now, Respondent 1 is an affiliate representing the complainant.
Respondent 1 is representing sellers.
Sellers,
The
okay.
complainants in this case were the potential buyers who lost the property.
Got it. So your assessment of this situation is that perhaps Respondent 1 was not clear in getting the message back to the complainants.
I believe it was actually the opposite. I believe Respondent 1 was clear that there was a binding contract. During their negotiations of counteroffer 2, we have text message copies that show that she does bring up that contract and they discuss it. The text messages end and a phone call is received in which they discuss the binding nature of the contract. I believe in reality, complainant's agent, who was previously Respondent 3, is the one who had the information but had a delay for whatever reason in relaying that to complainants.
So why wouldn't you recommend we just dismiss charges against Respondent 1?
I think that would be an appropriate action. I did want to point out this rule because I do believe there still is a violation at some level of this rule where it says that all PSAs must have some sort of term and condition. So if this commission was interpreted that rule to mean that if you are a backup contract, even if all parties knew that that should be listed in the contract, I believe that a violation still does occur here. I don't think it's nearly as egregious as it was originally interpreted because, again, all parties were informed of the status at the PSA level, including the complainants.
What's the rule number?
The rule is 1260.02.08.
Sure.
Move that we accept council's recommendation to assess a civil penalty of $500 against Respondent 1 for violation of 1260-02-.08.
Second.
Counsel for the respondent would like to know if you would like an opportunity to hear from him.
Let me get this motion on the floor, and then we'll
Yes,
check and see
Chairman.
if we want to do that. So the motion is properly made by Commissioner McMullen, seconded by Commissioner Hills, that Respondent 1's civil penalty be reduced to $500. That's what's on the floor. Mr. Bloom.
Yeah, I would like to add that that person go to school. You can't sell one house to two people.
Okay, do you want to offer an amendment?
I'd just like to add that the education be included in the $500.
Would it be like maybe like a 4-hour contracts class or something?
Yeah.
That's your friendly amendment.
Yeah, I'm offering that.
Okay, so the motion, is there objection to that amendment? Then without objection, we'll add that to the motion. The motion is to reduce the civil penalty to $500 and add a requirement that the licensee take a 4-hour contracts class within 180 days or attend a full session of the Tennessee Real Estate Commission meeting within 6 months. Is that what you said, Mr. Bloom?
That would be fine.
Okay. Now, is there a desire to hear from the attorney representing Respondent 1?
I want to ask a question, and
Okay, go right ahead.
when she gets finished in a second.
We're going to check on that as soon as we finish up with this. Stand by.
Would it be fair to think that? Go ahead.
It's unrelated. Go ahead.
Would it be fair to think that maybe both agents, some would call it the listing agent and the buyer's agent, are maybe both equally at fault in something and not reducing their thoughts and conversations to the actual contract?
Yes, I believe that in this case, Respondent 3, if Respondent 3 would have been equally responsible to ensure that language is in the contract. Where it gets a little more complicated, really just from the litigation perspective, is that she did offer evidence at some level that this commission believed to be credible, and I think that a judge could as well, that indicates that she was confused on the actual binding nature of the contract. I think there's evidence that does counteract that, but I would say it's a lot of it is interpretations from her credibility from discussions I've had with her.
Respondent 3 already been dismissed.
Respondent 3 was dismissed at the initial consideration of this complaint.
And where I'm going with this, because just what I've seen, what I've heard over this time, I think they both have equal issues, and I just have problem punishing one and not both. That's my concern. I'm not saying they don't deserve something. I just think it's equal.
I would agree with that, Commissioner Wood.
So, Mr. Wood, if you feel strongly about that, you're free to make a substitute motion.
Then I would like to, if I could substitute, and we're not, can I amend? Maybe it'll be easier?
Make a substitute motion. We've already amended it once.
Okay. But I like amendments. Okay. How about the substitute motion do exactly what we were talked about doing to respondent 1, but do the exact same thing also to respondent 3?
Is there an issue, since we've dismissed it, can we go back and reimpose it?
I'm going to defer to Mallory on that.
My understanding is that if it has not gone, unless it's a final order that's derived through a formal hearing, that it can be reopened.
Okay, so the motion offered by Mr. Wood is that both respondent 1 and respondent 3 be assessed the same civil penalty in set of circumstances. Ms. Taylor.
Would it be wise
I need a second to that. Let's just see if anybody
I'll
wants.
second. I'll second.
Okay, I got a second by Commissioner Bloom, so it's officially on the table. Now, Ms. Taylor.
Would it be wise to take them one at a time and
I mean, I think
It comes back from my rationale. I think they're both the same. Either they're both innocent or they're both guilty. I mean, they're both.
But is the, so 3 is the buyer's agent,
I'm assuming, yeah.
correct? No, 1 is the seller's agent.
Yes.
That's correct.
So 3 is one of the buyer's agents of the complainant. And so when you start off, to me, number 1, the seller's agent, the listing agent, is just at a little higher level of practice, agency-wise, to protect their client, the seller, where the number 3 is not at that level, and the
At the
and
same
one
level
here.
for the buyer.
Yeah, same level for the buyer, but it's the selling the 2 houses. I think the seller.
I think the law is basically saying take whatever is an accurate reflection of the transaction, reduce it to writing.
And which one had the 48-hour kick-out in it?
The original contract between respondent 1 and the people who ultimately purchased the home had the 48-hour kick-out clause that was enacted and ultimately complied with, so they got to keep the house.
Okay, is there a request to hear from the attorneys?
He's here. I would
this point, they
respect
both-
that, and if he has something brief that he'd like to say to us that might help in the consideration, that's fine with me.
If you come to the microphone, sir, and identify yourself for the record.
Good afternoon. My name is Aaron Guin. I represent respondent number 1, the agent for the sellers. If I may, just a point of clarification. A contract was entered into between the ultimate purchaser of the property and the sellers during a period when negotiations were ongoing with a number of other offers. There were multiple offers that were going on at the same time. It is perfectly clear that the day before the backup contract was entered into between the complainants and the sellers, that the agent for the complainants had text and verbal confirmation by my client, respondent number 1, that an offer that previously was understood as one of a number of offers had been accepted. It wasn't a matter of dishonesty or non-disclosure or anything like that. It's just the chain of events that took place. My client was not the draftee of any documentation. As the board is aware, the buyers would have drafted the communications. There was a suggestion that respondent number 1 would be more responsible than respondent number 3. I would suggest to the board, however, that the inclusion of some kind of language, whether it says backup or whether it's scribbled on the top of an offer or something like that, that was determined after a number of negotiations. So the backup situation was disclosed in the next communication between respondent number 1 and respondent number 3 once a contract had been entered into between the ultimate purchaser and the sellers. So I'm suggesting that there was no delay in non-disclosure, and I wanted to at least put forth the point that the disclosure of backup contract situation for the complainants and the sellers was discussed the day before any contract was entered into. My client obviously cannot discuss with the complainants. Had there been an opportunity, that certainly would have been disclosed upon the determination that there was a contract with superior timing. I don't know how to put it that way. I would respectfully ask this board to consider nothing more than a letter of warning, because as the respondent was not the draftee of the document that led to a backup contract, that information could have either been included in that counteroffer or offer by the complainants through their agent, or it could have been entirely withdrawn. I think the facts reflect that the complainants did not discover themselves a backup contract because their agent did not disclose to them timely. My client, at the first communication opportunity, made that clear.
Thank you, Mr. Ewing.
Was the backup nature of the contract included in the contract?
I don't know that backup was written anywhere in there because
or whatever, however you want to characterize that. I mean, that term that would have made it contingent on the other one falling through or whatever, was that anywhere in the contract or in any other document that we could say that is part of the contract?
Not to my knowledge. That was based on the communications from my client to the complainant's agent. And I would simply suggest that if that was unacceptable or needed to be included, it should have been either inserted or that offer withdrawn.
Did the contract have an integration clause in it? So that the other communications outside of the contract are not part of the contract?
And speak to whether that particular statement about prior communications, I'd have to go back and look at that.
Okay.
The kick-out clause and that first right of refusal language was obviously in the first actual contract between the ultimate purchaser and seller.
Mr. Bloom.
Yes, sir. Thank you for being here today. Let me understand, you're representing the seller's agent?
That's correct.
And that agent received an offer on the seller's property?
Yes.
And at that time, there was no other contract?
There were only offers at that time.
Okay, and so they picked the one that they ultimately sold, and I guess it had a contingency on the sale of these people's property.
The buyer had a sale contingency and also agreed to a first right of refusal with a 48-hour kick-out clause.
All right, and then the complainant introduced another contract.
They submitted an offer before the ultimate purchaser and the seller had entered an agreement. There was an overlap.
Oh.
So if I may, on a Friday, trying to get the exact date. On a Wednesday, there was an offer by the ultimate purchaser. On a Thursday, there was an offer by the complainants. On either Friday or Saturday morning, I can't remember the exact date, there was a contract between the seller and the ultimate purchaser. That that was disclosed to the agent for the complainant, that would have been acceptable and would have triggered that right of first refusal. At that point in that conversation, that is when my client disclosed that there actually was a contract, not just an offer, but a contract. And so I would suggest, I'm certainly not suggesting that anything be done with Respondent 3. I don't represent that individual. But I think it would be, one, unfair to punish one and not the other, but even more so, there was no opportunity other than disclosing that to the agent who made this offer, counter offer on behalf of the complainants, to put that language in about it being backup until that moment. And that's when it was disclosed.
Tails.
One, you said there was more than these two offers. Were there any other offers that were countered by the seller's agent at that time?
To be honest, I don't know that I have a document about, I know that there were two. I believe that there were discussions with other agents that did not precipitate into a written offer. My understanding is that there were two written offers. One, through negotiations, was accepted, obviously, before this backup contract was in place. And if I may point out, I understand this board's interest in protecting the public and the complainants. At no time were the complainants out money. They submitted an earnest check that was not accepted and returned to them. There was no action taken against them in this matter.
True, then
It
it
makes sense.
happens.
Yeah,
Yeah, it
that
happens.
Okay.
It's not fun.
So at the moment, the motion on the floor is to offer the same set of penalties to both Respondent 1 and Respondent 3. That's the motion on the floor. If there's not any more discussion about that motion, we'll vote on that motion.
Does he want to change his motion?
He's got the floor if you'd like to, but we'll see how the vote goes. I mean,
I change my motion just a
you
little
can
bit?
withdraw your motion, change it. You can
I would
amend
like
it.
to make the civil penalty, because this is fuzzy, $250 still for both number 1 and number 3. $250 and a 4-hour contracts class for each one of them.
Okay, that is it. The second was Mr. Bloom. Do you agree with that change?
I don't want to agree with that.
Okay,
fooey.
so is there somebody else that will second Mr. Wood's motion? Okay, Mr. Horn does. So that's on the floor at this point. All right, so motion is to assess a civil penalty of $250 to Respondent 1 and Respondent 3 and insist that each take a 4-hour contract class. That's what's in front of us. If you're in favor of that motion, you'll vote yes. If you're opposed, you'll vote no. We'll try a voice vote. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no.
No.
Chair votes no as well. Let's roll call it just to make sure.
Hey, John Grease,
Oh,
Rick Douglas, Gary Bloom,
No.
Diane Hills,
No.
Austin McMullen. Yes. Marsha Frank,
No.
Bobby Wood,
Yes.
Fontaine Taylor. Horn. So you have yeses and
So that motion fails. Now we're back to the original motion, which was to assess a civil penalty of $500 against Respondent 1, and I think there was a contracts class involved in that motion as well. Is that right, Mr. Bloom? 4 hours. 4-hour contract class.
I'd like to know, though, from State's Attorney, what is it that you think they violated? Number 1, Respondent 1.
I believe truly the only violation here was a technical violation in the fact that the face of the contract does not say it's a backup, the one entered between Respondent 3 and Respondent 1. I don't believe that there was any dishonest dealings in this case. I don't believe there's evidence to prove Respondent 3 was delayed if her belief in the contract was fair, because again, all of this happened in a short window of time. So on the face of it, I believe the only violation is technical in nature, and that is that backup language was not included in the purchase-sale agreement, but on the backup contract.
And Is it okay for her to tell me whether it was a TAR contract or not?
It is a model contract used by this firm. It very clearly looks like a TRA backup contract. Or
Okay,
contract.
so if it is, then that blank is not on that contract. They would have had to have written it in.
Yes, it has contingency and then a blank.
Okay, Ms. Hills.
So on the second one, that was the backup, was it countered by the seller or accepted by the seller with the original offer? Was it countered or accepted?
Original offer was countered at first. They negotiated a second counter offer. Before they agreed on it formally, it was disclosed that that would be the second contract, that there would be a backup. Then they accepted counter offer 2. Then Respondent 3's agent told complainants that what Respondent 1 said, which is that it's a backup. And then they entered into a purchase sale agreement. It seems that Respondent 3 either truly believed or at least told her clients that she didn't know if that contract was really binding because she wasn't sure both married couples had signed it. There was a move to amend that first contract at some point, so there is a possibility she might have been confused, but I don't believe the evidence fully supports that.
Let me be sure I have this. So on the one that did not get the house, so that number 3 wrote the offer. Then the Respondent 1's client countered it with a counter 1. And then number 3, that buyer that didn't get it did not accept counter 1 and made a counter offer 2. So you're saying in between 1 and 2, they already knew that there was a backup?
Between 1 and 2,
contingent.
yeah. Between 1 and 2, now the contract was formed with the original purchasers, and then the Respondent 3 was informed that that had happened. So between counteroffer 1 and 2 is when we got a contract with our purchasers who ultimately get the house, and when she disclosed.
And so then Respondent 3 went ahead and wrote a counteroffer 2.
That's correct, and it's on their firm's letterhead.
So they each touched the contract twice.
Yes, as far as the negotiation goes, they both have had access to that language. The ultimate purchase sale agreement that resulted from this was from Respondent 1's firm's letterhead, but however that came to be or what the agreement was on who would produce that, I honestly, I don't know.
Okay, I sense we're ready to vote. The motion on the floor is to assess a civil penalty of $500 against Respondent number 1 and require that licensee to take a 4-hour contract
I
course.
withdraw my second.
Or you could just vote no.
Or make a substitute motion.
Can I make a substitute
He said
motion?
make a substitute.
You can make a substitute motion.
Okay, I'd like to make a motion that Respondent 1 and Respondent 3 receive a letter in their file of reprimand for their handling of this transaction.
Is there a second to that?
I'll second that.
That's a substitute motion offered by Commissioner Bloom.
Got any education in that?
No, I think at this point, the motion is simply to insert or deliver a letter of reprimand, or is it warning, the proper terminology, warning, or what is the proper term?
I believe we can do either, but
Is there a different degree between the two? I don't care personally, but.
honestly, I'm not really sure because y'all haven't had me write one.
Okay, so it's,
Warning seems worse than reprimand, though.
is it a reprimand or a warning, Mr. Bloom?
Yes, sir.
Warning.
Okay, let's call it a letter of warning, just not to do it again, right?
That's
And then
fine.
that's your
That's
intent. Ms. Frank seconded that motion. Is there discussion on the motion?
It's concerning to me, regardless.
Speak into the microphone, please.
Concerning to me because, let's say, we hear that people did say this was so. Now, I'm not a court of law, but you also know that just because you said it doesn't make it true, you have to have it in writing. And to me, if I understood, if I were any agent on either side, and I understood it was a backup offer, whether I got it with it not written in or not, it's my duty, whichever side I'm on, to put that in there and see that it's in there for the best interests of my clients, whoever they might be. So that's my feeling.
Thank you, Ms. Taylor. Other comments or questions before we vote? All right, if you're in favor of the motion to issue or deliver a letter of warning to each participant number 1 and participant number 3, you'll vote yes. If you're opposed, you'll vote no. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no.
No.
Was that a no? Okay, we
And
have
a no.
six ayes, 2 noes. The motion passes. Ms. Page, is there anything else you want to bring in front of us today?
No, members of the commission, thank you as always for hearing us out, and we appreciate your time.
Thank you, gentlemen, for coming in. Mr. Young, I'd like for you to call the roll of the teleconference members.
Okay, do we have the others as well?
Let's get to 3.
Okay, the 3 that I'm checking on, Ms. Savage, Regina Savage, Regina Savage.
It was.
Okay, Gary Carrier. Wonder if it's working. Gary Carrier, are you on the line?
Anybody on?
Kevin Stafford, are you on the line? Brock Wagner? I don't think it's working. Hello.
It's working, but I don't think it's.
Carol Goodwin? All right,
Yes.
I got it. Who's this?
Howard Reagan.
Oh,
He's one that left at lunch. Dialed in.
all right, so Howard's the only one.
Carol Goodwin?
All right, anybody else on the line?
Gary Carrier is here.
All right, Carrier's here.
And Carol Goodwin?
Carol Goodwin.
Yes. Marquez Williams.
Okay,
Regina Savage.
thank you, Regina.
Why can't we hear him up here?
Brock Wagner.
Brock Wagner. Okay,
Kevin Stafford.
thank you, Kevin. Who's that?
Anithia Blackman.
All right. Anybody else?
Did you get her name?
It must be Marquis. Okay. Okay,
I don't think we got that girl before him though.
I don't either. There's one other person that registered with us, but we didn't quite understand your name. Okay.
Ask her license number.
All right. Okay, thank you. Chairman, would you like to proceed?
I would like to proceed.
Can they hear a meeting?
All right,
They can't hear a meeting.
that's what I was wondering.
So dismiss them. I mean, we got them sitting around, can't hear us. What good is that? I'll make a motion that we dismiss all of them that's on the phone. With credit for the meeting.
Okay, the
It's
motion,
our error.
motion on the floor offered by Ms. Frank, seconded by Mr. Horn, is that the teleconference participants be allowed to get off the teleconference and still get full credit for this meeting. Discussion? All in favor, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Ladies and gentlemen, we've got a lot to do yet. We're going to go to the topic under commission discussions, which is on the second page of the agenda. First up is education instructor training verification. Mr. White, tell us what you know about this topic. Get that microphone up there.
We had, thank you, we had discussed last time, just briefly, some ideas and some proposals to basically help our instructor training throughout the state. And so I proposed several items, and when last we left those, the commission was going to study that, and then we're back today. So basically about those training proposals, I think, you know, I can just take them one by one or go through them the way I see it, and then the commission can view it, or if you all have had a chance to look at it, or...
I mean, what number they're on
Yeah,
the
what
iPad?
number are we on the iPad?
They got
11?
reloaded.
We have September education report, and we have instructor background briefing.
Right.
That's all we have
This
on
is under
education.
education instructor training verification of confirming access. That language is not exactly true. I'm not sure, you know, what we're trying to do today is essentially adopt a train the trainer course. That's what we're talking about, and then to enhance the idea of giving training to instructors in Tennessee. Because of the fact now we have been accepting the manual and an affidavit online. We wanted to get beyond that. We wanted to encourage training in Tennessee for the instructors. So my view was that we would make or propose that a policy, and this would be in accordance with the statute and the rule, that there be a train the trainer course. Now, at present, we're accepting a train the trainer course, but the only one in Tennessee is that of TAR. And so we were going to, at least I was proposing to open that up to others, to get out the word that other providers could provide that training, and if the commission so rules. Now, you know, I don't know why, you know, I'm assuming this was on last month's, it's not on this month's, but that was the basic proposal.
Let me also provide a clarification. The rationale for bringing this to your attention a couple of months ago was that the training, to qualify for training, an instructor could go online, they could go to the training document on the education part of the TREC website, they could scroll down to the bottom, they could check that they had completed the training online, and that would suffice for their training to be an instructor in Tennessee. So that was the whole purpose of bringing this to your attention, and for Ross to do the research. And just reviewing some of the proposals, I can see potentially some kind of, you know, training course, whether it be online or live, it minimally every 4 years. And but the whole reason it came to your attention was to eliminate the situation online.
So how time sensitive is this topic?
Well, you could defer it another month.
The only reason I ask is apparently we've not received anything in writing.
Well, you had it
We did
last month.
But we don't have it.
Yeah.
We don't have it in front of us this month. Is it a simple recommendation or is it a complicated recommendation you have, Mr. Moore?
He had several recommendations.
I have several recommendations, but I think it's fairly straightforward. I don't think it would be that difficult, but however we could continue it, it's not something that is pressing, but it's something we want to do in the future.
I think it's something that we didn't get it in our documents for this month. And so maybe we need that to look it over and think about. I still have mine saved from the month before, but I don't remember if that was in our legal documents or not.
I will say this, what Ross had prepared, it did not change the rule, because basically the rule is that effective January 1st, 1995, has completed a Tennessee Real Estate Commission approved course in instructor training.
That's correct.
So that, I mean, whatever you do, obviously it's not going to change that rule. Now, my recommendation to you would be to definitely eliminate the online training doc that they can certify that they've been trained.
Because anybody could take that for
Right,
them.
and I think the decision of the commission has to be if you feel like that the instructors should have live training, or if they should take it online. I guess basically the pros and cons of that would be you also have to look at what would qualify an out-of-state instructor, because I think you also have to look at that as part of your deliberations.
And that's one of my proposals as well. And also, I guess underlying all of this is to improve the education and the delivery of that education from instructors who heretofore we haven't really looked at their ability to teach. And that's really important as we consider these proposals.
Later this month, I'll be attending Arello, and I've been asked to moderate. It's called the Commissioners Roundtable, and it's where all the commissioners from across the United States get in this giant room in this big round table, and we discuss what's happening in their state, and how they are handling those matters. It might be a good thing for me to be able to, because I'm coming up with a list of things in case nobody's talking, that I can get everyone on a subject. This might be a good subject for us to look at what's going on nationwide, and then I could come back at the October meeting and let you know what I've learned. I also think that I would hate for us to take a vote on it without us sitting here with it. So I would make a motion that we defer until the next meeting.
Motion by Ms. Frank, second by Mr. McMullen. This topic be deferred to the October meeting.
And
Yes.
Mallory and Malcolm are both going too? Y'all going?
They'll listen as well.
Bobby and Fontaine.
They'll listen as well. Let us know
Arello
how.
Oh,
and go to
Let
that
us know how
round
Marcia does moderating that big round table.
I won't need a microphone, will I?
No. All right, let's vote on the motion to defer for 30 days. If you're in favor, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Okay, next up, the Malcolm, you want to give some information about 2017 travel schedule and locations?
The travel schedule has been approved. Now, the 2017 off-site commission meeting locations, y'all asked to defer until this meeting, and I want to thank Chairman Grease for doing his research, and I want to thank Gary Bloom for doing his research. Gary did do research and recommended that we go to Collierville City Hall. Am I confirming that correct?
Yes, sir.
Mr. Bloom?
I wouldn't call it research. I think he twisted an arm or two and got that taken care of.
And for the chairman, I know that he did some research with Chattanooga and put us in touch with actually it's the county and not the city. What is it, Hampstead?
Hamilton County.
Yeah,
Courthouse.
Hamilton County. We would be using their facilities in Chattanooga. And at this point, once you sign off on those two locations, then Brooke and I will do research on hotels according to state rates in both those communities and get those secured.
Is Collierville where we went before?
No, we were in Bartlett before.
In the Chattanooga, is that the same place we went in Chattanooga? Okay.
All right, just so the staff will feel comfortable, is there a motion that those accommodations and locations be approved?
Motion to approve.
Ms. Taylor makes a motion, Ms. Hill seconds. Any discussion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Next up, we've got a discussion topic about single-family rental. Mr. Young.
Under the, do you want to do
I'm
clarification
sorry.
and deposit
I'm sorry.
of
Excuse me.
earnest money?
Excuse me, yes. Clarification of deposit of earnest money.
Okay, and I'll tee this up and then I'm going to hand it off to Bowery. And I will say again, we've now done 68 outreaches. If nothing else, we got tremendous input, and some of those questions and debates have created the list before you today. And one of that is the clarification deposit of earnest money as far as number of days to deposit. And I'm going to hand that off to Ms. Kirby.
Yeah, so this came up in a Q&A, and it was something that I couldn't answer because I think it needs to come from the commission. And it was, specifically in standard TAR contracts, but across the board, really. It says, when the earnest money should be received by the whoever's holding it, usually the other agent. And the question is, when does it have to be deposited once it's received? So the rule that we have is 1260-02-.0911, which reads, trust money shall be deposited into an escrow or trustee account promptly upon acceptance of the offer, unless the offer contains a statement such as trust money to be deposited by. And I did look up a TAR contract, and below that section where it says when you have to, hand it over to the holder, below that it does say shall be deposited by, but I believe it's also very general. I think it says like within a reasonable time or something like that. So it's also not specific. So I guess what's in the contract is not that's not something the commission needs to necessarily discuss, but it would be, if the commission wants to determine a certain time period to interpret this rule about being deposited promptly upon acceptance, or if you don't think that it's appropriate to set put out a number, then that's fine too. It's just a question we got and couldn't answer on our own.
Sales.
So promptly, if it is left at promptly, then a purchase and sale agreement that has so many days trumps the promptly, correct? Or
Right.
not?
If the contract specifies, then this rule would, because it says unless the offer contains a statement such as trust money to be deposited by. So if there's a specific number there, then the contract
And then
will govern.
we write an offer on Friday, and it gets worked out Friday even after office closes, and we determine something right now that it's 2 days, and that agent leaves it blank, it won't get deposited
And then Monday's
on
Labor
Sunday.
Day.
Yeah, it just.
That's why I was asking Ahmad this morning, specific how many business days?
I always think, because of weekends, that 3 or more.
In case there's a Monday holiday.
Also, Bobby was in the outreach when we had that active discussion too.
I think the contract that a lot of us will use, I think it says you have to deliver the earnest money basically to whoever's going to hold it within a certain number of days. I don't think it says it has to be deposited within that time. And then that was the question, and then where the discussion came upon, because in that same meeting, there was a broker that said, well, we got audited, and the auditor was looking at, it said 5 days, and so his interpretation was it should be in the bank in 5 days.
Not 5 business days.
Well, even though the contract said it had to be in the person's hand, that the auditor was interpreting it as it should be in the bank as soon as it gets in your hand. So, and again, everybody's just trying to look for a clarification. I don't think anybody's trying to skirt the rules. We just want to know what the rules are, you know.
And we make the rules, and we don't know the rule.
Yeah.
Why don't we leave the rules like they are? You got to do it as quick as possible, or you put in a number.
And you got to remember that 12,000 licensees in this state are not members of TAR or any board, so they don't have access to TAR contracts.
Right, which is why we really just need to look at the rule here in our rules that talk about this, which is the one, number 11 that I read, which isn't super clear about what that means, but doesn't necessarily mean the commission has to set a number either. So
What was the word that used soon, or what is immediately? Or
trust money shall be deposited into an escrow or trustee account promptly upon acceptance of the offer, unless the offer
Promptly
contains a
means
statement
nothing.
such as.
Yeah, promptly is.
That's what the brokers were asking. How long is promptly?
Define it.
Yeah.
And that's why I was wanting to know from Ahmad what is promptly to him.
Well, and the brokers at the Q&A, I think we're specifically asking about the TAR contract, which the commission can't really opine on that. But if there's no specified date, then this rule would probably come into play.
Change the rules to say within 3 business days of acceptance
Of a binding offer?
or binding offer or something.
And,
Other
but it's
contracts
got to go
will
through
say
the whole
30
process.
days.
Yeah, but you may not have the money. You may not have the earnest money until 4 days after the binding contract.
Within
I'm
4
okay with
days
promptly.
after receipt or something like that.
I think it's going to be
Okay,
based
all
on
right,
all of the relevant circumstances. And I mean, as soon as you put 3 days in there, you're going to file a complaint against somebody for doing it 4 days, and they're going to come in with some really good explanation
They had to
about
go to
why it took them
emergency
4
room or
days.
something.
And so,
Or you could write in the offer, earnest money not to be deposited for a blank number of days. And then that just really blows yourself up here.
So,
Stated check.
so legal is looking for guidance. Does anybody want to change anything, offer guidance, or leave it like it is?
Even though I've never liked promptly, I guess I like promptly. And the purchase and sale
Like
should
prominent.
tell the story. Tell the story or the instruction manual. The purchase and sale should be the one then that tells the
And
story.
it should be a broker decision, don't you think, at the end of the day?
I have a little machine that connects to my computer that goes to the bank, and we can put them in there the minute they come in. But if it's on Friday and it doesn't come in until Tuesday, I can't put it through that little thing that takes it straight to the bank without me even getting in my car. So I think we're better off saying promptly than trying to put any amount of days. We had, the auditor this morning, we kind of don't know what his thoughts are.
I mean, I think
we're better off.
that's fine. I think probably the solution is just to advise the auditor that if they don't have it deposited on the day that it says it should be received, that's not necessarily a problem.
It's kind of like promptly is the same as, is my house clean or is your house clean? We may have two different ideas of what clean is. Promptly is the same way.
Thank you for that analogy.
Eloquent.
Eloquent, that's eloquent. All right.
you thought it was eloquent. Maybe I didn't. I don't know.
Yeah. How's your house, though? I mean, is it
Not
clean?
clean.
All right, I sense there's no Mr. Horn.
Yeah, I'm sitting here listening to this. We seem to have that problem all over the place. But I think 5 working days, 5 business days, would give everybody adequate time on any given situation. And that's just me. And I'm thinking if I would get something that say, you got to do this within 3 business days, then I would count like everybody else. Anything can happen. But 5 days, come on, if you really try to do it, you can do it within 5 working days.
We have buyers from out of state, and when they travel, just like when I come here, I take my checkbook out. It's one of the things I leave at home. I don't travel with it here because I'm not going to be writing a check in Nashville. And we have buyers that do the same thing. They don't come with their checkbook. Now, we're not able to handle debit cards or credit cards at our office. It's just checks. So it could be that they travel back to California and they may stop at Disney on the way, and we put in there that it may be 12 days or it may be 10 days.
It's according
That's
to the
the-
circumstances.
Yes.
And I would almost-
promptly is not enforceable anyhow. I mean, if you were in court fighting over what was promptly, that's not enforceable. Is that word
I know.
enforceable, you think?
And I would almost think in today's market, out
Situation.
as quick pace, just like the conversation we had here earlier, 5 days to me in today's market is too long. So, and again, where is the magic number? I think that's why we want to stay with promptly and go on. So.
Okay,
Leave it to principal brokers to decide what they want to do per office.
done with that topic. Okay, let's move on. Thank you. Next up, what I was trying to get to, single-family rental, can an unlicensed person unlock the door? That's come up.
Back to our outreaches. This also became a topic at one of our outreaches. So the question back to the commission, which we couldn't answer, is if you have a single-family residential rental, the question came up, can an unlicensed person unlock the door?
Where is that in our,
So, the two things that to look at when thinking about this is under 6213-104E, sorry, A1E, is the exception for a resident manager, for a broker or owner, or an employee of a broker who manages an apartment building, duplex, or residential complex where the person's duties are limited to supervision, exhibition of rental units, leasing or collection of security deposits, and rentals from the property. So that one, is pretty clear about if this unlicensed person is doing an exhibition of rental units, then they don't need a license for that if it's an apartment building, duplex, or residential complex. But the question came up is, what about single-family homes? Does them just unlocking the door for somebody to go in and look at it fall under the definition of broker?
Mr. Bloom.
Yes, on our website, it says an unlicensed agent may unlock property under the direction of a licensee.
Right, and that's what the people that were asking the question were referring to, but those frequently asked questions aren't the law, so that it needs to be
But that's
looked
a
at.
confusing direction if we're telling them one thing one place and then we have a statute that says something else.
Right, I mean, the frequently asked questions are currently not on the website right now. Because they need to be looked at again, so.
So, is a lockbox an unlicensed person, or a key hidden under a mat an unlicensed person?
If it's at the direction of the licensee.
I mean, we're just trying to get access to people into
we can give it
property.
to the inspector, or we can give it to the bug man, or?
So the question is, in front of this commission, do you think that a person who opens the door to let a tenant view a building or an apartment need to have a license?
Or for a sale. I mean, the question is for
sale as well?
I think the question would apply to all of them, to
Okay.
all of it.
Don't use a key card, because they can't use anybody's key card. So that brings in a whole new thing. They can give them a one-day code or.
What's the statute? 104 what?
But that's only
104
for the people who use.
A1E.
Right, you can't let
There's a
anybody your
lot
key
of
card.
still, what do you call them? I hate those kind of locks.
I guess the question would be,
Combos.
does that rise to the, to fall under the definition as an attempt to solicit a listing, sale, purchase, exchange, or lease?
If they don't open their mouth and all they're doing is unlocking a door, I don't see how that could be. But that's the
I would
key
agree.
thing. You'd have to have somebody that's not going to talk to them and tell them, can't talk to them.
So it could even be for a repair.
Right.
So, we're just trying to get the sense of commission here. If, in the scenario that's described, does that person who opens the door need to have a license, real estate license?
And they don't for apartments or anything else?
Right.
Then why should they on this?
We're trying to get to someplace. Mr. Bloom?
Well, I just think that the situation that Mallory described is kind of the mindset we've always had. If there's an agent on site, like for a large apartment complex, you can do those things. But for a unlicensed real estate agent, you could not. But then someone brought this question up to her because it is in our handbook. It says that you can do that.
But you could send at an apartment building the maintenance man over there to unlock it, according to this, or your husband.
I think the way the statute works is that the first question is, does it fit under the definition of a broker under 102.4? And then there are exceptions under 104, like the one you were talking about. So this doesn't look like it fits within the exception, but the first question is, does it fit under the conduct of a broker under 102.4? And I don't think that unlocking the door is soliciting, negotiating, or attempting to solicit or negotiate a listing, sale, purchase, exchange, lease, or option to buy, sell, or rent, or exchange real estate. So
I would agree with that.
I'm just looking for a motion that we can vote on.
Do we need
a motion? Well, I think legal would like an action by this commission if we're willing to take it.
What does legal think?
Well, I think I tend to agree that if it's just opening the door and no explaining to them about the property or anything like that, then I don't think it falls within the definition of broker. Now, if they start to offer information about the property and kind of try to encourage the person to rent or buy I think then you kind of cross
Or
into
even
another
show it
line
to them.
there.
Yeah.
Right. But I think if they're just opening the door, I don't think that would fall under the definition of broker.
So the motion might be that the simple act of opening the door does not necessarily meet the requirements of the Broker Act.
I make that motion.
second.
All right, we have a motion by Ms. Frank, seconded by Mr. Wood. Wasn't my motion. I haven't made a motion in 2 years.
I know.
You've heard the motion. If you agree with that motion, you'll vote in the positive. If you disagree, you'll vote in the negative. Is there discussion on the motion? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Hopefully that's helpful, Ms. Kirby.
Be here. No, I'm kidding.
Next up is a discussion of advertising rules and statutes.
Review and vote informal applicant.
No, I took that off, but I shouldn't have, right? Yeah. Review and vote informal applicant process rulemaking filing.
Okay, this is number, I believe, 21 through 25 on your iPads. Let me make sure that's correct. Yes, 21 through 25. Sorry, 22 through 25. Those four. This is so last month you voted on the language for the informal applicant process rule. And these are the remaining documents that have to be submitted with that rulemaking file. The only thing I will point out that I've added to the language that wasn't on there last month is in the very last sentence. On Part C, I added the applicant shall ensure the presence of his or her principal broker or intended principal broker in accordance with 10 Comp Rules and Regs 1260-01-.19. So I just made a reference to our rule that requires the principal broker to come, so there's no confusion there. But that's the only change. And the rest of it is the usual documents that you see with rulemaking proposals. And we'll need to take a roll call vote unless there are any questions or unless you have anything you want to revise to these documents.
Can we combine these into one vote, or you need each?
You can do it in one vote. I think it's fine.
So items 22 through, for instance, 25.
Yes, 22 through 25.
Proper motion would be accept the language found in these items.
Motion to accept 22 through 25 as written.
Motion offered by Ms. Hill, seconded by Ms. Taylor, that 22 through 25 be adopted as presented. Is there discussion? If not, Mr. Young, will you call the roll for the vote? If you're in favor, you'll vote yes. If you're opposed, you'll vote no.
John Grease.
Yes.
Rick Douglas. Gary Bloom.
Yes.
Diane Hills.
Yes.
Austin McMullen. Marcia Franks.
Yes.
Bobby Wood.
Yes.
Fontaine Taylor. Johnny Horn.
Yes.
That motion
Passes.
passes unanimously. Anything else on that topic?
Oh.
Thank you, Ms. Kirby.
Thank you.
Now, discussion of advertising rules and statutes. Anybody want to lead this discussion? Mr. Young?
Actually, Austin and I have kind of gone back and forth. Basically, we looked at ways that maybe we could change the advertising rules. I think the one that is probably very clear that I would probably ask the commission to look at, and it also is supportive of a request that came from Real Tracks as well, and it has to do with today's social media issues, or social media, I guess you'd call it ramping up. The use of firm phone number when people are communicating by email and other means, that potentially we may want to consider dropping the firm phone number. But then again, as you discussed today, you may want us to look at other areas as far as the advertising, to maybe come back with some potential recommendations. So I just thought I'd kind of tee up probably the largest thing that I've seen as far as any kind of request as far as changes to advertising.
I don't want to take a lot of time because I had hoped we'd be having this conversation 3.5 hours ago. So, but I will just briefly say that, you know, I've been on this commission for 5 years, and I came on as a public member, and I knew very little about this industry. So my perspective was always one of, I thought my main goal is to make sure we're protecting the public. And a lot of the details about how do real estate firms work and a lot of that stuff, I didn't know that well, and I thought that was probably a little outside of maybe what my function was in being here. But having now been on here for 5 years, I feel like I have learned some about the industry, and now I think take a greater interest in some of the things that do affect the firms and the licensees. And I think that with respect to this advertising rule, as I've looked at it more, I think that there is a real question in my mind how much of it is really protecting the public beyond the protections that are already built into the statute. You know, I think we had a broker here today who said, if somebody wants to find me, they've never had trouble finding me. And you know, I understood maybe this was here to make sure that, you know, principal brokers aren't getting cut out of the loop. We don't have these rogue affiliates that are out there, or that if somebody's going to file a complaint, that they know who to file it against and stuff like that. But I really think we need to take another look at the advertising rules and eliminate areas that are duplicative of what's already in a statute. I mean, we can't change what's in the statute. And so if we're duplicative in a rule, then I think the rule ought to go. I mean, let the statute say what it's going to say. We don't need to have a rule on it. And again, with respect to the rules, if it's something that is not actually doing something more to protect the public, then what's the point of having it? It seems like there should be very few instances in which we have an advertising violation. I mean, the violations that we ought to be looking for are some of the other things that we hear where people are doing dishonest things and stuff like that, and we ought to go hard after those. But advertising, unless you're making a false claim or something like that in your advertising, I don't see that a lot of these regulations are really protecting the public, and I think they're just imposing more requirements on firms and on licensees that really don't protect the public. That's a very general statement. I mean, we could go through the rule, you know, point by point, and I'm sure there are some things that are worth keeping, but I think that there's a lot of it that probably needs to go.
unfortunately, it's already 2:45 or so, so it's late in the day to start doing that kind of analysis.
But you're local.
But well, yeah, I mean, I'm just respectful of Ms. Hills, though, or actually Chairman Grease, who probably needs more time to get home than Ms. Hills does. But I would really like to see us do that. As I said, this afternoon may be late in the day to do that, but certainly I think there's a lot of that needs to be reexamined, and I think we have to be mindful, as I said last month, of the atmosphere in which we're operating, and in the legislative and the regulatory and the administrative atmosphere is one in which we want to try to encourage business growth and job growth, and we want to eliminate regulations that hamper job growth without a significant corresponding benefit to the public. If we're protecting the public and we can see a real clear connection between the rule and protecting the public, then let's do it. But if there's a very loose or no real protection of the public and we're just putting an additional regulation on business, that's something we want to steer clear of.
I also want to follow up your comments, Austin, because as we started this discussion in the interim, one of the questions asked of Mallory was how many advertising complaints that we've received came from consumers, and the answer was 0. I think that's, that backs up, and it's significant of the statement that you just made.
Yeah, that's a great point. I mean, if we're protecting the public, then we're responding to complaints that are filed by the public. But if this is a situation where one licensee is trying to use the rule just to get a leg up on another licensee or to have kind of a turf battle, that's something that I think we want to try to stay away from. And so if it's a rule that the public never complains about, then maybe the rule isn't really doing much to protect the public.
I think what I hear a lot is like specifically things like Twitter. If you go by our rules, and by the time you put your name, your company, your office phone number, the tweet is pretty much useless with the number of characters. So if we really just want to start putting civil penalties on it, get everybody who's on Twitter, I don't think that's our purpose. But I think if we're not going to follow through on our rules, then let's change that rule. And that's one of them specifically. I'm not ready to do it today. I'm hoping a place like Arillo, somebody's already got this figured out. We can copy it from somewhere.
Yeah, I've heard the exact same point that you're making, and with the as fast as houses are going now, I mean, people are putting them on Twitter, and people are looking on Twitter constantly. But I mean, if our rule basically makes it impossible to use Twitter in a way that complies with the rule, then we may not have such a great rule.
Twitter today, and it's something else tomorrow.
Yeah.
Well, I'd like to make a motion
Please do.
that we defer this until next month, so that we can all really take time to look at each of these advertising rules and see if there are things that are antiquated, or even if there's something missing. I think for most of us, we like following the rules, and sometimes it's because we've just always done it that way. So maybe we really need to take, have new eyes and look at it to see we really need to keep this one not so much, and then come back next month and discuss it better.
I think one other thing maybe to keep in mind as you're thinking about these things is there, when you're looking at a specific rule, like, is there specific proof that this rule protects the public? Not just, do I think that it protects the public? Is it logical that it protects the public? But do we actually have proof that it protects the public? Do we have proof that that there was harm, and so the rule was needed? I think that's something that just to keep in mind as you're thinking about, which rules are necessary and which aren't.
And look at it from the public's eye.
The other thing I would say is that, if you're a member of the Real Estate Commission as a licensee, then you probably are one of the best real estate licensees in the state of Tennessee. Somebody who's sloppy doesn't get appointed to the Real Estate Commission. Okay. Now, as a licensee who's sitting here, I think you're tempted to say, well, I think that this is the best practice. And you're tempted, I think, to put that in as the rule, which sets the floor for how everybody in the whole state has to operate. Now, I'm a lawyer, so I'm a rule follower and a rule reader too. And so, I'm about what's the safest, what's going to protect my client, what's going to protect my firm. But I have to recognize that there are people who can operate at a lower level maybe than I would, but it would still be acceptable. And so I think we need to think about these rules in the context of not setting out the highest possible standard that we consider to be the best practice, but instead as setting the level that is acceptable for everybody in the state, considering that there are tens of thousands of licensees out there. That's a different mindset, I think, and it can be difficult to do. I mean, we certainly want to protect the public, but is there a way to protect the public without setting the bar so high that we're imposing an unsubstantiated burden on businesses without protecting the public in a corresponding way?
Ms. Taylor.
I was wondering if there might not be a way in some of these things that we're looking at to have input from other agents and even the public. Maybe have a 90-day period or something to talk, we could put it in a bulletin, or I don't know how the word would get out, to have input from what they think is important or not important. Then we'd have to, of course, glean it and then see how that falls with and we might have some really good ideas, and we might then decide that nobody's worried about anything or what the worries are. Would something like that?
That typically comes at the rulemaking hearings, and but that's typically at the end by the time we've drawn it up.
But you on your road show, you've come back with questions and you've gotten information.
That's where some of these things came from today.
Right.
It's
And
not
so-
just good for them, it's good for us.
Right,
that you're
and
doing
so
it.
in reading that, no, it was on the agenda, that was one of the reasons I wanted to hear from some different brokers that came here today. Well, I mean, we had the perfect little audience here, and especially the last gentleman. But so I would like that. I agree that there are many things, just like it may be that we don't have licensees work under brokers. Maybe the public deserves every person to be a broker and to have single licensing. I mean, it could go all sorts of directions. But with the advertising, now that licensees have practiced it and now that brokers have been supervising it, I would like 90 days or something, and come up with some way to hear. All are hearing it on the road show, so that is a perfect example. But if we can come up without a public hearing, official public hearing, to come up with it, I don't know, questionnaire. We don't have email database, but.
Oh, and we can talk to the administration and kind of ask them what some options might be for getting feedback from the public. I mean, I'm not sure.
I think we can do it through Verify.
Well, let me say
Through
something
Notify,
about the
yeah.
public.
I mean, there may be some options of ways we can do that, but Malcolm and I can look into that for next time.
In saying about the public doesn't even understand really what a real estate
Right.
agent
I guess
is
I
or
meant
what they do,
licensees,
period.
yeah.
But I think that we should at least give other agents the input to see what is really bothersome and not. Like I say, the public doesn't really understand what we do and how we do it.
Right, yes. I guess I should have said licensees.
Instead
Yeah.
of something
So,
of value.
I made a motion that we defer till next month. Do I need to amend that for further out than 1 month then, or? Do we even need a motion?
Well, I think what Ms. Taylor is saying is that Mr. McMullen's comments may all be well and good and valid, but it would be good to hear
Point of view.
if all of a sudden we get comments from a bunch of licensees that say, Twitter, man, that's a big deal. And I don't know why we have to put each company independently owned and operated under a franchise. That gives us good direction to go. On the other hand, if they say, It's okay if the company's name is the same size as the agent's name. If we get that kind of stuff, that would be helpful to me as well. So I don't know how, so the question is, if this commission is on board with soliciting some input before we make decisions, what's the best way to solicit that input? And if you, is it,
We'll look into that.
We have a vehicle called Notify.
you know, I never get anything from that ever.
Have you signed up for it?
Yeah, of course I have.
But
Of course, yes.
well, the thing that I would say that you all say that a lot of these things never come before the commission. Well, they come before. Talk about, well, and now don't talk, well, I have a lot of people at the office that say, what are you gonna do about somebody's sign? I said, it's not up to me to do so about somebody's sign. I said, if it bothers you, go take a picture and send it in. I mean, there's a lot of that, but they don't take it to you. And it's about, and I'll just bring up, it's about teams. There's a lot of stuff that comes out about teams a lot. But it doesn't seem to come here. It seems to be people on the street and other agents that discuss these things. So I don't think we're really getting the whole picture unless we ask.
I mean, and we are getting advertising complaints now, especially they've kind of picked up. But all the ones I've seen so far, and Rihanna's looked at more of them than I have that we haven't presented to y'all yet, but they're all from other agents. I still don't think we've gotten any from consumers, have we?
I don't
So-
think consumers know what the rules
know who
are,
to
so why
report
would they
to.
know? They just wouldn't know.
To me, that just shows the public is not being harmed if they're not complaining. Instead, it's just tattletale between one agent and another. But I would like to see us get feedback, and I'd like to see us go through a process and try to cull some of these rules out. But I also think it's important that we take action on this before the end of the year. And so that would be my goal, is to have us take some sort of action on this before the end of the year.
And to just talk a little bit more about what you're saying, Ms. Taylor, you're right in that the consumers aren't going to know the advertising rules, so they can't put in a complaint that says this person's violating this advertising rule, but they could complain about the result of what the thing is supposed to protect. So like if they didn't know who the principal broker was and they needed to contact the principal broker, you know, they could file a complaint saying I had a problem and I didn't know who to contact as the manager, but we don't get those either. So
Or I looked up the team's name and I can't find them in the phone book.
right, yeah.
But I do think that we have to be ahead of the curve as far as innovation and technology. And I think it's very harmful to licensees that if we're changing the rules all the time, and it all depends on who's sitting up here on this commission, and they're having to pay for new signs and things. So I agree with Mr. McMillan that I think we need to do something for the end of the year. So, I mean, it's September now. So I would like to defer until next month, and you all get us what information you can. Let's talk to as many people as we can, at least get the ball rolling.
I agree, but I think next month would probably be more of a plan with information that comes from you, how we could do
Just so
certain
that we could
things
at
and
least
stuff.
discuss it better next
Right.
month.
Right.
You also have an opportunity, since you're traveling out, and you may have an audience, you know, on a distant
Thanks.
road,
Mhm.
is you actually do some kind of town hall platform in the middle of your commission meeting and advertise it. It's a possibility.
Or it may not be possible, depending on who's running the meeting. Last
Well,
time-
you are the chairman.
I remember opening the floor in Bartlett, and all kinds of stuff
Don't ever
happened.
do that again.
Gosh, yeah, that was scary.
That's scary.
You kind of had that down the road this year, too.
So, will you guys commit to trying to figure out how we can analyze what,
Get feedback
us
from
feedback
licensees.
from,
Mhm.
And we're also going to add that to Marcia's list.
And the administration too. We want to know what they think too,
And the legislature.
and the legislature.
all right, next month, we'll put it back on the agenda. Is that
Okay.
okay? Thank you, Marcia. Okay, teams, anything anybody wants to bring up today that we haven't already talked about? If not, we're just going to keep that on the agenda. move it forward
I
next
was
month.
hoping to do sort of the same thing,
Okay.
ask the same questions.
Right.
Ask questions about,
If we get feedback on what
Right,
people,
right.
the good and the
Mhm.
bad about what we say about teams.
exactly,
Okay,
advertising and all.
okay.
The,
Mr. McMullen, you put an item on the agenda regarding litigation, pending litigation.
There's a case, was it Lindahl?
Yes.
And the current penalty that is on appeal is $2,000 civil penalty and downgrade from principal broker to affiliate, correct?
Yes.
I make a motion that we offer the respondent the option of a consent order for a $2,000 civil penalty in order to resolve the pending appeal.
I'll second that.
A motion by Mr. McMullen, seconded by Ms. Franks, that if passed, would have the effect of keeping everything intact except for the downgrade of the license.
Now we can talk.
Now, open for discussion. Ms. Taylor.
the case was heard some time ago, I will say that. It's in the last, 4 months or something like that time
I
frame?
believe it was April,
April, all right.
March or April.
Well, and having heard it in April and coming here today, you might lose some things. But as I recall, he did not show up. It was a telephone conversation. He did not have his information together even on the telephone conversation. Had not sent his paperwork, all the paperwork in necessary for the conversation. And we had to stop several times to send him things so that he wouldn't come here. It also, I think the thing was that his secretary or something was sending letters out and saying what the
Had a staff person, I think, that was
staff
negotiating
person
the
that was
contract is what we come up with.
Yes, giving terms of the negotiation to other people. I also do remember that he was a broker in, I believe, 25 states. All of that being said, and putting that whole picture together, and this went on for several hours. My interpretation at the end of that was that his license should be downgraded.
Let me just
along with
let
the
me just remind the commission that the only thing that should be considered in the decision is the facts on which the complaint was filed. The fact that he appeared via teleconference, the commission voted to accept that. That's his option, and you all agreed to accept it. That
All
can't
right.
be held against him.
All right.
And the procedural stuff, that really shouldn't be even taken into account. The decision should be made on the substance of the complaint. And even the fact that he's a broker in 22 states or whatever it is, that really isn't a matter, that isn't part of the complaint either.
Because that's legal.
Yeah, I mean, he's legally able to be a broker in 22
What was
states.
the complaint?
The complaint was the emails that were sent by the assistants.
She was offering, she sent
She sent a
contract.
counteroffer. She sent a counteroffer on
Who filed a complaint?
another agent on the other side of the transaction.
And that was the complaint?
Yes.
That unlicensed person negotiated?
Right.
I think it's very significant that the state has brought this to us, I don't know, 3 or 4 times, wanting us to settle. I think it was my motion that we downgrade this licensee in the first place. I don't know everything that legal has or what they've heard or any of this, but I do give it credence that on all these occasions that they've come to us wanting to just have the civil fine. And I know we can decide to do whatever we want to do on it, but I do give significance to that's out there. For some reason, they keep coming back saying we need to settle. I don't like have a lawyer. But when I pay the money to have a lawyer, I tend to listen to them. Just like a doctor, if a doctor says, you know, you need chemo, I'm going to go get chemo. So I just have this in my mind about there's something significant here of this happening on multiple occasions that they've come to us and asked us to do this. So I do give credence in that.
I think to be fair to legal, I don't think they asked us to do this. They just they updated us. Now, there might have been an implication you drew from the conversation.
Okay.
But I wouldn't want to say that we had a recommendation. It was an update is how I prefer to.
But it's the only one that keeps getting updated because it's the only one in Chancery Court.
Right, that's the only thing you have pending in litigation right now.
And we keep getting asked that I think it would be settled without the downgrade of the license. So I tend to interpret it the same way you do.
We just have a
Commissioner
duty to, if there's a settlement offered on the other side, to present it to you. So, you know, it's up to the commission to accept it or not, but we have to, you know, pass along the information that we're given.
I just want to say this about Fontaine, circle back to Fontaine's comment about the broker and how you pointed out about the broker. I really don't think Fontaine was pointing to the fact because this person has license in a lot of states, that's the reason the vote went the way it was. I think her point is, and I would agree with her point, is he didn't do a very good defense. That was the whole problem, and it really had nothing to do with that he called in, but he wasn't prepared, and he got defeated, and that's why we're here. So that would be, I'm not trying to talk for you, but I don't think it has nothing to do with the fact that the broker's out of state is why we're having this discussion. It's just the fact that was his defense. Well, I have a lot of licenses, and that probably wasn't a good defense. But I'm ready to vote on this thing.
Would you like to make a motion?
I think we already did.
Oh, okay.
The motion on the floor is to, if the settlement's still on the table, accept the settlement offered by the respondent, and that would be to stick with the civil penalty previously offered, but to remove the downgrade that was previously agreed to, not agreed to, but offered by this commission.
And who made that motion? Okay.
And you seconded it, I think.
Yes. Okay.
All right, are you ready to vote?
Could you tell me his name again?
Oh.
Spencer Lindahl.
Okay, if you're in favor of Mr. McMullen's motion, which would effectively remove the downgrade from the previous sanction, you'll vote yes. If you're opposed to that motion, you'll vote no. Are you ready to vote? Let's do it. Those in favor of the motion vote yes.
Yes.
Those opposed, no. That motion passes on a 7-aye.
Mr. Chairman, I'm going to recuse myself. I wasn't here in April.
Okay, so I've got 6 ayes, 1 no, and 1 recusal. All right. Before we take a break, Ms. Hill, at this point, had asked that she and the commission become clear on what it will take to satisfy this meeting requirement. Is that still a question mark in your head?
Yes, since we had to excuse the people on the phone, and we still may have people that decided to stay. I need to have an understanding of the plan.
The goal, as I heard earlier, was that this will never be an issue again, right?
Well, I can't say for sure because I don't
But
know
that's the goal.
when it's going to get signed, the emergency rule. But my guess would be that it would be before the next meeting.
Can we address that so that it doesn't happen again?
Well, until the rule passes, we'd have to do it on a case-by-case basis or meeting-by-meeting basis is our issue. So,
But if we don't agree for them to do it, and because, I mean, we had people who drove here from Johnson City today, there's no way of knowing did everybody get contacted or not. Then we put them on the phone, and that, that doesn't work. So, I mean, I just don't see the point of doing it. I would just, and I know they're wanting to do it so that they can get their licenses reinstated quickly. Is there any other thing that we can do?
And there really isn't. The only thing that the commission voted on during the emergency meeting was that they're not going to be disciplined if they go ahead and keep practicing real estate on an expired license. If this is if they're attending the meeting is the only thing holding them back from reinstating.
So why do we need them to call in or?
So their license would not be expired. So
Yes.
that,
Show up.
that gives
Yeah.
them
Right.
attendance. So we said in the emergency meeting and voted on it that we would not take actions if their fees, everything had been completed except the attendance. So I thought that was the end of it with that.
But you have some people whose licenses are still showing up as expired on the internet, and they want to have that changed to be not expired.
Yeah.
And the only way they can do that is by meeting the attendance requirement until the rule is actually approved by the Attorney General.
Right, and I think maybe one of the reasons why people want it to show active is maybe because of the MLS. Somebody mentioned that to me, that the MLS won't let them participate on the MLS if they don't have an active license. So that might be the issue, but I mean,
Also,
the commission doesn't have control over that,
it
so
also,
we can't
like,
address
had-
that issue.
They require that the licenses be active.
Got somebody off the MLS, they're dead. Yeah.
So, if we hope for the best, we don't have to discuss this again. In a worst-case situation, we've still got to make exceptions, either by phone or in person, for next month's meeting.
So they're next month gonna call people and tell them you can, in, where is it we're going next month?
Farragut.
Farragut? You can call into Farragut? Do we have that
Yes.
ability even?
If the Attorney General has not already signed the rule.
Hopefully he will, but
Right.
we have to be prepared.
Yeah. I mean, there's always that chance that it won't have happened, but I really think it will probably have happened well before then. But obviously, I can't say for sure because I'm not over at the Attorney General's office. But
When it does happen, can you let us know so we can quit worrying about it?
Yes.
Okay.
Can I ask a little bit more general question about meeting attendance? What are the circumstances under which someone is required to attend a meeting?
what's currently in the rules, you mean?
Rules, orders, statutes, whatever.
the
When
only
would somebody have to attend a meeting?
Okay, the only thing is for reinstating an expired license, the one that we've done the emergency and proposed rules on. And then I think there are, I don't know what the number is. Do you have any idea, Rihanna, of how many consent orders that were proposed or that were accepted before, a while back when the commission was offering for people to attend a meeting as part of a consent order? There,
10 maybe.
yeah, she says maybe 10 of those left. So that's it.
And then if you need to show up because you have a criminal conviction,
Oh, well, yes. I mean, that's a different.
like the
thing, but-
informal appearances that we had, if you want a waiver from the 50-mile rule, do you have to show up for that?
That's not in the rule. That's something the commission has historically asked people to come. The rule itself says you just have to submit a written request.
Okay. Is there anything else that we require somebody to show up for?
I believe so.
Okay.
Well, that's, yeah, I mean, that's optional. If they
elective.
if they want to come for CE credit, they can, but.
Thank you.
I have a question.
Yes.
Is there anybody here still remaining because they needed to be here to get their license active? Oh, okay. And they're questioning their decision that they should have left and called in right now.
When they
Okay.
had
And so would it be wrong for us to I want to make the motion that we now consider those people here for that reason to get their license active, that they've considered they have been here for the meeting today, and they can be dismissed at our next break.
Second.
Okay, I think that's going to pass without.
We're sorry.
Okay.
We're
Now,
sorry.
but there may be a sign-out sheet that we still enforce, I guess. All right, let's take a 10-minute break, and we'll get started on the last lap. Yep, I do.
Quick.
10 minutes?
I'm sure other states have done advertising town halls because it's such a.
I think this is gonna be our audience from now on, is a blank room.
What's up, buddy?
Yeah.
Because
to add?
That's all right, let her rip.
Every firm is franchised.
Let her rip, let her rip.
I've already taken.
Record keeping the reinstatements.
And you know, the rule about the, oh, we got all kinds of.
Hey, Malcolm.
Remember, though? It's like, every time.
Hello?
Yeah.
Nice to meet you. I apologize for taking your time.
So I deal with phone calls. I'm in the queue in the afternoons. If you recall.
Hey, is this the living room?
I've been here for 3
That's why I said, don't say nothing. Open the door, go back to your car.
Yeah, because we.
Don't show them around the property lines or anything.
Okay.
Yeah.
Because I know, like, we're like the.
Yeah, I mean, it could be so innocent.
And all you
What
gotta
color's
say
that
is,
carpet?
I am so sorry, but I can only let you in.
Yes.
And you know, when you're clear with people about that, then they know, oh, I can only say it.
Stairs, we're saying the correct.
Right.
Because that's what we, I mean, because rule of thumb, the moment you're even like.
Is that not correct?
I mean, the phone calls that we get, regarding.
There's so many rules and so many.
Well, the ones that.
I don't know how y'all do it.
We get a lot of people who, you own a home, right? He actually owns the home, so. And
I
you
didn't know
still
that
think-
till I came on this board.
Oh, I didn't know it
And my
either.
husband has like 10 LLCs, and he's a developer, and he's out.
But it's a third party
I
now.
was so disturbed about it, they went and got the Attorney General's opinion for me to see it. And I said, I couldn't even vote on it, I was so upset. And I went home and I told I got my husband, I said, we're calling the lawyer, he's coming over, I'm gonna show y'all something.
Yeah.
They freaked out, and they're like, this can't be.
Bad
And I'm like,
parts on the way down.
oh, yes, it is.
Today, but
So I had to immediately, on every contract my husband had, go get, cause he'd get them off he didn't even get them from me, cause I wouldn't give them to him. You know, he wanted to pay no
Yeah.
commission.
Oh, yeah.
So we had to have them all re-signed and everything. I said, I can't be sitting up there and then you come before us unlicensed.
sorry about this.
No, that is fine with me.
There it is.
Off
Just
property
email me.
management.
All right.
And I was like, I wonder if you're licensed. Looked them up. They're not licensed. Well, it's my dad's property.
A lot of property management.
Oh, yes.
I got one this past week too.
Oh,
And it's like, I called him, I said, look, yeah, I can call you or I can call your broker, but I don't think your broker knows, because his name's nowhere else. Our broker's not involved in this. I said, I'm just telling you as a real estate commissioner, you gotta set this right. I'm not turning you in. You better say it right.
Than somebody else with less education.
Well, that's more of a legislative fix, though. Like, I don't think we can change that. I'd have a two-tier system anymore, basically.
Yeah. It is.
You're about to chair that discussion.
Oh,
Yeah.
goodness, okay.
Yeah.
I had to ask legal before I could let him know.
So we have to have this arduous process to enact a rule if we want to remove.
It's a public hearing.
Yes, no, they're that's just how it's a standard sheet. Even if there's only a day one, you're fine. You do not come back to
I
me.
don't know, there's not anything to
I will not
scan
be down
on.
here.
I guess, unless the picture scans, there's a picture scan.
I have no idea.
I've seen people come
barcode or
through,
something.
you know, when we sign in there, I've seen people come through and put that. That gate's always open.
I know nothing. I know nothing.
Oh, yeah, this.
And I'm the first one to tell you
We
that.
thought they were gonna.
I like the idea that show Bobby that
I gotta climb over the cord.
I don't think it's necessary.
Saw that too, but I just wanted to. And then I wanted to make you aware fair game. Yes, I do have the information, and that's on my agenda.
Same mother company, right?
You're coming? Knoxville? Yes.
Well, that's a good question. I guess I need to ask her.
Check her, see if she'd like to.
Yeah. Only if Mickey
That
and Minnie's there.
is fall break.
It is fall break.
And that's why afterwards, my two daughters and grandson are coming up. We're going to Scotland Park. It's fall break. Any reason for a vacation?
Yeah. Take what you get. All right.
We have one lone survivor.
No, I'm so.
Well, I still think though, if those contracts had gone to the court and it wasn't written in there.
I know.
It's not,
Meeting will come to order.
well, I guess so.
Okay, next, where's Ross? Okay, let's move on. We'll come back. Executive Director's Report. Mr. Young.
Actually, I will try to be fast.
Good.
First of all, agreed citation. We are moving forward with putting this. The attorneys and staff had a meeting last week. We will have the procedures together, but I wanted to give you an update that we are moving forward on that. Also, as part of input to finance, we have a risk assessment input that is an annual activity that actually I put together. I felt like as executive director, I just wanted to make you aware of it, that it is input that we give to financial. Also, I did request of the commissioners input on PSI state review panel participants. I have gotten input from one commissioner, so to that one commissioner, thank you. I would like to hear from the rest of you of potential names that we could put in as far as a pool. Let me explain to you the background. They will actually be working on the bank state questions that will be on the licensing exam. And this would be effective 2018, but the work will begin this fall for that panel. And I know that some of the panel members that you had in the past, I know that they have retired from the industry. So we do need like a new group of people. So that would be helpful. Also, we have it is called a legislative audit of TREC. And let me explain to you what this is. I believe it's every 4 years. Each regulatory agency is measured on their relevance to consumers and licensees and whether or not the agency is to be sunsetted. And in fact, I found I think there's 5 out of the 9 regulatory agencies that are being audited. That was a gift. We got to be one of them. And I had my preliminary meeting with the auditors last week, and they're so serious about it, they've actually moved in our building. And so I think it's with a lot of detail that they will be reviewing our activities as far as the commission and the relevance to the consumers and the licensees. So I wanted to make you aware of that. Also, as far as financials for this month, I do not have the statements because they are closing out the year. So actually, when you meet in October, you will be getting the last 2 months. So with that, it concludes my report as far as executive director. Any questions? And plus, you have my written report as well, which has a lot of activities. Yes, sir.
It's wonderful what you're doing with the road show and getting out amongst the people. We haven't had.
Mallory and I both feel really good about it because the exchange, and I will tell you, when we end, they basically, we stay for at least 45 more minutes, and they are very engaged in asking us questions and interacting with us.
Questions for Mr. Young?
Can I give you one more name?
Sure.
The gentleman who is here today from Franklin.
I think he would be good.
I'm writing them down right now.
Mr. White? Want
Yes.
to talk about your education director's report?
Thank you, Mr. Chairman, members of the commission. I'll be very brief. I think that I've reviewed all the courses, and I know that earlier today we talked to Mr. John Giffen, so that course has already been approved, and just go ahead and mark that one S5. However, as a addendum, there's a typo or something that was left off on the last course, Taxation of Real Estate Transactions, on the last page, page 4, and that should be marked as S18. Additionally, I was contacted, and I want to say this is at no fault of Knoxville Area Association of Realtors. They sent in a new course to us, but because of our current situation involving renewals, we have hundreds of courses and hundreds of documents that are floating around. Well, this one should have come to me, but it did not. And they asked me if we could add them on today as the last course. The name of this course, which I've reviewed, is Course Components of Commercial Brokerage, Ethics and Professional Standards. And it's all complete, and I would just ask that you would add that as S19. With that, I would ask the commission to approve all the courses and the one loan instructor who needs approval, S1 through S19.
Is there a motion?
I have a question.
Okay.
On S3 and S4, I'm a little bit confused about that. 12-hour Tennessee Principles Review. There's CR and PP. What's the difference in these two? And they're 12-hour classes, so I wanted to be sure about these.
Okay. Well,
Is this a new class?
it is, as far as this education period, as far as I know. It is a new class.
Is it something that we've approved in the past, a 12-hour Tennessee Principles Review?
I could not say, in my time here, I do not recall that has.
Do the educators here have any knowledge of that class? Know anything about it? I tried to look it up and I didn't see it anywhere. I was just wondering, I mean, so it's a 2-day class? With it 12 hours?
Right.
But I mean, I was looking to see if it had been approved and we had it some other time by some other teacher.
It says
I think
previously
they're
approved.
offering it.
The teacher was previously
Okay.
approved.
Yes, I think they're the Fast Track Real Estate School is an approved provider.
And I looked them up. What is CR and PP?
CR is, essentially classroom.
Oh, okay.
Yeah,
And PP's paper and pencil.
Yes, ma'am.
Okay. Who do they see taking that class? Maybe somebody needs 16 hours and they go knock 12 out?
Well, I was thinking that part of the reason and the proposal is because of the PSI requirement that they would have to take a refresher if they, I've forgotten how many times they take the exam, but it's a refresher course.
Oh, that's what it is. It's for people unlicensed then.
Could be, yeah, but it lets them get back in if they have, they've got to take that.
I see. If they've had it in retirement and they would need to come back, they could take that class and
That would
refresh.
suffice.
Okay, sounds like a good idea to me.
So is there a motion to approve courses S1 through S19 and the instructors that need approval? All right.
Second.
Motion by Commissioner Taylor, seconded by Commissioner Hills to approve the courses and instructors. Is there any discussion? Let's vote. All those in favor say aye.
Aye.
All opposed, no. Motion is approved. Anything else, Mr. White?
That's all I have, Mr. Chairman. Thank you.
Thank you very much.
Thank you. Could I?
Mr. White, who's the teacher for S19?
Teacher for S19 is Bill Burgess.
Been improved before? Yes. Okay.
From the
Mr.
Rick and
Chairman.
Bubba Show? Bill.
Mr. Chairman, I have a question, Mr. Ross.
Go ahead.
I happened to be at an association, and they suggested to me that we have a very old system, and it's so time-consuming doing notepad to turn in education. And I took a picture of the screen. They said, this is what it is. And they typed the names, typed the slashes, number of slashes, and
Right.
and you get it off, and you have to.
Well, we've got an improved roster format now, and we haven't had too bad a situation with that, but I do
So it's
understand.
not on through Notepad. There's a different system.
We still do Notepad.
It is done through Notepad. It is slightly dated, but it has been updated in the past, I would say
6 weeks.
6 weeks, yes, to where it's more user-friendly. We are still in communications with IT, being able to run them ourselves and come up with something even better. But right now, this is the process that we are using.
Strange looking. I took a picture of the screen. It was shoot yourself. Strange.
Questions about education? If not, then let's go to Kirby. Before we actually start with the cases, I was going to ask, at our last meeting, we had a vote about a new rule or revised rule about the 50-mile rule.
Yes.
Could you give us an update on that?
Yes. So, and I guess it wasn't on the agenda. There should be there's a draft of that on your iPads that you all asked me to draft. That is number 27. And that is, the commission asked me last time to draft a version of the rule applying the 50-mile rule also to the principal brokers. I will let you look at that and discuss it, but I'd like to just mention that legal counsel does not recommend adopting this rule. I don't really see that it's needed to protect the public based on any information that we've received. And in fact, if this commission was to do a rule change dealing with the 50-mile rule, my recommendation would be to get rid of the rule altogether rather than adding a more restriction to the rule that's already there.
All right, is there discussion or questions for Ms. Kirby?
I would just like to also comment, I guess one of the concerns that I have is, with various business models that are entering the marketplace, and also the ability to work remotely. Those are two concerns that I would just, interject with the things that are trending as far as real estate brokerages today and the ability to supervise your agents in a, remotely and not right underneath them as far as agents.
I know that from our discussion last month, this was motivated by a desire to see that the same rule that applies to the affiliate brokers also apply to the principal brokers. And that was the reason for the rule to be drafted.
Yet today, we are allowing a broker from Oregon, Mr. Lindahl, at this point. Is that how you see it?
Arizona, I think.
Arizona?
We had 2 brokers in Arizona, 3 from Florida. Those are states that, I was just looking at the states that don't border us. I mean, you can tell Virginia and Georgia and North Carolina and things like that that border us. Those make sense.
And that's a law from the legislature, right? Not a rule?
50-mile rule?
No, the other, where the principal broker doesn't have to live in the state.
It just was silent to the principal.
Yeah, I mean, the statute doesn't address the distance that anybody lives from the firm. That's only in the rule. But the statute does allow for people who live outside of the state of Tennessee to have a Tennessee real estate license.
That's what I'm saying.
Yeah.
So, and this is
Those
just
are too arbitrary.
been a pet peeve of mine. I guess it's either all or none. I think the broker's more important than the licensee, but with technology, I just. So if we were to decide to do away with it completely, what do we have to do?
I would just prepare a rule amendment reflecting that, just like our other.
Have an
just like
emergency meeting to get that taken care of quickly.
I'm not sure that this would really fall under something that could be taken care of in an emergency meeting. In order for it to, be a candidate for emergency rules, I mean, it really needs to have imminent harm to the public, which I'm not sure that this would rise to that. But, we can always look into it. I'm just saying my best guess is that it probably would not.
So would this be to just eliminate part 2 of this rule, and then we would still keep parts 1 and 3?
I think that's correct. Let me pull up the rule. Yes. Mm-hmm.
At the time that we vote on that, do we also need to have all those other regulatory flexibility analysis votes and all that sort of stuff too?
They don't necessarily have to be voted on together, but we can't move forward unless all of those documents are done. So those could be prepared for, next time if the commission wanted to do that.
So to Mr. McMullen's previous point, so this is a rule. If we keep parts 1 and 3, is there a statute that already speaks to those two issues?
Well, there's a statute that says a firm office must have a principal broker. The number 1 goes into it a little bit further and says a broker who devotes his full time to the management of such office. So that's kind of the addition there in the rule versus the statute. And then number 3, that's, I believe, derived from the same statute that just says there has to be a principal broker, but the statute doesn't address specifically those other things, which are engaged primarily in the real estate business and accessible during normal working hours.
We also have a statute that requires the principal brokers to supervise the affiliate brokers.
Yes. I believe that's
Try to get rid of that one.
See again, it's 24/7.
I almost think, we come and we're like, we hold the brokers accountable for things that are done. If you're going to do away with the broker, even need to be near or not have the broker need to be near the office, or the agent's not near the office, I think we need to completely change the whole model. And instead of having brokerages, make everybody an individual license. And so let's just have a free for all. Let's not even give them a test. Let's just, if we want to just let everybody get in real estate, let everybody get in real estate and go buy a lottery ticket and get in real estate. But I think
Time for his peel.
Yeah. It started at 8:30 and it ticked me off, and it's been that way all day. Okay, and so I'm like, at some point, common sense got to kick in, and you got to have some rules. And I still think, even with technology and stuff, the thing that we're selling is still property, and whether it's residential, commercial. And I just don't understand how you can adequately take care of a place and you have no idea where in the world it is. You can take all the pictures you want to and stuff, but still there's nothing like going and touching it and seeing it. And I don't understand that. And I'm not going to tell you I haven't sold stuff that I didn't see it, but you can't do that on a consistent basis, I don't think. But
I suggest we just take out the new part we were gonna add and go back to the old rule and just stick with it till something else comes up. I'm like Bobby. I feel very depressed today. I feel like everything we've done is loosen the rules and just it's kind of like a free for all. So, but that's what I would like to do. Just take the broker, having to live within the 50-mile limit out of there.
So last month, the commission asked legal to come up with draft language. They've done that.
They don't recommend it.
Well, so they don't recommend it, so is it your sense that you would like to withdraw the request that we made last month? Is that what you're trying to?
Well, with what they've come up with, I'm saying let's just keep the old rule and not take on this one.
The rationale for not putting the new rule in is we're going to restrain trade, or?
I just don't feel that it's with all the technology that we have now and the way other business industries work and can function without being physically in an office. I mean, even the state of Tennessee is implementing alternative workplace solutions where departments are transitioning to having people working remotely. That this is really something that's necessary to protect the public. I mean, I think if somebody's not going to supervise their agent, or if the agent's going to do wrong, they're going to do wrong whether or not supervise whether they're doing so electronically or physically in an office. I don't know that having somebody, either the principal broker or the agent, living within 50 miles of the firm really solves that problem.
And the majority of agents don't even go to the office much. I mean, they go to turn in their paperwork, they go to turn in checks, but the model these days is not some big, what we used to call them, the big pen? Bullpens, where 50 agents are sitting in there and they're all on the phone. I mean, that's not how it works anymore. Everybody's on their computer.
But there still is that base place, though, where they go to.
I mean, they're still required by statute to have a firm office, so that doesn't go away. It's just it would just be the requirement, or my recommendation would be to get rid of the requirement to require anybody to reside within 50 miles of that office.
Why don't we just do like some states and you can broker 4 or 5 offices if you want to? Why do you have to have a broker at every office?
We'll get to that someday, I suspect.
That's the next one.
Sure.
I'm running the meeting.
Well, you get to let everybody else talk first, and you get to say what you think.
All right. Well, I would like to see us get rid of the 50-mile rule. I think that with the technology that we have, to require somebody to live within 50 miles is not realistic. I mean, people live farther and farther out and can telecommute and things like that. We're still requiring the principal broker to supervise the people. We're still requiring that there be a principal broker for the office. So I would like to see us get rid of the 50-mile rule and just delete number 2 under this rule.
And frankly, to speak along the same lines Austin's talking about, if you're going to affiliate and I'm going to be your principal broker, you better live closer than 50 miles. It's a company policy, not necessarily a state policy that dictates who you get. Right. So generally speaking, I'm in support with what Austin says. How often do we have a 50-mile appeal? Once every 2 months? I can't imagine it'll be a huge deal, just because I don't want the liability of somebody in Nashville representing me and my company while I'm in Knoxville. Just don't.
I had to when this law came into effect, I had to let my best agent go because they lived outside of that. To this day, they're still one of the biggest realtors in Franklin. So that just kind of kills me, but.
Now you go back and get her.
But I mean, he does it on his computer and he does it on his phone, and you know, I'm texting at 10 o'clock at night to people, you know, in my bed. So the nature of the business has changed. And I agree that the principal broker, maybe you could require them, okay, you can live outside of it, but I want you to be at every sales meeting that we have. You know, that's a business model that the broker could set forth, which is something I would want to do.
But you have a sales meeting. might be totally different than the model that's out there now.
Right,
So it's more of a company policy than it should be
Right.
a state policy, I suspect.
right. And it would be an agreement between two people, because I'm not their employer. It would be agreement, two people, you know, I want you to come, but, you know, I have this problem, you live in so far, so I need you to come in once a week. And do you agree to that? You can or you cannot. So I agree also.
I would like it one way or the other. Either
Right.
both brokers and licensees or neither. I just.
We have a motion.
No, if somebody'd like to make a motion, that'd be great.
I'd like to make a motion.
Go ahead.
I would like to make a motion that under the Rules of Conduct Amendments, number 2, be stricken, period.
And direct legal counsel to prepare the necessary regulatory flexibility analysis and other documents so that we can make a final vote on this next month.
Yes, I was going to say that.
Okay.
Second.
All right.
So let me just follow up on one part of that. So you're suggesting we take out paragraph 2. What about the last sentence in paragraph 2? How important is that to stay in there, Ms. Kirby? Last sentence of paragraph 2.
How about the waiver?
Yes.
Oh,
For purposes of this rule of property manager?
Because it's in parentheses in the first sentence. It's the only reason it's there, I would say.
right. I mean, if we get rid of all of number 2, I don't think it's really relevant anymore.
So you're okay taking that piece of paragraph 2 out as well?
Yes,
I mean, it's
because if no
defined-
one's required to live within 50 miles, then property management wouldn't be either.
Okay, universally handled.
Right.
Okay.
All right, it's been moved and seconded to direct legal counsel to prepare the necessary documents for us to vote next month on the deletion of paragraph 2 from Rule 1260-2-.01. Any discussion?
This is nothing we can handle totally next month, is that correct? This is a rule change, it's gonna take months to take effect?
Right, you can do all of your part next month, but the rest of it will have to go through the process.
That process could take months.
It will take months.
It'll take months. Okay, so it's not imminent.
Let me know so I can get that guy back.
Okay.
All right, let's vote.
Let's vote. All in favor say aye.
Aye.
Opposed, no.
No.
That motion carries 7-1. Thank you, Ms. Kirby. Are you ready to go into the legal report now?
So ready.
All right, me
Let's do
too.
it.
Let's go.
A consent order authorized by the Commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. So we'll start with number 5. And it's 2016000651. And I would prefer not to read all this again, but I will if the Commission would like me to.
Without objection, you are clear to move forward beyond that.
Okay. So this case, or this complaint, was placed into litigation monitoring when it was after it was first presented to the Commission. Essentially, the issue in a nutshell is that there was a contract on the house. The inspector came back with several things that could be repaired. They did a replace addendum identifying the things that the seller was going to take care of in terms of repairs. The language in that contract included a provision which said the repairs would be done by a licensed contractor. And essentially, they were not done by a licensed contractor, but but the details surrounding that whole thing about why it wasn't a licensed contractor and whether it was approved by the buyers or not is kind of the issue at hand here. So the respondent submitted a judgment. So this went to General Sessions Court. The respondent submitted a judgment from General Sessions Court showing that the complaint against respondent and seller for failure to make repairs under the contract was dismissed. However, unlike the court, which was to view the matter from the breach of contract standpoint alleged, the Commission must look at the matter as it relates to violations of the Broker Act by respondent. It is legal counsel's opinion that it is not in the best interest of respondent's client for respondent to advise the sellers and buyers to use an unlicensed contractor, and when the contract states that the repair should be done by a licensed contractor. An email dated 11/21/15 from respondent to buyer's agent provides basically a bio of this contractor and a personal recommendation from respondent since respondent has used him for many years. The email also states that he had a license but that it had expired and his wife had kept track of all the records and renewals, and she had passed away a few years earlier. The buyer's agent responds, stating the buyers are okay with this person doing the repairs, but that they want him to get his license renewed before doing the work and were willing to delay closing for this to happen. The email also states the buyers want respondent to be responsible for paying another individual to reinspect the work after it's done by respondent's contractor. The very next day, the buyer's agent sends an email stating that the buyers are willing to go ahead and allow respondent's contractor to do the work if respondent pays the person that is to reinspect prior to any work being done. It also states that the buyers will withdraw the contract if the person re-inspecting finds the work was not satisfactorily done by respondent's contractor. It seems clear that the buyers felt pressured to use this contractor, even though the signed repair-replace addendum states it must be done by a licensed contractor. Thus, even though it may have saved respondent's client money on the repairs, it does not seem in the client's best interest or in good faith to complainants to recommend taking action that is in contradiction to the contract, especially when it looks like the work that was not done according to the contract and resulted in the seller being taken to court, albeit a dismissed case. If respondent thought it was in the best interest of the client to have this contractor do the work, respondent should have worked to remove the licensure requirement from the repair-replace addendum prior to execution. The recommendation is consent order for $250 for violation of TCA Section 6213-4042, failure to be loyal to the interests of the client, and $250 for a violation of TCA Section 6213-4034, failure to provide services with good faith.
Move to approve recommendation by council.
Is there a second?
Second.
We have a motion by Commissioner Franks, seconded by Commissioner Wood to approve council's recommendation. Is there any discussion? If not, let's vote. All those in favor say aye.
Aye.
All opposed say no. That motion is approved 8-0. Number 6.
201601641. Complainant alleges that complainant was provided false information, lied to, and property was misrepresented by respondent regarding any covenants or restrictions on a property that was to be purchased by complainant. Complainant states that complainant entered into a contract to purchase the property pending receipt of a disclosure, which was received 6 days later. The contract also included an inspection contingency and staked perimeter requirements. Because the disclosure showed nothing out of the ordinary, complainant proceeded with the home inspection. Complainant states that complainant verbally requested a copy of any current or existing surveys, and when it was finally received, the survey revealed that the property was part of a platted subdivision. As a result, complainant states complainant inquired about the covenants and restrictions and disclosures, and the disclosure stated there was no subdivision and or deed restrictions. Complainant states that respondent told complainant's agent there were no covenants and restrictions. Complainant states complainant was still unsettled regarding the extent of the subdivision, so complainant's agent did some more research and found that there were restrictions and covenants. Complainant concluded that the covenants and restrictions were adverse to complainant's intended use of the property and proceeded to notify respondent that complainant was rescinding the offer to purchase. Complainant requested return of the earnest money and inspection fees. Complainant states that respondent is refusing to return complainant's earnest money on the basis that complainant's notification was given past the inspection date. Respondent states that complainant's agent sent respondent an email requesting additional information regarding the property on 11/13/2015. Respondent states respondent told complainant's agent that respondent had requested the survey from the seller and has not yet received the disclosures back from the seller. Respondent states complainant's agent responded stating, "No problem, I pulled the deed and it seems as though it is a platted subdivision in at least 5 lots, so the survey should be at the courthouse." Respondent states that the property was listed in the MLS as part of a subdivision. Respondent states that the parties entered into a contract on 11/16/15 which had no contingencies regarding receipt of disclosures, and that the disclosure and survey were sent to complainant's agent 3 days later on 11/19/16. Respondent states the contract provided for a 10-day inspection period and a 2-day resolution period. Respondent states respondent never received any inquiries about covenants and restrictions, and that the first time respondent heard of any issue regarding covenants and restrictions was when respondent received the notification of cancellation of contract. Respondent states that the seller completed the property condition disclosure to the best of her knowledge, and that upon receiving complainant's request for return of earnest money, the seller asked if there was anything that could be done to remove the restrictions. Respondent states complainant was not interested in moving forward with the contract. Respondent states complainant wanted to put horses on the property and could have done so. Respondent states that the seller refused to return the earnest money because complainant had an inspection period that could have asked for an extension but did not. Respondent states that all of the inspections had been done and a negotiation had taken place on 12/6/15 to reduce the sales price in lieu of repairs for the buyer to accept the property in as-is condition. Respondent states that the seller made a counteroffer to the notification to cancel the contract, which included splitting the earnest money and not refunding the buyer inspection fees. Respondent states complainant's agent informed respondent the next day that complainant would accept the counteroffer, but within an hour decided not to accept. Respondent states that respondent did not lie or misrepresent the property and is offended by the accusations. Respondent states that there was possibly a lack of information provided by complainant's agent. The purchase and sale agreement was executed on 11/15/15. The MLS listing showing the property as part of a shows the property as part of a subdivision. On the Tennessee Residential Property Condition Disclosure Form, which was sent to complainant's agent on 11/19/16, the seller marked no to question 17, which asks, subdivision and or deed restrictions or obligations? There is no evidence to support that the seller or respondent knew about the covenants or restrictions. There is also no documentation or other evidence that complainant or complainant's agent had any communication regarding covenants and restrictions. Additionally, complainant's agent in an email dated 11/13/15 states, I pulled the deed and it seems as though it is a platted subdivision in at least 5 lots. So the survey should be at the courthouse. The recommendation is to dismiss.
Motion?
Move to dismiss.
Second.
Motion by Commissioner Frank, seconded by Commissioner Taylor to dismiss. Any discussion? If not, let's vote. All those in favor say aye.
Aye.
All opposed say no. That motion carries 8-0. Number 7.
20160164331.
Move to dismiss.
Second.
Motion by Commissioner Frank, seconded by Commissioner Hills to dismiss. Any discussion? If not, let's vote. All those in favor say aye.
Aye.
All opposed say no. That motion carries 8-0. Number 8.
20160183991, 20160183992, 20160183993, 20160183994. Complainant is an agent of respondent's firm and alleges substantial and willful misrepresentation, making any promise of a character likely to influence, persuade, or induce any person to enter into any contract or agreement when the licensee could not or did not intend to keep the promise, discrimination, and improper, fraudulent, or dishonest dealing. Complainant states complainant has tried to talk to the operating principal, but complainant's call has not been returned. Complainant states complainant has asked for complainant's personnel file, but was told it was the firm's property. Respondent submitted a joint response by and through an attorney. Respondent denies complainant's allegations of discrimination and inappropriate action. Respondent states that complainant was notified orally and in writing about the firm policies and guidelines at the outset of complainant's employment, including paying local association dues, monthly fees, and reimbursing the firm for advances made on and floor time. Respondents state that the complainant's relationship with the firm was problematic from the outset, and complainant was terminated on March 26, 2016 for repeatedly failing to follow policies and procedures and dishonesty. Complainant provided no factual allegations, and respondents' responses indicated that any problems between complainant and respondents were based upon internal firm policies and procedures and did not involve matters that fall under TREC jurisdiction. The recommendation is to dismiss.
Move to dismiss.
Second.
Got a motion by Commissioner Frank, seconded by Commissioner Hills to dismiss. Any discussion? Hearing none, let's vote. All those in favor say aye.
Aye.
All opposed say no. Motion carries 8-0. Number 12.
201601871. Complainant, respondent's former principal broker, alleges that respondent changed dates on the exclusive buyer representation agreement from 1 year to 3 years without consent of the client, threatened to sue a client unless they personally wrote respondent a check in the amount of $850, forged client signatures on 2 documents to the sales contract, and compensated another licensed agent directly for an agent bonus in the amount of $600. Respondent states respondent had listed the client's house for sale for 6 weeks when respondent and client decided the client would offer a $600 agent bonus as a strategy to bring buyers into the home. Respondent states that respondent changed the MLS listing to reflect this, but neglected to present the amendment for client to sign right away. Respondent states that when respondent realized the amendment had not been signed, respondent called the client, who said he was away on military mission, for respondent to sign for him. Respondent states that respondent should have waited until the client returned instead of signing the document, which respondent regrets. Respondent states that in the process of selling the home, the inspection report asked that some repairs be done, and respondent and client agreed that since the client didn't have time, respondent would take care of the repairs and the client would reimburse the firm. Respondent states respondent provided the receipt for the faucets but cannot provide receipts for the other repairs. Respondent states that the client's divorce decree also had to be recorded, which respondent took care of in the client's absence. Respondent states that the buyer's agent didn't receive the agreed upon bonus, and the client was confused as to why it didn't come out of closing and thus was reluctant to pay it. Respondent states respondent wrote a check to prevent a delay in the agent being paid. More than 7 months later, respondent received a call from the client stating the client was ready to buy a home and wanted to work with respondent. Respondent admits to changing the date on the buyer's agreement after they met and neglected to have the client sign it. Respondent states that client eventually decided not to buy a house. Respondent states the client never reimbursed the firm for expenses previously advanced. Respondent asks that the commission consider respondent's professional history and not base respondent's future on one isolated file. Respondent states the respondent has been a real estate agent for more than 12 years and a public servant for about 30 and has always placed clients' needs first. Respondent states respondent got lost this time and wishes the client would have never contacted respondent. Respondent provided a copy of the check written to the buyer's agent in the amount of $600 for the agent bonus. However, TCA section 6213.312B11 says accepting a commission or any valuable consideration by an affiliate broker for the performance of any act specified in this chapter from any person except the affiliate broker with whom the licensee is affiliated. Thus, is legal counsel's opinion that the respondent is not in violation of the statute. Respondent states respondent was given permission by the client to sign the listing agreement for him, and the client proceeded to close the sale of the house with respondent, so it is legal counsel's opinion that permission was likely given, even though it was not best practice to do so. Respondent admitted to changing the buyer's representation agreement without the client's consent. The recommendation is the consent order for $500 for violation of TCA section 6213.312B20, improper, fraudulent, or dishonest dealing.
So did this person get $600 outside of the closing?
Yes, this respondent paid the other agent the $600.
I think the violation should be more than what he got. I'd move to change that to 1,000.
All right, we have a motion to adopt council's recommendation, but amend it to increase the consent order to $1,000 by Commissioner Bloom. Is there a second? Seconded by Commissioner Taylor. Discussion?
My concern was that I couldn't really pinpoint a specific statute that him receiving or him paying that money would be violating. As I said here, the TCA 6213.312B11 would seem to indicate that the person receiving it would be in violation of that statute, but not necessarily the person giving it.
So, in your interpretation, anybody can give money other than a real estate commission?
Other than a real estate commission, what do you mean?
A real estate agent can only receive money at a real estate commission at a.
Well, our law doesn't say that. Our statute just says you can't accept a commission or any valuable consideration for anything that requires a license from anyone except the real estate broker.
And they didn't get it from the real estate broker.
Right, but the statute says accepting a commission, not giving a commission. So I think the person that at fault here was the agent that received the bonus. I don't think this statute could be applied to the person giving it because it only says accepting a commission.
So 20 would cover that, wouldn't it? That you have here. B20?
Right, 20 I cited for the changing the date on the listing agreement without the client signing it.
Still improper. The $600 was still improper too, though.
Well, did the 600 go from one broker to another broker?
Yes.
Okay.
Oh, I thought you went from
No,
affiliate.
it went, well, by broker, you don't mean, do you mean principal broker?
Principal broker.
No,
principal.
no.
Went from affiliate to affiliate.
Well, that's clearly illegal on both parts, I would think. I mean.
Under what, though?
It just says accepting, not, so the accepting person was guilty.
I would say so, but that's not who the complaint's against.
That's not the complaint.
So let's just say there's a situation in a residential office where a guy is real busy with buyers and he finds a slower buyer's agent and says, if you'll drive these people around all day today, I'll give you $200. So the
In
agent,
another company?
maybe, but it doesn't matter according to the statute. The agent can't take that $200 under any set of circumstances unless the licensee sends it up to the principal broker who then sends it back down.
Right, if what he's doing requires a license, if he's just driving them around, then.
Take them in the house.
So,
Tell them what color the carpet
Yeah,
is.
if you,
so a licensee paid the other licensee, or the principal broker paid another licensee?
Affiliate paid the affiliate.
Right, the
affiliate
check was made out to the other affiliate. It also had the name of the firm on there, but it doesn't indicate that it went to the principal broker. So, I mean, I agree that it was wrong for him to do that because it's wrong for the other person to accept it, but I'm not sure what we could pinpoint here to put it on this person. I mean, if you have a statute that you think could apply, I'm certainly you're welcome to discuss that, but.
The check, did it had the other agent's name on it, but it had the broker's name too? Is that what you said?
Company check?
Was it a company check? I believe it was a personal check.
But was it made out to just the agent or the agent and his brokerage?
It was made out to the agent's name.
Okay.
And then his firm name was written next to the agent's name.
So Marcia Franks, Franklin Realtors. So I think he gave it to the wrong person. It shouldn't go to Marcia Franks, it should go to the company. And then the company can take out their divvy and give them whatever.
Put both names on it.
Mhm.
I think he's okay. Yeah, because he couldn't cash it without the company signing it.
Oh, can you
Council's
pull up the check?
recommendation.
Let me look at it again.
Right.
It's based on changing the.
You're welcome to find other violations as well, but.
Accept that invitation.
It's a personal check written from the respondent to person, and then his firm name is written to the side there.
This is agent bonus.
Who's it endorsed by?
Well, we get the documents from the respondent, so it's not gonna have that.
The motion is to accept council's recommendation, but to increase the amount of the consent order from $500 to $1,000. That was made by, who seconded that? Oh, Commissioner Taylor seconded that, right.
Seems to be in the ensuing discussion since that motion was made, it's clear to me that the respondent who issued the check is in violation of that. There is a violation to pay another licensee. There's a violation to accept it, but perhaps since the check was made out to the company and the agent, that wasn't an issue either.
Focusing on for the violation is changing the buyer's representation agreement without the client's consent.
Which that is wrong.
So we're really not focusing on, because the payment violation could only be on the one who accepted it.
Gary, you still okay with the $1,000 fine or civil penalty, or would 500 be better?
I never thought that you could give or receive money other than broker outside of a transaction.
But I think in light of what, it's got the agent and the brokerage name on it. So I think they could make a good argument. That was legal.
Yeah, they can't help what account it went into. It was illegal that they did it from their own personal account, though.
I mean, I could see this happening. I mean, because we've had this happen in our office. Somebody goes, hey, you did a great job, agent. I want to do something even more special. I know you'd help me. And they wrote it out to the agent, and the agent brings it in, and we endorse it and run it back through our account, and then do it properly. Because the agent realized, and that may very well have been what happened there. So I'm not as hung up over the bonus part. Because I think after hearing what was on the check, I'm good with that, actually.
Have a motion on the floor. Do y'all want to vote on it, or is there a substitute motion?
I'd like to put a substitute motion. It's $500 civil penalty rather than $1,000.
Okay, we have a substitute motion to accept council's recommendation for $500. Is there a second on
Second.
that? Okay. Any additional discussion? Hearing none, let's vote on the substitute motion, which is for the $500 penalty. All those in favor say aye.
Aye.
All opposed say no.
No.
That motion carries 7 ayes, 1 nay. Number 13.
Can I just clarify for my consent order writing purposes that $500 is for changing the listing date without the consent of the client? Right, okay. Okay, 201601847. Complainant states respondent refuses to comply with their contract with respondent, has breached complainant's trust and possibly damaged complainant's sales position. Complainant states complainant purchased a home through respondent's firm a few years ago and listed the home for sale with respondent around 11/15/15. Complainant states that in the past 4 months, respondent has only informed complainant of one serious potential buyer. Complainant states that respondent sent the disclosure statement to the potential buyer without a written offer being presented and without complainant's permission, which complainant states was not acting in good faith. Complainant states that an email was sent to respondent after this happened, requesting that respondent not send the disclosure without a written offer and without notification to complainant. Complainant states that complainant became concerned when respondent advised complainant that a buyer's father-in-law, who was a licensed engineer, checked the crawl space and became concerned with moisture levels. Complainant states that complainant attempted to invoke complainant's right to submit inspection results to potential buyers in lieu of the disclosure statement per Clause 4 of the disclosure statement and TCA Section 665204, but the broker owner-manager refuses to do so. The principal broker referenced by complainant passed away in April of 2016. The agent that worked with complainant states that the potential buyer requested information on the home, including the disclosure, which was emailed to her. The agent states that the potential buyer looked again at the house and the potential buyer was concerned about mold possibilities caused by moisture in the crawl space. The agent states that it is the agent's understanding that the disclosure must be filled out unless the 3-year rule applies and that the seller could supply an inspection or some other proof as an answer to questions the buyer might have relative to the seller disclosure. The agent states that the complainant emailed the agent on 3/13/16 stating the complainant had allowed complainant's spouse to fill out the disclosure and now wanted to change it. The agent states the agent was informed by the principal broker any changes to the disclosure must be completed through an amendment and that both the original disclosure and the amendment would be provided to potential buyers. The agent states complainant was very angry about this. The agent states that complainant allowed her to release the original seller disclosure approximately a week later to another agent with a potential buyer. TCA Section 665203 states that the disclosure should be delivered prior to acceptance of the purchase contract. Legal counsel will defer to the Commission as to whether providing it prior to the offer is acceptable industry practice. The statute reads slightly different than the agent's interpretation in that the statute does allow the seller to provide a report or an opinion from an expert in lieu of the applicable portions of the disclosure when the report or opinion is requested for such purpose. It is unclear if complainant wanted to submit the inspection results from when complainant purchased the house in July of 2013 or conduct a new inspection. Regardless, because the disclosure was already completed and given to complainant's agent, and there's nothing to indicate that complainant ever mentioned anything about wanting to exercise this option prior to a potential buyer expressing concern about the moisture in the crawl space, it seems reasonable for the agent to think that the seller was not going to exercise that option. Recommendation is to dismiss unless the Commission finds that providing the disclosure prior to an offer being received is against the interests of the client or lack of skill and care.
I make the motion to dismiss.
Second.
We have a motion by Commissioner Taylor, seconded by Commissioner Wood to dismiss, consistent with council's recommendation. Any discussion? Hearing none, let's vote. All those in favor say aye.
Aye.
All opposed say no. That motion carries 8-0. Number 14.
20160195331. Complainant states that respondent failed to provide full and written disclosure to complainant regarding any conflicts of interest. Complainant states that respondent is representing an immediate family member in the purchase of complainant's house. Complainant states that the complainant has no written confirmation of this relationship. Respondent states that when this issue was brought to respondent's attention, respondent refused to correct, make amendments, or cancel the contract. Complainant states that the principal broker was informed via telephone of the situation and told complainant that she did not have time to discuss the matter with complainant. Complainant further states that respondent provided confidential information about complainant to a mutual acquaintance without complainant's permission. Complainant states that respondent admitted fault and negligence in the failure to fully disclose to complainant and to respondent's principal broker. Respondent states that respondent verbally informed complainant's agent about the personal relationship between respondent and the buyer prior to the contract being bound. Respondent states that respondent forgot to include the proper disclosure in the original paperwork and tried to correct the oversight by sending the form to complainant. Respondent states that complainant refused to sign the disclosure statement. Respondent states that respondent listed another property for an individual who happened to work at the same hospital as complainant and in casual conversation said that they might know each other. Respondent states that complainant suddenly changed complainant's mind and said complainant was not going to sell the property or let the appraiser on the complainant's property. Respondent states that complainant then told complainant's agent that complainant still wanted to sell the house but not to respondent's clients. Respondent states the seller is threatening lawsuits and calling calling anyone that will listen, including news media. Respondent states the complainant contacted respondent's broker, and respondent's broker said they intended to proceed with the transaction. The broker told complainant she could not meet with complainant that day, but could at the first of the week. Respondent states complainant screamed at the broker that complainant was going to call an attorney. Respondent states complainant told complainant's agent that complainant was contacting the news and that no one was to set foot on complainant's property. Respondent states that suddenly after complainant spoke to an attorney, complainant decided to allow the appraiser onto the property and move forward with the sale of the home. Respondent states that the house did not appraise, a mutual release was signed by both parties, and complainant still owns the home. Recommendation is a $100 consent order for violation of TCA Section 6213-437, acting on behalf of an immediate family member without timely written consent of all parties.
Is there a motion?
Make the motion that we go ahead with the $100 for violation of 6213-403.
Is there a second? Motion by Commissioner Taylor, seconded by Commissioner Horn to accept council's recommendation. Discussion.
So is it clear in your mind that no disclosure was given?
Right. The respondent said that she forgot to do the disclosure right away, and you know, it looks like she did try to do one very quickly after the purchase and sale agreement was entered into. So, I mean, there really wasn't any harm to anyone here. So, I mean, I would also be fine with, you know, a letter of warning if the commission wanted to do that.
Property didn't convey.
It didn't appraise, so the deal fell through.
Off the question.
No further discussion. All those in favor of the motion say aye.
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 All opposed say no. Motion carries 8-0. Number 15.
20160195551. TREC opened a complaint against
Move to
respondent.
dismiss.
Second. Motion by Commissioner Frank, seconded by Commissioner Woods to discussion. All those in favor say aye.
Aye.
All opposed say no. Motion carries 8-0. Number
201601941. Complainant alleges the respondent has raised the social membership fee and imposed a food service facility fee without explanation. Complainant.
Excuse me, please.
Yes.
So this is a topic that we don't have any jurisdiction over.
That is correct.
I'd move that we accept council's recommendation and dismiss this complaint.
Second.
motion by Chairman Grease, seconded by Commissioner Franks to accept council's recommendation and to dismiss. Any discussion? All those in favor say aye.
Aye.
All opposed say no. Motion. Did you vote no? Motion carries 8-0. Number 17.
201601981. TREC opened a complaint against respondent for allegations of fraud and forgery filed in Chancery Court and reported in a local newspaper. 2 LLCs and multiple individuals, including respondent, were named defendants in a class action lawsuit arising out of an alleged scheme to illegally acquire properties under the tax sale redemption process. The complainant alleges that LLCs allegedly would identify properties sold to satisfy unpaid property taxes and then create false instruments with which to assert rights of redemption. Specifically, the complainant alleges that respondent notarized a falsified quitclaim deed and the individual whose name is on the quitclaim is a forgery. Respondent states that respondent was formerly employed by a title company from June of 2013 until August of 2015 as a closing agent. Respondent states that respondent was labeled an owner of the defendant LLC as a result of being an employee of the title company. Respondent denies any wrongdoing or improper conduct alleged in the lawsuit. Respondent states that the plaintiffs in the lawsuit are business competitors with respondent. It appears that the defendant LLC and the title company that formerly employed respondent, which is now dissolved, had the same registered agent. Respondent denies any wrongdoing alleged in the complaint. The complaint does not allege any wrongdoing by respondent in respondent's capacity as a real estate agent, but only through respondent's connection to the defendant LLC, which appears to stem from respondent's employment at the title company. So the recommendation is to dismiss.
Move to dismiss.
Okay.
Motion by Commissioner Franks, seconded by Commissioner Taylor to accept council's recommendation and to dismiss. Can I ask a question? The allegation is that the respondent notarized a falsified quitclaim deed. Is there a case that we had in which a licensee was punished for notarizing documents signed?
Well, it is different because that was a criminal conviction. This is just a complaint filed in civil chancery court. So I think it is different in that respect. Also, I think that in that case, it's yet to be determined whether that person was acting as a real estate agent. In that something that's
One that we're currently talking
no, in the other one.
Okay.
And in this one, it seemed pretty clear that this individual was not acting as a real estate agent. That this was when this person was employed for a title company before they. I think maybe this person had a license at that point, but wasn't doing real estate.
Well, to Mr. McMullen's point, the case he's referring to where we revoked the license or temporarily suspended it, is that temporary? Do we have another hearing on that coming up?
Yes, that's actually going to be heard in October.
Okay. But he was acting not as a real estate agent in that course, but the criminal conviction is what triggered the suspension. And we don't have that here because we're not monitoring this case. Is it still ongoing?
This case,
Chancery Court litigation.
the Chancery Court litigation is still pending, yes.
So why wouldn't the recommendation to monitor that?
Because it was not, we don't have a conviction, and it doesn't appear that it has anything to do with this person's actions as a real estate agent.
I'm just trying to draw the parallel. We monitored that case. He wasn't convicted of anything that involved his real estate license.
Well, the documentation that we had didn't specify that. It just said in.
Are you talking about the person who was managing property for the pilot?
There's Stevenson's.
Oh, okay.
And it was a criminal felony conviction. That was the main thing there.
But we don't, and maybe that will happen in this case too. If we instead of your recommendation said monitor it.
Well, this isn't a criminal allegation though. This
It's
is a
civil.
civil allegation.
So the basis for the charges against the other licensee, the other case, are they because there was a criminal conviction, or is it because he notarized a document that he didn't witness being signed, and that's a violation of some other?
It's because of the criminal conviction, which is the only reason that that person notified us to begin with. It was because the statute says if you're convicted of a felony that has to do with fraud or embezzlement or any of those enumerated offenses, that you have to report it to the commission within 60 days of the conviction, or otherwise you're automatically revoked. So that's why that person even notified us to begin with. Right. Well, and that one had already concluded in a conviction.
And this no way could become a felony because it's civil.
Well, if it were to, then there would be an obligation on the part of the licensee to notify us of that, and then action would be taken. Is
Right.
that correct?
Yes. If this ended up being a criminal thing, that's correct. If they were convicted, then they would have to report, or if not, they would be automatically revoked.
If we dismiss this complaint, number 17, would this licensee have any basis to raise that as a defense later on in the event of a criminal conviction?
I don't believe so, because that's required by statute. The action that can be taken by the commission because of a criminal conviction is in the statute. So I think that would set that apart from having any bearing on bringing it up again.
Any other discussion or questions? Not, let's vote, which is on the motion to accept council's recommendation to dismiss. All those in favor say aye.
Aye.
All opposed say no. That motion carries 8-0.
2016019881. Respondent was also named as a defendant in the Chancery Court case referenced in complaint number 2016019861 above. Specifically, the complaint alleges that bogus certificates of authenticity were notarized by respondent. Respondent, by and through an attorney, denies any wrongdoing or improper conduct. Respondent states that the claims are unsupported and that the plaintiffs are trying to rid themselves of their perceived competition. Respondent states that law enforcement authorities contacted respondent's principal broker, and both the principal broker and respondent fully cooperated with authorities. Respondent states the authorities have yet to take any action against respondent now almost a year later. From the complaint and answer to the complaint filed in Chancery Court, it appears that respondent is an owner of one of the defendant LLCs and was acting in an owner capacity for the LLC and not in an agent capacity. However, neither of the LLCs listed as defendants in the complaint are licensed as real estate firms or appear to be using real estate firms to conduct their real estate transaction. The recommendation is to dismiss and open a complaint against the defendant LLCs, respondent, and the owner of the other defendant LLC, also a named defendant, for unlicensed activity.
Motion to accept, council.
All right, we have a motion by Commissioner Horn, seconded by Commissioner Hills to accept council's recommendation.
I
Discussion.
thought he said to dismiss.
Are
What
you
was-
okay with, also with the part about opening a complaint about against the LLCs? Yeah. Okay, motion is to accept council's recommendation. Discussion. Let's vote. All those in favor say aye.
Aye.
All opposed say no. That motion carries 8-0. Number 9.
20160200321. Complainant alleges that respondent attempted to promote a listing in which respondent had a personal interest over respondent's client's property. Complainant states that complainant submitted an offer to the listing agent who handed the file to respondent when the listing agent took time off to get married on a property, but when complainant called respondent to check on the status, respondent stated that the seller was thinking about withdrawing the listing and that respondent had a property in which respondent had a personal interest in Alabama that complainant might be interested in. Respondent states that complainant made a low offer on respondent's client's apartments and the seller refused to counter because in her opinion the offer was too low and not worth countering. Respondent states that the seller got another offer which was accepted for one of the complexes. Respondent states that the seller decided not to sell the other complex and, to respondent's knowledge, still owns it. Respondent states complainant asked if respondent had any other listings that might work for respondent, and respondent told complainant about the Alabama listing and several others. Respondent states that respondent has never had a personal interest in the property and does not know where complainant got the idea there was a personal interest. The recommendation is to dismiss.
Move to dismiss.
Second.
Motion by Commissioner Frank, seconded by Commissioner Wood to dismiss. Discussion. Let's vote. All those in favor say aye.
Aye.
All opposed say no. Motion carries 8-0. Number 20.
20160200341.
Move to dismiss.
Second.
Motion by Chairman Grease, seconded by Commissioner Franks to dismiss, accepting council's recommendation. Discussion? Let's vote. All those in favor say aye.
Aye.
All opposed say no. That motion carries 8-0. Number 21.
20160342271.
Move to dismiss.
Second.
Motion by Chairman Grease, seconded by Commissioner Hills to dismiss according to council's recommendation. Discussion? Let's vote. All those in favor say aye.
Aye.
All those opposed say no. Motion carries 8-0. Number
20160282021. Complainant by and through complainant's son-in-law filed a complaint against complainant's son.
So, just based on that one sentence alone, is there anything that we have jurisdiction over in this complaint?
No.
Move to accept council's recommendation and dismiss.
Second.
Motion by Chairman Grease, seconded by Commissioner Franks to accept council's recommendation and to dismiss. Discussion. All those in favor say aye.
Aye.
All opposed say no. Motion carries 8-0. Number 23.
Has to read the number.
20160286061.
Motion by Commissioner Taylor to dismiss. Is there a second?
Second.
Seconded by Commissioner Hills. Any discussion? Let's vote. All those in favor say aye.
Aye.
All those opposed say no. Motion carries 8-0. Number 24.
20160333811. Complainant alleges that complainant had
May I interrupt you? So, as I read this complaint, it has to do with commissions.
yes, and
Do we have
internal actions within the firm.
internal actions, firm policies, but nothing I think this commission has jurisdiction over. Is that your take?
That is my analysis, yes.
That being the case, I'll move to accept council's recommendation and dismiss the complaint.
Motion by Chairman Grease, seconded by Commissioner Hills to accept council's recommendation and to dismiss. Any discussion? Let's vote. All those in favor say aye.
Aye.
All those opposed say no. Motion carries 8-0. Number 25.
20160222821. Complainant states that respondent was complainant's agent for the property they purchased. Complainant states that an inspection and structural engineering report were done and the seller agreed to fix everything on the inspection list. After closing, complainant asked the seller about the location of the septic system and was told that there was not one. Complainant states that the disclosure states there is a septic system. Complainant states that a septic company told them that they have an old rotten tank. Complainant states complainant contacted respondent and asked why this would not have been found during the inspection, and respondent said respondent had no idea. Complainant states respondent never mentioned anything to complainants prior to closing about getting a septic inspection, or complainants would have done so. Complainant states complainant contacted respondent's broker, who stated that neither respondent nor the firm are responsible for the septic tank costs. Complainant states complainant states complainant had to have a porta potty at their home for 2 months until the new septic system was installed, which cost $4,700. $7,400. Complainant states complainant would not have purchased the property if they had known of the issues with the system. Respondent denies that respondent violated any laws or regulations governing real estate licensees. Respondent states that the seller specifically represented in his Tennessee residential property condition disclosure that the property had a septic tank and expressly represented that the septic tank had an adequate capacity and approved design to comply with present state and local requirements. Respondent also states that the seller also represented that he was unaware of any defects or malfunctions with the septic tank. Respondent further states that respondent provided written notice to complainant in the disclaimer that it was complainant's responsibility to address any concerns with the septic tank by requesting information contained in the file for the property maintained by the appropriate governmental permitting authority and have a professional check the system. The disclaimer was signed by complainant on the day it was provided. Respondent states that complainant tendered a written offer using a standard TAR form, which states that it is the responsibility of the buyer to address any concerns regarding the septic by specific contingency in the special stipulations paragraph of the agreement. Complainant did not include any contingencies, nor did complainant ever request a septic system inspection. Respondent states that the disputes between the parties began shortly after closing. Respondent states it is unclear if complainant spoke to seller about the septic before or after closing, but that complainant never contacted respondent about the septic prior to closing. Office of Legal Counsel reviewed the documents submitted by respondent. According to the Tennessee Residential Property Condition Disclosure, the seller represented that the septic tank was in operating condition and the seller was not aware of any defects or malfunctions of the system. The seller also marked yes to whether the septic tank had adequate capacity and approved design to comply with present state and local requirements. Additionally, the MLS listing noted that the property had a septic tank. Respondent also provided copies of the disclaimer notice and purchase and sale agreement, which are both signed by complainant. The recommendation is to dismiss.
Discussion. Discussion.
I don't sell houses that have septic tanks. They're not an issue in Memphis. But isn't there a requirement that you prove that the septic tank will work in the state of Tennessee?
It's called a septic tank letter, and you get it from the health department.
But it does not prove that it works.
Right.
No, but don't you have to provide that?
No, you don't have. I think that's part of your inspection period that you get the inspections on it. On the contracts that we use, it's part of the buyer's inspections.
And there's an environmental form, and you can submit the environmental form to the county, and then the county responds saying they find something or did not find anything, and number of bedrooms.
Call for the question.
There's no additional discussion. Let's vote. All those in favor of the motion vote aye.
Aye.
All those opposed vote no.
Mr. Chairman, can I interrupt for a second? Sure. While we're in the mood to be dismissing things, I suggest we dismiss this gentleman.
Hang on just a second. That motion carries 8-0.
Excuse me. My motion is to dismiss this guy that's sitting out here in this audience, unless he wants to stay.
All right, is there a second?
Second.
It's been moved and seconded to dismiss our final attendee who is here to comply with a consent order that required him to attend a meeting.
Just stand by for this vote.
Okay, we have a motion to allow you to leave if you would like. And this gentleman is here to comply with a consent order that required him to attend a meeting. And he has attended at least through 4:36 this afternoon. So the motion is to allow him to go ahead and leave at this time. Is there any discussion on the motion?
Can I get in on that motion too?
No.
Put my name in, please?
You're riding with him, right?
All right, let's vote. All those in favor say aye.
Aye.
All those opposed say no. That motion carries 8-0, and you are dismissed at this time. Very good.
Thank you.
Thank you, and safe travels. Moving on with the legal report, number 26.
20160193001. Complainant states complainant has been forced to break a lease on a vacation rental after 4 months due to numerous violations. Complainant states a lead paint disclosure was not given, and when complainant informed respondent of complainant's intention to break the lease, respondent attempted to get complainant to sign a disclosure at that point. Complainant states there is not a working smoke detector, and complainant researched that it is what is required for the battery and found the alarm is very outdated and was probably the original detector. Respondent did not disclose where complainant's security deposit was being held and did not reply when asked. Complainant states that the shower stall is made of metal and the floor is rusting out. The doors to the showers do not close properly due to poor structure. Kitchen floor is caving in. There are several tripping hazards due to rotting wood and construction of stairs to the boat dock. Electrical is not grounded and insufficient lighting outside for safety. Complainant states complainant was given a heater that was made in the 1950s with a three-pronged outlet, the blue sparks when plugging into the outlet. Complainant was required to pay a $100 cleaning fee out of the security deposit. Respondent allows washing machine to run off into the lake. Respondent drops by without notice. Complainant was required to pay extra for cable that complainant requested, and when complainant requested to see the bill statement, respondent refused. Complainant was told it was a 6-month lease, but when it was time to sign the lease, respondent said it was month to month. Complainant states complainant had no choice but to sign since complainant turned down the other rentals. Respondent states that according to the EPA, lead complaint disclosure is not required on vacation rental properties. Respondent states complainant leased one of the complainant's cabins for 1 month and another for 2 months. Complainant states that every single surface of said property was painted in May of 2015. Complainant voiced displeasure of possible exposure to lead paint, so respondent gave complainant disclosure, which complainant refused to sign. Respondent states that smoke detector in the property is updated and that respondent put one in when respondent bought the property 3 years prior because there was not one. Respondent states respondent was not notified of non-functioning smoke detector until this complaint was filed. Respondent states respondent gave complainant the name of the bank, name on the account, and the last 4 digits of the account number where complainant's deposit was being held. Respondent states complainant signed the lease, which states upon moving in, resident has examined the unit and accepts it as is. Respondent states the shower is old but is clean and usable. Respondent states that there is rust on the sides of the shower but does not present a safety issue. Respondent states there is a small gap, maybe 1/4 of an inch in the sliding glass door, but poses no safety hazard and does lock. Respondent states that the kitchen floor is not caving in. Respondent states there was rotten wood up in the eave off the deck due to leaves in the gutter which clogged the downspout. Respondent states there was no safety issue and the problem has been resolved. Respondent states there's no evidence of rotten wood on the stairs to the lake. Respondent states that the heater was in good working order when complainant took possession of the property and when respondent was notified of the sparks coming from the plug. Respondent's husband supplied complainant with a brand new heater. Respondent states the outlet was changed and is up to code. Respondent states complainant was never without heat and the old heater was discarded. Respondent states that there's a street light by the front door and 3 outside lights on the back deck. Complainant asked respondent if complainant could place a motion sensor light on the side of the property. Respondent allowed and the complainant did. Complainant wanted additional television channels and respondent agreed to upgrade and passed the increase to complainant. Respondent states respondent was uncomfortable giving complainant access to respondent's account, so respondent gave complainant a copy of the initial bill and the emails documenting the extra charges. Respondent states complainant wanted a 6-month lease, but respondent only does month to month during the off-season, which renews automatically until such time that either party gives notice, which is all written in the lease. Respondent stated to complainant there should be no reason to expect that they could not stay 6 months. Complainant was not forced to sign the lease, and complainant did not communicate that complainant was uncomfortable with it. Respondent states a $100 cleaning fee is charged for all monthly leases and is listed in the lease. Respondent gave complainant the entire $300 damage deposit back, and no cleaning deposit was withheld. Respondent states water does not run into the lake. Respondent states due to the fact that the lake levels rise and fall regularly, constant attention is needed to the floating dock, and mentioned to complainants in the beginning that respondent would be by periodically to make necessary adjustments to the dock. Respondent did not bother complainant and would let complainant know via text message when respondent was coming. According to the information from the property assessor's website, the property is owned in trust by the respondent's spouse. The problem is that the lease is between complainant and an LLC labeled in the lease as management. According to TREC files, the LLC is unlicensed. The recommendation is a consent order for $500 for violation of TCA Section 6213-301 and 6213-309A1A and 4 hours of CE and property management to be completed within 180 days from execution of the consent order above the minimum required for renewal.
Question.
So they didn't sign the lease. They didn't require them to sign the lease. Is that correct?
The complainant did sign the lease.
Oh, okay.
Lead-based paint they didn't sign.
Okay.
So after all the back and forth about what the status of the property is and whether the heater worked and whatnot, that really doesn't matter.
No, because
right.
So the lease agreement is between the complainant and an okay.
Not a property management or real estate firm.
Correct.
So
this
then,
person is
But he does
licensed,
have a license.
but
he didn't want to run it through his
But
broker.
it doesn't
Okay.
look like it doesn't look like this has anything to do with the firm with which their license is placed. It's a totally separate thing.
But Okay, so if it's between an LLC that owns the property, is it
The LLC does not own the property.
doesn't own it? Who owns it?
The respondent's spouse. In a trust, yeah. Well, the spouse is the trustee. Yeah. Mm-hmm.
Property management.
Property management when it doesn't have a license.
And so is this, but this is against the affiliate broker, not the LLC.
Correct.
So do you have a motion, Mr. Chairman?
I don't have a
I mean,
motion.
if you prefer, we can open a complaint. We can dismiss this one and open one against the LLC. We could do it that way as well, instead of against the
I'm
individual.
trying to figure out how you tie the respondent to this. Is he guilty because his wife owns the LLC?
Well, LLC.
I mean, or is that why he's even getting on here, because his wife owns the LLC that was doing the property management?
Well,
respondent
nobody
is licensed.
owns the LLC. The LLC is just something this person created to be their management company.
And it's not even, so it is a real LLC? They did create a LLC?
I mean, that's what they claim, yes. It is a real, I mean, it's named as a party on the lease. No, but I don't know that that really matters. Because it's still a company that's not licensed, it's holding itself out as a property
Right.
management company.
Well, since this has been recommended by legal counsel, and I have no idea.
Motion from
I'll second
Commissioner
it.
Taylor to accept council's recommendation, seconded by Commissioner Franks. Discussion. Hearing none, vote. All those in favor say aye.
Aye.
All those opposed say no. That motion carries 8-7.
201601931. Complainant states that respondent provided the key code to the house before closing, or in the alternative, left the home unsecured. Complainant states approximately 1 to 2 weeks prior to the contracted closing date, scheduled on December 28, 2015 at 12 p.m. for sellers and 2:30 p.m. for buyers, a formal request was submitted by respondent for 2 items. First item was having the carpets of the property being sold, purchased, professionally cleaned prior to the closing date. The second item was for the buyers of the property to begin moving in boxes and other stuff into the garage prior to the closing date. Complainant states the complainant accepted the request to have the carpets professionally cleaned prior to close as long as respondent was present during the cleaning. The second item was rejected for reasons of liability concerns. On December 23, 2015, complainant received a text message from complainant's agent, again with a request from respondent for the buyers to begin moving in, this time into the house, not the garage, prior to closing date and time. Complainant states the complainant denied the request again and until all paperwork had been signed and funds had been received for the transaction. On the day of closing, December 28, 2015, a formal request was sent by the respondent to complainant's agent requesting the complainant to allow move-in prior to close date and time. Respondent informed complainant via phone of the written request. However, complainant denied the request and a formal request was never signed and returned to respondent. Several text messages were exchanged during the day of closing between complainant's agent and respondent, continuing the request to move in prior to close date and time due to time restraints. Complainant's agent continuously responded no to the request while complainant was in lawyer's office signing closing documents. Repeated text messages and calls were exchanged, and the lawyers 100% supported and agreed with the decision not to let the buyers move in prior to closing. On December 28, 2015, at approximately 12:30 p.m., complainant exited the lawyer's office after completing paperwork. Respondent's buyers had not completed their section of paperwork at this time. At approximately 1 p.m., complainant received a phone call from complainant's agent who drove by the property being sold and informed complainant that 2 cars and a big orange moving truck were parked in the driveway. The garage door and back doors were open and unlocked with cleaning crews and moving crews cleaning and moving furniture into the home prior to the fully executed contractual agreement being solidified. This event occurred approximately 1.5 hours before the scheduled closing date for the buyers. Complainant's agent promptly entered the property and requested the keys from the keys from the individual within the property and demanded that everyone leave the property immediately as it is not owned by the buyers. A female occupant in one of the two cars stated that she did not know where the key was located, but when arriving, all the doors were unlocked and the garage door open. Complainant is unsure of how many hours and days the property was unsecure. Respondent states that on December 23, 2015, respondent spoke to complainant's agent about the buyers moving in at 12:30 on the scheduled closing date of December 28. Complainant's listing agent stated that it would not be a problem. At the time of discussing if boxes would be able to move in the garage, the buyers asked respondent if they were going to be able to move in a little earlier, hours but not days. At this point, respondent had already gotten verbal consent from the complainant's agent that it would not be a problem for buyers to enter. Respondent states that complainant's listing agent and respondent wrote an amendment on December 27th holding the seller harmless and allowing the buyer to move in, although the listing agent had already said it was okay. Respondent's buyers wanted the agreement on paper so both parties could sign. Upon verbal agreement from the seller's representative, respondent told the buyers to schedule their movers. Respondent states that the listing agent had given the okay via email and it had been repeated that they could not move unless funds were available. Respondent states it was a cash purchase and the funds were available and with the title company prior to the buyers moving their stuff in. Complainant had signed the deed, at which point the possession per the contract should have been granted. Respondent states respondent forwarded an email from the buyer's attorney stating the funds to complainant's agent to show complainant that the funds were there. Respondent states that the amendment was sent to complainant's agent on December 27th, but complainant's agent did not present this in a timely manner 18 hours after receiving it, which created more confusion. Respondent states that the only reason respondent gave the code to the lockbox on December 27th was because of the amendment that the buyer's agent and respondent had written together and the verbal permission of respondent received from complainant's agent. Respondent states the female occupant complainant referred to was one of the buyer's friends and was not there when the buyer first arrived and opened up the home, therefore not knowing when the house was opened. The closing date possession date amendment was marked with delivery of deed and payment of the purchase price. An email from the title company dated 12/28/15 at 11 a.m. confirms that the funds have been received. The amendment to the PSA allows the buyers to move in at 12:30 on the day of closing, is signed by the seller and sent to the complainant's agent via dot loop at 2:23 p.m. the day before. It appears the complainant's agent did not view the document until 9:55 the next morning and presented it later that morning to complainants at closing. Text messages between respondent and complainant's agent indicate that complainant's agent intended for complainant to sign the amendment, but it was presented to them at closing. When it was presented to them at closing, the attorney encouraged them not to sign it. Because the funds had been received by the title company and the seller had closed, there does not seem to be a possession issue with the buyers beginning to move in. So it seems the only issue was whether it was acceptable for respondent to give the buyers the key code to the house the day before the closing. It is legal counsel's opinion that this is not the best practice, but it did not create any harm in this case, and respondent acknowledged that respondent should get everything in writing and not just trust the word of other agents. This does not seem to rise to the level of violation of the Broker Act. The recommendation is to dismiss.
Move to dismiss.
Motion by Commissioner Frank, seconded by Commissioner Taylor to accept council's recommendation. This discussion.
Is there more than one title company in this closing, or just the one?
I think there were two.
Okay. The difference being, it should be money, just because the money's, I'm going to say at the buyer's title company, does not mean it's available to the seller. It's got to be at the seller's title company. Now, that could take an hour, that could take a day or two, but I don't think it's going to change my vote. But
I'm not 100% sure about that either, whether there was one or two.
That we have that problem. We have an issue where people, when buyers push away from the closing table, they think it's their house, and that's not what the contract says. So, but
give them an inch, they take a mile.
In this particular one, the sellers went first. Yeah.
Additional discussion? Let's vote. All those in favor say aye. Aye. All opposed say no. Motion carries 8-0. Number 28.
2016019341.
Move to dismiss.
Second. Motion by Commissioner Frank, seconded by to accept council's recommendation to dismiss. Discussion. All those in favor say aye.
Aye.
All opposed say no. Motion carries 8-0. Numbers
20160200191, 20160200192. Complainant alleges that respondents were advertising and misleading the public. Complainant alleges respondents were advertising in several media outlets and advertising they are with a specific firm in a particular city. Complainant alleges that this company does not have a firm in that city. Complainant alleges respondents are neglecting to post the firm name as registered with the TREC along with the firm phone number and social media advertising. The telephone number they have is for the firm located in another city and may be more than 50 miles from their residence. Respondent's principal broker responded on behalf of the respondents. Principal broker states there is an office in the advertised city and provided the firm's license number. The firm has been licensed since April 12, 2016. Principal broker stated that the respondents live 45 miles by straight line boundary as the law allows. Principal broker states that there has been no misleading of the public in any shape or form. Office of Legal Counsel researched the website pages referenced in the complaint and is of the opinion that it is the opinion of legal counsel that respondent's firm name is not the most prominent on the Facebook page. Respondent 1 and Respondent 2's names are presented in the top center of the page in the cover photo. The firm name is presented in the profile picture of the Facebook page and also underneath the profile picture and is the same size font as the agent's name in the cover photo. However, the profile picture and the firm name are located on the left side of the page and not top center like respondent's names. Office of Legal Counsel confirmed that the firm's address listed is for the firm for which they are affiliated. The original complaint was filed in February, which is prior to the firm's license date of 4/13/16. However, Legal Counsel is unable to verify or review any advertising from this time period because no screenshots or printouts were included in the complaint. So the recommendation is a consent order for $100 for violation of Rule 1260-02-.123B1. Firm name must be the most prominent name in the advertising.
And why $100?
Because when looking at this advertisement, it was very clear what their firm was. That was not hidden. It wasn't, like, if you looked at this Facebook page, it was obvious. It was written several places on the Facebook page. It just, when you look at the Facebook page, you probably wouldn't say that it was the most prominent because the actual individual names were at the top and in the middle and seemed to, like, be the first thing you see. So I don't think it's harmful. I think that it's obvious what their firm is. But, I mean, it is, since we do have this rule, I think it is a violation of the rule.
Move to accept council's recommendation. Second.
Motion by Commissioner Frank, seconded by Commissioner Taylor to accept council's recommendation for $100 consent order. Discussion.
Just to follow up on one point here, it seems to me that perhaps these agents were advertising before the firm was actually licensed in that city. Is that your conclusion?
It's possible. I just don't have anything to verify that.
Proof.
Well, the fact that the complaint was filed before the office was opened up, does that carry any weight?
I mean, it could, but I have to think of it in terms of if this case was to move to litigation, would our litigator have a case? And because they would have no proof, we wouldn't have a case.
So the complaint didn't offer proof at all?
The complainant only included the link to the website and the Facebook page, and not any screenshots or printouts from that time. So when you go to those links now, it doesn't show me what was there in February, so I can't really verify that.
Is the firm name on the Facebook page twice?
Yeah, I mean, it's on there in the profile picture, and it's on every, so on a Facebook page, it'll have your name, everything you post will have your name at the top. So it has their names, their, like, group or team or whatever it is, and then it says / the firm name on every posting.
But then, so it said, I was reading, it said the Office of Legal Counsel researched the web page. Okay. The respondents' names are presented in the top center of the page in the cover photo. The firm name is presented in the profile picture of the Facebook page, which is like the square to the left, right? And also underneath the profile picture, and is the same size font as the agent's names in the cover photo. Could you say that the firm name is the most prominent because it's on there twice, the same size as the individual's names, and the individual's names are only on there once?
You could say that. You could probably make that argument. I was just going by when I first, and I asked a couple people around to see, without explaining to them what the rule was. Marina and I both looked at it and asked a couple of people, when you look at this page, what's the most prominent name that sticks out? And it was kind of concluded that it was the. Now, again, there was no question of what the firm was. So
What's happening is people are doing their own personal Facebook page, and then they're adding their real estate items to that personal Facebook page. What would accommodate the commission is that they open a company Facebook page. Mine has Franklin Realtors 615-794-1177, and that's what's up there big. And so it's on everything. It's on everything. But they're not seeing the reason to. That's one way to get it on everything. They're trying to just have one Facebook page, probably.
Would you think that the agent's name was bigger than the company name, or is it the same size as the company name on that page? Is it the same size?
I mean, it's hard to say from the profile picture, but the other places where it's listed, I would say it's probably the same size.
Was it an agent's name or a team name?
It's two agents' names.
What's your interpretation then? Does each agent's name have to be the same size as the company, or the combined height of those two?
Well, there's no specific size requirement for the names unless it's on a sign. For the internet one, we're just looking at the prominent thing. It's hard for y'all to make these decisions without seeing the advertising. I realize that, so I'm try to explain, kind of try to describe it the best I can. But
And I think since we don't, that we should take your advice.
Yeah, we trust you.
letter of warning is also an option.
There's a motion on the floor, right?
There is a motion to accept council's recommendation. Any further discussion or other motions? Hearing none, let's vote. All those in favor say aye.
Aye.
All opposed say no.
No.
Motion carries 6-2. Number 31.
2016-04-2981.
Move to dismiss. Timeshare.
Motion by Commissioner Franks to dismiss. Is there a second?
Second.
Seconded by Chairman Grease. Discussion. All those in favor of the motion vote aye.
Aye.
All those opposed vote no. Motion carries 8-0. Number 32, please.
2016-019461. Complainant signed a contract with respondent on February 7th, 2016. Excuse me. On February 8th, complainant let respondent know complainant wanted to cancel the contract. Complainant was not happy with the transaction because the respondent was almost 3 hours late for an appointment, and respondent was only with complainant for 15 minutes before respondent's wife called and wanted to know what was taking so long. Complainant has made several calls to respondent and texts requesting to cancel, and respondent said that respondent had shredded the contract, so no worries. Complainant told respondent complainant needed something in writing to prove that the contract was canceled, and respondent continues to put off complainant. Complainant has emailed and called the broker with no response. Complainant wants to get complainant's house listed but cannot do that without this being resolved. Respondent states respondent discussed this seller with respondent's broker and both mutually agreed to release the listing. After releasing the listing, the complainant filed complaints on Yelp and with TREC. Respondent states respondent's broker has advised respondent to have no contact with the seller. Respondent provided the mutual release agreement, which was signed by the principal broker and complainant on 2/16/16. The complaint was filed on 2/17/16. The recommendation is to dismiss.
Move to dismiss.
Motion by Commissioner Franks, second. All those in favor vote aye.
Aye.
All those opposed vote no. Motion carries 8-0. Number
2016-019481.
Move to dismiss.
motion by Commissioner Franks, seconded by Commissioner Taylor to accept council's recommendation. All those in favor vote aye.
Aye.
All those opposed vote no. Motion carries 8-0.
Question for legal.
Okay.
6213-317. Is something that we need to look at to remove, or am I missing the point of this?
Directory? That's a good question. Yeah, it's a statute. I mean, the commission can't just get rid of it. But as far as what it's for, I'm honestly not sure.
Are we mailing it to the county clerk of each county?
Things, and I thought, what the heck is
B.
that thing? What
You're a
is it
little picky.
for?
I would
So I bet we are.
I would think that possibly our online license verification system might fulfill this requirement.
I request that we do mail it to all the courthouses. I mean, why can't we request that this be killed?
It's statute.
Statute. You
can
contact.
request
We
it.
could ask
Yeah.
that the administration include it in its package to send to the General Assembly, but
Have to be next year.
Especially the other data that the commission may determine to be in the interest of the public.
it's just,
I know,
it's
so-
permissive though. I mean, we don't have to do a
May.
directory, it just says we can if we want to.
Right, that's true.
If we do it, we've got to mail it to the county clerk.
You just leave it, you don't ever ask for it to.
Mum's the word.
I mean, the commission can certainly, next time we do legislative proposals, propose that it be taken out of the statute. But as far as right now, we can't really do anything about that.
Downside to that is once you open the statute up,
Yeah.
anything else.
Pandora's box.
Yeah.
Well, you can narrow the caption.
No, some people are just looking for an opening.
They laid it enough to
Yeah,
see.
if they have a bill to amend 6613,
I don't think so.
then once they go in there, they can do
Looking
anything.
at hour 45.
So just help me out. The minutes of the special meeting, have we approved those yet? Okay.
So the revised minutes were
Good catch.
circulated later in the meeting. Has everybody had a chance to review those? Are y'all ready to vote on those?
Move to approve.
Second. Okay. Motion by Commissioner Frank, seconded by Commissioner Taylor. Discussion. All those in favor vote aye.
Aye.
All opposed vote no. That motion carries 8-0.
Brooks, thanks for doing that. We appreciate it.
Make sure Brooke gets all of these too.
All right. Give the
Your
gavel
son.
back to the chairman.
Thank you, Commissioner McMullen. Good job. So, what do we do with these things? What are these for?
So,
They're
you know
earrings.
those little bars at the parking garage? They will be coming down within the next coming months, and to actually make them open like a normal parking garage, you're going to have to bring them with you every time and scan it, and it will open for you. That is what we have been notified as of today.
So it's not to scan out here.
Not to my knowledge, no.
Open the garage door.
Yes.
Okay, so if we lose this, we can get another one.
You can park downstairs.
That's what I was thinking.
Or you don't lose it.
lose it.
Or you
Oh,
can
good
sell
luck on
it.
that.
Yeah.
Oh, yeah, or we can sell it, especially for ball games.
All right, ladies and gentlemen, we've covered a lot of business today.
You better take back control.
So let's see if any commissioners have closing remarks. Commissioner Horn, you just ready to leave, or do you have anything you'd like to say on the way out?
It was good seeing everybody,
You too, sir.
and I think everybody did well.
And we did a lot. Ms. Taylor,
No, it was a very interesting meeting, and I'm ready to go home.
don't be despondent, okay? Don't be depressed. Don't be despondent. Okay.
Very engaged.
Mr. Bloom,
Angry.
Oh, I'm just ready to go home.
Ms. Hills,
I'll get home.
Mr. Wood.
How long's this stinking term I'm signed up for? Is what I want to know. So
I think you just started.
I'm done. I'm good.
Ms. Franks.
I wanted to ask about the education award for Janet. Did we ever vote on that, or?
It's
I
automatic.
think we had to. Yeah.
Okay, good.
I think it just happened.
Is that-
So what does he need to do?
Vote on it. We did
Just
vote
stand
on
by.
it.
Because that's important to her.
Yeah, we'll get that to her.
But we
Okay.
did-
It's a built-in award, and the commission, a couple of years ago, passed a resolution that said any commissioner gets that as a matter of being a commissioner. You might want to change that at some point, but that's what passed 2-3 years ago. Mr. McMullen,
I'll miss you all next month, but I will think about you while I'm on my Disney cruise.
Pictures with your big ears.
okay, let me just, one quick comment. So Malcolm's been with us 6 months. He sent us a 6-month progress report that I was most impressed with. I didn't realize collectively we're that good, but thank you for putting that together.
Working hard.
From a personal point of view, and I suspect on behalf of this commission, we would like to express our confidence in you and appreciation for what you've done and support for your leadership, which you've shown throughout the staff. So I just want to say that on the record.
You're here.
All right, anything else to talk about? Let's go home. Safe travels.
Bye.